So.
Thank you.
Thank you.
Now in session, presiding the Honorable Seema G. Patel. All persons having business herein draw near, give attention, and they shall be heard. God save these United States, the state of Michigan, and its honorable court. Please be seated.
Good morning, everyone. We are here for calling case number 24-11 Northland Family Planning Center versus AG Nessel et al. We're here for the trial on the merits. Welcome. This is a very full courtroom, and I think most of us are attorneys in here. Before we begin, can I please have the attorneys put their appearances on the record? If you're at council table, you can do so at council table. If you're in the gallery, I would ask that you come up one by one and go to the lectern, please. Oh, and also, good morning. Welcome. Thank you so much for your services today. Go ahead.
Good morning, Your Honor. Molly Twink, plaintiffs from the Center for Reproductive Rights. Good morning, Your Honor. Megan Kelly from Fort Carrington and Sutcliffe. Good morning, Hillary Schneller from the Center for Reproductive Rights.
Please come up to the lectern. Thanks.
Good morning, Julie Hurwitz from the firm of Goodman, Hurwitz and James as local counsel for the plaintiffs, and also here on behalf of the National Lawyers Guild.
Allison Epperson from Fort Carrington Sutcliffe on behalf of the plaintiffs.
Alexandra Willingham from the Center for Reproductive Rights on behalf of the plaintiffs.
Rachel Miller from Fort Carrington and Sutcliffe on behalf of the plaintiffs.
Deja Tillman from Goodman, Hurwitz and James on behalf of the plaintiffs serving as local counsel.
Good morning, Your Honor. Kendall Asbenson, Assistant Attorney General on behalf of the people of the state of Michigan.
Good morning, Your Honor. John L.A. Tuttle, Assistant Attorney General, hearing on behalf of the intervening defendants.
Good morning, Your Honor. James P. Kennedy, Assistant Attorney General, hearing on behalf of the intervening.
Morning, Your Honor. Daniel Pang, appearing on behalf of Defendant Director Hertel.
Good morning, Your Honor. Assistant Attorney General Christopher Braverman, appearing on behalf of Marlon Brown, Director of the Department of Licensing and Regulatory Affairs.
Good morning, Your Honor. Assistant Attorney General Rebecca Abuna appearing on behalf of the defendant, Attorney General Dana Nessel.
Morning, Your Honor. Neil Giovanatti, also as Assistant Attorney General on behalf of AG Nessel.
Good morning, Your Honor. Brianna Listerman, also an Assistant Attorney General here on behalf of Dana Nessel.
All right. Welcome, everyone. We are here on the trial on the merits on plaintiff's claim. We have conferred with counsel, and counsel has agreed to forego opening statements. And so I think at this point, is there anything preliminary before we start the testimony? Yes, please.
Your Honor, as we discussed off the record yesterday, the parties have conferred on a number of evidentiary issues and have agreed to stipulate to the admission of a number of exhibits, which I would now like to put on the record.
Please.
The parties have agreed that Plaintiff's Exhibit 4, the MDHHS Informed Consent for Abortion in English, will be, and they both agreed to admit that into evidence. Do you want me to pause after each one, Your Honor, to confirm that the intervening defendants agree, or do you want me to go through the list first?
You can just go through the list. I'll object if there's any misstatement, but I don't anticipate it.
Thank you, Your Honor. Exhibit 5, the Michigan Coercion Notice. Exhibit 6, the Michigan Coercive Pre-Screening Summary for Patients. Exhibit 7, the Michigan Coercion Screening Tools for Abortion Providers. Exhibit 10, Northland Family Planning's Screening for Domestic Violence, Intimate Partner Violence, and Coercive Abortion Policy. Exhibit 11, Northland Family Planning Center Standard for Abortion Services. Exhibit 12, Northland Family Planning's Checklist for Coercion and Domestic Violence. Exhibit 13, Northland Family Planning's Medical History Form Electronic. Exhibit 14, Northland Family Planning's Medical History Form Continued. Exhibit 15, Northland Family Planning's Intake Training. Exhibit 16, Northland Family Planning's Abortion Intake Training Procedures. Exhibit 17, Northland Family Planning's Emotional Assessment, Abortion and Decision Consulting. Exhibit 18, Northland Family Planning's Helpful Language for Coercion Screening. Exhibit 21, the CV of Dr. Sharice Loer. Exhibit 23, the CV of Dr. Amy Levi. Exhibit 25, the CV of Dr. Antonia Biggs. Exhibit 27, the CV of Professor Kate Spector Baghdadi. Exhibit 29, the CV of Natasha Bagdasarian. Exhibit 31, the CV of Dr. Monique Wubenhorst. Exhibit 33, the CV of Dr. Farr Curlin. Exhibit 36, the Defendant Attorney General's response to plaintiff's first set of requests for admission and interrogatories dated November 6th, 2024. Exhibit 37, intervening defendants' responses to plaintiff's first set of requests for admission dated November 6th, 2024. Exhibit 38, intervening defendants' answers to plaintiff's first set of interrogatories dated November 6th, 2024. Exhibit 39, Director Marlon I. Brown's response to plaintiff's first set of requests for admission and interrogatories dated November 13th, 2024. Exhibit 40, Director Elizabeth Hurdle's response to plaintiff's first set of requests for admission and interrogatories dated November 13th, 2024. Exhibit 41, Director Marlon I. Brown's response to intervening defendants' first set of interrogatories dated November 19th, 2024. Exhibit 43, gestational age verification. Exhibit 44, MDHHS's informed consent confirmation form. Exhibit 45, MDHHS's online informed consent confirmation form. Exhibit D, safe abortion procedures in Michigan from Northland Family Planning's website. Exhibit E, emotional health after an abortion from Northland Family Planning's website. Exhibit F, adoptions in Michigan from Northland Family Planning's website. Exhibit G, pregnancy testing and ultrasound services in Michigan from Northland Family Planning's website. Exhibit I, pre-abortion instructions. Exhibit J1, medication abortion information. Exhibit J2, mifepristone information. Exhibit J4, Northland second trimester abortion 2 or 3 day procedure. Exhibit J5, Northland's Guide to Contraception. Exhibit J8, helpful language to use with the patient. Exhibit J9, Northland Statement on State Mandated Information. Exhibit K1, Northland Medication Abortion Consent Form. Exhibit K3, Danko Patient Agreement Form. Exhibit K4, Danko Amendment to Patient Agreement. Exhibit K5, Telehealth Services Informed Consent. Exhibit K6, Ectopic Pregnancy. Exhibit K7, Northland Consent for Abortion Procedure, Medical Procedures, and Anesthetic Services. Exhibit K9, Additional Consent for Multiple Day D&E Procedures. Exhibit K10, Northland Declaration of Age. Exhibit K11, Michigan Laws Reabortion Services. And Exhibit L, DHHS Opioid Start Talking Consent Form. At this time, Your Honor, the plaintiffs would move all of those exhibits into evidence.
Okay,
No objection, Your Honor.
okay, so moved, and those will be entered into evidence as exhibits.
And as we discussed, Your Honor, what we will do is file those on the docket, each of those exhibits in the format that we discussed off the record this evening following the court day, as well as any other exhibits that may be moved in and that Your Honor chooses to admit during the course of the trial, if that's acceptable with Your Honor.
That is acceptable. Thank you very much.
Thank you. There's also some additional outstanding evidentiary issues, Your Honor. Plaintiffs filed last Friday on the 7th a request for judicial notice for several of our exhibits, specifically plaintiffs exhibit 1, 2, 253, 260, 261, 262, 263, and 264, all of which are either statutes or regulations in the state of Michigan. Intervening defendants filed a response in opposition. We would request at this time that Your Honor admit those. We believe you are required to admit them under Michigan Rule of Evidence 202 subsection B. While the intervening defendants have stated that they agree that Your Honor has to take judicial notice of it, they do not believe they're evidence. We disagree. Specifically, the section of the Michigan rules that address judicial notice happen to fall within the rules of evidence. The intervening defendants cite no authority that statutes and regulations cannot be evidence. They are regularly accepted in other cases. For example, if Your Honor thinks about a negligence case or a case where exemplary damages are being sought, where issues of reasonableness are relevant to the proceeding, whether or not a defendant complied with applicable statutes, administrative codes, and regulations is some evidence of their reasonableness. In those cases, the only way a finder of fact, typically a jury, in this case, Your Honor, can determine whether or not the defendant complied with those is to actually examine statutes, codes, and regulations. They are substantive evidence. They are regularly admitted as substantive evidence. And we think all of the regulations I just read into the record, of which we believe the court is required to take judicial notice, are evidence in this case. These are the regulations that plaintiffs, including Northland Family Planning, has to follow as an abortion care provider. And so at this time, Your Honor, we would seek to admit Plaintiffs Exhibit 1, 2, 253, 260, 261, 262, 263, and 264.
Mr. Absenson, did you have some argument on the other side?
Your Honor, my position is that all of Michigan's laws and regulations and constitution are all before you. You don't need an exhibit to examine them. The code books are all before you. I have no problem with the plaintiffs using demonstrative exhibits if they want to, or using them for convenience. I just don't think that they need to be in evidence, because every single Michigan law, regulation, and constitution is already before you, and you can consider it in making your decision.
I agree with you, but I also don't see any harm in having them admitted as exhibits. So I'm going to grant plaintiff's motion
Very
to
good.
allow them to be admitted as
Thank you, Your Honor.
exhibits. Thank you.
Thank you, Your Honor.
Anything else preliminarily before we begin examination in this case?
Not for plaintiffs, Your Honor.
Okay, defendant, any of the defendants or intervening defendant? Okay, well, thank you very much. I think then we are ready to proceed. Please, plaintiff, call your first witness.
Thank you, Your Honor. Molly Duane, again, from the Center for Reproductive Rights. For the plaintiffs, and we would like to call Renee Chillian to the stand as our first witness. Good morning. Ms. Chillian, can you please state your name for the record and spell your first and last name?
Chelian.
Ms. Chillian, what's your current job title?
Executive Director, Northland Family.
I'm going to stop you for one moment. Is that sufficient for you to be able to hear? Yeah, and maybe move the microphone a bit closer.
Is that better?
Okay, wonderful. Thank you.
All right. So you just said your testimony was that you're the Executive Director of Northland Family Planning. Yes. All right. What is Northland Family Planning?
It is 3 clinics that provide abortion, miscarriage management, ultrasounds to determine gestational age, pregnancy testing, telehealth abortion services, and unbiased decision-making counseling.
When was Northland founded?
1976.
And over the last 50 years, has Northland provided other services other than the ones you just mentioned?
Yes, we had a very busy GYN clinic for a long period of time.
But you no longer do?
No,
Okay. How long have you personally worked in abortion care?
since before Roe.
So more than 50 years?
Yes,
Okay. And how long have you lived in Michigan?
my whole life.
You mentioned that Northland has 3 clinics in Michigan, right?
Yes,
Where are they?
Sterling Heights, Westland, and Southfield.
Okay, so all in the Detroit area.
Yes,
Ms. Chillian, there are 3 entities that are plaintiffs in this case. Can you describe what those 3 entities are?
Northland Family Planning Clinic, Inc., Northland Family Planning Clinic, Inc. West, and Northland Family Planning Clinic, Inc. East.
And what do those legal entities do?
They're management companies.
So one management company per clinic, is that right?
Yes,
Okay. Who is employed by those management companies?
everyone who works at the clinics except the physicians.
So who employs the physicians?
They work for Northland Family Planning PC as independent contractors.
And why are the physicians employed by a different legal entity
Physicians must work for a PC
under Michigan law?
under Michigan law.
Okay.
Yes.
I'm going to refer to all the different legal entities collectively as Northland, if that's all right with you.
Yes,
So you mentioned that Northland provides abortion services up to what gestational age?
up to 24 weeks.
And is that dated by last menstrual period?
Yes.
You said 24 weeks?
Well, 23.6 weeks.
Right, okay. Has that always been the limit?
Yes.
Do you provide medication abortion?
Yes.
Up to what gestation?
12 weeks.
And just briefly, what is a medication abortion?
It's a series of pills that bring on a spontaneous miscarriage.
Do you also provide procedural abortion, which is sometimes referred to as surgical abortion?
Yes.
And just briefly, what is a procedural abortion?
You use instruments to remove pregnancy.
All right, and so that's through the whole gestational ages that you provide services?
Yes.
Does a procedural abortion in the first trimester of pregnancy differ from one in the second trimester?
Yes.
Just briefly, how so?
Well, the risks increase with each age, with each gestational age. The fee increases, and the procedures are different. They can be 1 day or 2 day.
Are similar instruments used in both?
Yes.
Approximately how many abortions does Northland provide each year?
Between 7,000 and 8,000.
And roughly what percentage of those abortions are in the first trimester?
Do you mind if I look at the vast majority?
The vast majority. Okay, that's fine. We don't need a
Okay.
more exact number. Thank you. And just roughly, what percent of abortions, I guess in the first trimester, would be medication abortions?
Roughly 45%.
Does Northland also provide training for medical students, medical residents, and fellows?
Yes.
What does that training entail?
Shadowing the doc, it depends on who we're training, but most of our training right now is focused on fellows. So it is to advance their skills in second trimester abortions, and for family medicine physicians, advance their skills in abortion and early second trimester abortion.
Is this training they wouldn't otherwise receive in their medical education?
Yes.
Do medical providers looking for abortion training have lots of options on where they can receive that training?
No,
So why does Northland provide that training?
because we feel it's extremely important to train the next generation of abortion providers.
Ms. Chillian, let's talk about your personal job responsibilities. What do you do just generally as the executive director?
I oversee every area of the clinics that affects patient care and that affects any policies and procedures that we have.
How often do you speak with your chief operations officer?
Daily.
Over the last 50 years, have you performed other jobs at the clinic?
Yes,
Which ones?
I have worked washing instruments, doing pathology. I have held patients' hands and assisted the doctor during an abortion procedure. I have worked recovery. I have answered the phones, and I have been a patient advocate doing informed consent
Ms. Chillian, do you have medical training?
on the job.
Did you go to nursing school?
I did.
And did you finish nursing school?
No.
Why not?
I started working in Buffalo, New York. The physician that I worked for at the time got a license to practice medicine in New York, and he asked me if I would fly to Buffalo with him on weekends. So I worked Monday through Thursday, 4 10-hour days in his office here in Detroit. And then I flew at 4 or 4:30 in the morning on Friday morning to Buffalo and flew home on Sunday night. So I worked 7 days a week, and there wasn't time to go to school. And when Roe was passed, I found my calling and stayed in abortion care.
All right, so I just want to break that down a little bit. So you were traveling to and from Buffalo. That must have been before Roe?
Yes,
I see. And then you stopped doing that when?
when Roe was passed.
And that's approximately when Northland was founded?
No, I worked for several years at his clinic and another one
In Michigan.
in Michigan.
All right. Now, when was the last time you personally worked directly with patients in your clinics at Northland?
Well, I still go into the clinic and have the opportunity to touch base with patients and talk to them. You know, that's the reason I do this work. But I haven't worked regularly with patients since COVID.
2020.
Yes,
In your current role, are you involved in developing Northland's clinical policies and procedures?
yes,
Does that include developing training materials for staff?
yes.
Does Northland look to any authoritative sources in developing their clinical policies and training materials?
We follow evidence-based medicine that produced the standards of care by, and that are then written by the National Abortion Federation, ACOG, the World Health Organization, and the Society of Family Planning.
So you mentioned the National Abortion Federation. Is it okay if I call that NAF?
Yes.
Yeah. What is NAF?
NAF is an organization, a member organization of clinics, of researchers, attorneys, nurses, anyone involved in abortion care that would like to learn, would like to stay on top of the latest standards of care. And they also have clinical policy guidelines that as members, we have to follow, and we're inspected by them to maintain that membership.
Were you involved in the founding of NAF?
Yes,
Is it fair to call you a founding member of NAF?
yes,
Okay. Do you periodically update Northland's clinical policies and procedures?
yes.
What's the goal of that?
To stay on top of the best evidence-based medicine, however often that changes.
Do you do anything else to stay up to date with evidence-based medicine other than, consulting with NAF?
Our physicians have regular staff meetings with myself, with the COO. They do research, and we talk frequently about making sure that what needs to be changed to stay on, to provide the best evidence-based medicine.
Do you attend conferences as well?
Yes. The doctors attend them, and as well as myself and the COO.
I'd like to ask you some questions generally about the patient population that Northland serves. What is the racial and ethnic breakdown of your patient population?
Do you mind if I look at my declaration?
Okay, so did you prepare a declaration in support of the preliminary injunction motion
Yes.
in this case?
I want to make sure I have the numbers correct.
Okay, so you cited the statistics in that declaration. Would it refresh your recollection to review that declaration now?
It would, thank you.
All right, so please turn to, in the book in front of you, Plaintiff's Exhibit 8. All right, can you look at the last page of this document? So this is actually an affidavit. It's signed under oath.
Yes.
All right. I would direct you to paragraphs 13 through 15.
Do you want me to read you what it says?
No, just read to yourself. All right. Does that refresh your recollection?
Yes.
All right. So I'm going to ask the question again. What is the racial and ethnic breakdown of your patient population?
Approximately 65 to 70% of our patients are non-white, made up of Black, Latino, Asian, other nationalities.
What proportion of your patients receive financial assistance?
Approximately 60% of our patients have received some sort of financial assistance. And in 2022 and in 2023, 3/4 of our patients receive financial assistance.
So is it fair to say that most of your patients are low income?
Yes.
Ms. Chillian, in this lawsuit, the state asked for a corporate representative who could speak on behalf of Northland. Who is that representative for this case?
I am.
And in addition to your usual oversight of the clinics, what else did you do to educate yourself as the corporate representative for Northland?
I interviewed multiple staff people.
So let's talk about the laws in Michigan that apply to abortion. You can set that aside for now. When the Northland clinics first opened in the 1970s, were they regulated like any other medical clinic in the state?
Yes.
Were there any laws at that time that applied only to abortion clinics?
No.
Over time, were laws passed in Michigan that did apply only to abortion clinics?
Yes.
All right, can you turn to Plaintiff's Exhibit 1? Are you familiar with this document?
Yes.
All right, and can you turn to Plaintiff's Exhibit 2? Are you familiar with this document?
Yes.
So these are two of the laws that apply only to abortion clinics.
Yes.
Yeah. Have these specific laws changed over time? Looking back to Exhibit 1, actually.
Yes.
All right, so in 1999, I believe, the first version of that statute went into effect. So broadly, what did that law require?
It required that women had to wait 24 hours, 24 hours before obtaining an abortion after receiving state mandated materials, either having them faxed, picking them up at the clinic, or getting them from the internet. But if they got them from the internet, they had to print out a confirmation form that had a date and time stamp. That was not on the necessary if they picked them up. It also required us to give verbal information to patients 24 hours in advance of their appointment.
Okay. So we'll get into the details of the laws in a minute, but do you have an understanding of what the original purpose of that law was?
Make it more.
Objection Foundation.
Your Honor, she was there when the laws were passed. The intervening defendants have made the intent behind these statutes an issue in this case. And so I'm just going to be asking her a few questions about her observations of the laws at the time that they were passed and what her understanding was as to their purpose.
Keep it limited to her understanding.
Yes, Your Honor.
Please.
Because I worked lobbying legislators in Lansing, my understanding was this was to make it more difficult for women to get abortions, to delay their abortion. And more importantly, the anti-abortion legislators that I spoke with told us that women would change their
Objection,
mind.
hearsay.
Ms. Chillian, just keep it to
Assisting.
your observations.
Okay, my observation was it would deter women that when they read the materials, they would change their mind.
Were you physically present when the legislative debate was happening about this law?
Yes, multiple times.
All right. At that time, did Northland seek to challenge any of these statutes in court?
Yes.
And what was the result of that litigation?
We reached settlement agreements in court that made the law easier to live with.
Can you give an example of what that settlement included?
Well, for example, in the definitions, some of them were, for example, one was the definition of menstruation, and it was the sorrowful weeping of a disappointed uterus. And the court took that out. That we also, the court agreed that, or the settlement agreement allowed the physician to designate a staff person to give the 24-hour information and the verbal information instead of the patient having to speak to the physician.
So which staff members at the clinic provide the majority of pre-abortion counseling in general?
Any patient advocate working at the clinic.
All right, and which patient advocates, at the time that the laws were in effect, they're enjoined now, we'll get into this, but which patient advocates were responsible for informing patients about this state law and its requirements?
The main staff people would be anyone answering the phones. They would, yes, the main people would be anyone answering phones.
So is that the staff that make appointments?
Yes.
Okay. Can you turn to Plaintiff's Exhibit 4, which has been pre-admitted? What is this document?
This is the website, what's on the state's website currently.
So this is the state mandated information that was required by that law, but this is the current version?
Yes.
All right. What's included in these materials generally?
There is information on every abortion procedure. There is information on fetal development, parenting, and prenatal care.
So absent the law that we're challenging in this case, would Northland provide parenting and adoption information to every patient that comes in the door?
Only if a patient requested that information.
So apologies, I'm going sort of back and forth in time here, but before this law went into effect in 1999, did Northland have policies and procedures in place to ensure that patients provided proper informed consent before abortion?
Yes.
All right, can you turn to what's been pre-admitted as Plaintiff's Exhibit 11? All right, you testified earlier about Northland having various policies and procedures. Is this one of those policies?
Yes.
All right, so let's look at it together. On the first page under 2, which is eligibility for abortion, I'm going to read items A and B. A is confirmation and documentation of pregnancy. B is confirmation of gestational age by exam and or ultrasound and or LMP. So does this mean that these things are always confirmed before an abortion?
Yes.
Now, looking at item C, is that the requirement for the state mandated information?
Yes, prior to the injunction.
Yeah. So then looking at items D and E, can you describe what these are?
Well, the patient must be choosing an abortion of her own free will. And E is explaining what should be included as a standard of care in an informed consent.
So do those requirements exist independent of the law?
Yes.
And that's always been true?
Always.
So independent of the laws we're challenging in this case, do patients review written information about the specific abortion procedure that they will receive that Northland has created?
Yes.
Do patients receive information about the abortion procedures they will not receive?
No.
Is that relevant to them?
No.
All right, I'm going to show you what's been pre-admitted as Defendant's Exhibit J1. So if you can flip to J1. Okay, what is this document?
It's information about medication abortion.
So is this the educational material that a patient would receive if they're getting a medication abortion?
Yes.
That Northland created?
Yes.
All right, can you look at J3, which has also been pre-admitted? What is this document?
This is explaining information for the patient about a 1-day second trimester abortion procedure.
And then J4, can you look at that document as well? It's also been pre-admitted.
It's information about a multiple day second trimester abortion.
Are these the current versions of those documents?
Yes, they are.
So a patient getting a second trimester abortion that's 1 day, which form do they get? Or which informational packet do they get?
They would get the 1 day information.
Does Northland also utilize informed consent forms
Yes,
for
we do.
patients to sign? All right, can you turn to intervening defendants exhibit K1? Well, what's this form?
It's a medication abortion consent form.
So this is the informed consent form for medication abortion?
Yes.
Okay, we'll try to run through these quickly. K5, what is K5?
Telehealth services, informed consent.
Okay, K7.
Every patient signs, who's having a procedure abortion, signs this consent form, no matter their gestational age.
All right, K8.
This is an additional consent for a 1 day D&E procedure.
Okay, so a patient who gets a 1 day D&E procedure is going to sign the K7 consent form as well as the K8 form?
Yes.
All right, and K9.
In addition to the standard consent form, patients who are having a D&E that's multiple days would sign this consent form.
And are these the current versions of the consent forms to your knowledge?
Yes, they are.
All right, so we've looked at a bunch of different forms, all of the J forms and the K forms. Are all of these forms developed, created, and used by Northland?
Yes, they're written by using evidence-based medicine and the standard of care.
So when evidence-based medicine suggests a change in practice, do you update the forms accordingly?
Yes.
All right, and this is something you do independent of the law?
Yes.
All right. So when in the course of their counseling at the clinic, do patients review and sign the consent forms?
In the intake or counseling, they get the consent forms. The patient advocate goes through them with the patient. The patient initials each section that she's read it and understood it. If there's a section that she doesn't understand, it gets left blank, or we try to answer her questions before she ever goes back to see the physician.
All right, so maybe let me back up for a minute. When a patient comes in for their appointment, all of this review that you just described, does that happen in person?
Yes.
All right, so this is on the day of their abortion.
This is all on the day of the abortion.
And what's the purpose of the consent forms at the point at which they're signing them?
Well, medical ethics. I'm sorry, would you repeat that?
Sure. I think I asked that in a confusing way. So what is the purpose of the consent forms? Why do patients have to sign them?
Medical ethics require that we give patients all of their options, that we explain the procedure, that they know the possible risks and complications and benefits of the medical procedure that they're having and alternatives.
Now, do physicians review the consent forms with the patient?
Yes.
Before their abortion?
Yes.
And does the physician also talk to the patient at that time?
Yes.
So is that sort of the final check before the procedure or the medication abortion?
Yes.
All right. Does Northland also have a website?
Yes.
What kind of information is on Northland's website?
Everything that I thought someone who was searching for information about an unintended pregnancy may want to seek out. I wanted people to find factful, truthful information, and I would like them to find our website as opposed to an anti-abortion site that is full of lies and misinformation about abortion.
So if patients in Michigan are looking, or actually anywhere, are looking for correct information about abortion, they can find it on your website?
We have patients who look at it from all over the world.
Do you also have information about adoption and parenting on the website?
Yes.
Okay. Is the information on Northland's website a part of the informed consent process?
No.
All right, so going back to the history of abortion law in Michigan, another law went into effect in 2013 requiring clinics to screen patients for reproductive coercion, right?
Yes,
Is that, well, go back to Exhibit 2. Is this the law that we're talking
Yes.
about? Okay, or most of it anyway, yeah. Before this law was passed, did Northland already screen patients for reproductive coercion?
yes,
All right, recently in 2023, a large piece of legislation repealed many of the abortion restrictions in Michigan. Are you aware of that legislation?
yes,
Okay, and perhaps this is obvious, but the laws we're challenging here were not part of that repeal.
right.
Okay, so what was your reaction to learning that these laws would remain on the books?
I was disappointed, angry, and sad because the part of the law, this part that we're challenging, affects our patients the most.
All right, so let's address each of the laws that we're challenging in this case in turn. And I'm going to start with the one that we haven't talked about yet, which is the law requiring that abortion providers be physicians. So to your knowledge, under that law, can advanced practice clinicians provide abortions?
No,
Can I use the acronym APCs?
yes,
All right, this is APCs from now on, everyone. All right. When I say APCs, though, what do I mean? Who's an APC?
a physician assistant, a nurse practitioner, or a nurse midwife.
Okay. To your knowledge, in the states where it's allowed legally, do APCs provide abortion just as safely as physicians?
Yes,
To your knowledge, is allowing APCs to provide abortion consistent with NAF guidelines?
yes,
And when the injunction entered 7 months ago in this case went into effect, blocking that law, at that time, did you consider hiring APCs?
yes,
Did you end up hiring any?
no.
Why not?
Well, the law is not in effect yet. And right now we have coverage. We don't need a new practitioner.
Okay, so when you say the law is still on the books at this point, that's why we're here today. Yeah, okay. If circumstances, well, I'm sorry. You said that you don't have any openings right now, is that right?
That's correct.
Okay, so if circumstances changed in the future and you did need to hire a new abortion provider, would you be interested in hiring an APC?
Yes,
Would you have any concerns at all about hiring an APC to perform abortion?
no,
All right, let's move on to the next law. And I want to go back to the 24-hour mandatory state information law we were discussing earlier. So you testified that patients must review the state materials before their abortion, and that was the materials in Plaintiff's Exhibit 4. Has the content of that state material changed over time?
yes.
Have there always been inaccuracies in those materials?
From the time that it was written until recently, there was a great deal of inaccuracies.
In 1999, when the law first took effect, you were working in the clinic at that time?
Yes,
And I think you said this earlier, but you have served as a patient advocate
yes,
and you've answered the phones.
yes,
And you testified that as CEO, you're involved in developing clinic policies and training materials. Yes? All right. Does that include training materials for patient advocates to comply with the law?
yes,
All right. So before the preliminary injunction entered in this case went into effect last year, I want to ask you some questions about what the impact of the law was from those 24 odd years. Okay. So can you please turn to Plaintiff's Exhibit 45, which has been pre-admitted? You testified earlier that when plaintiffs receive the state mandated information over the internet, they need to sign a form of some kind.
yes,
Is this the form?
yes,
Now, looking at the form, there's a couple headers here, and then I'm just going to read this. In order to comply with Public Act 345 of 2000, PA 345, you must bring this page and present it. You must print this page and present it to the physician or other qualified person assisting the physician. So is your understanding that patients have to physically print that form?
absolutely.
What is your understanding of how the 24-hour mandatory state information law impacted Northland staff?
Well, patients were confused, first of all, finding the website and then navigating it. there's there was a timed or delayed response, and patients didn't have long enough sometimes to stay on the website for the whole time. So they would have to get off and start over again. Then they would call back again to figure out how to get back on the website.
Can I stop you there for a moment? I just want to make sure I understand what you said. So are you saying that for a period of time, patients had to stay on the website for a specific amount of time?
Each page was timed. You couldn't click from page to page.
All right. So apologies, continue.
Patients, if they were, well, first of all, many of them didn't have printers, and they told us that. You know, we told them where they might be able to go to get a printer, or to use a printer. But
Where would you tell them to go to find a printer?
a library, see if they had a friend who had a printer, a FedEx office, which in Detroit there are very few. But most of our patients don't even have computers. Their phones are their computer, and many of them don't have access to the internet. So they would have to go somewhere else, a public setting where there was public Wi-Fi.
Did you and your staff have any concerns about patients going to public locations to review this information?
The patients had concerns. They were afraid when they called back and they started asking questions that their confidentiality was being violated because people around them could hear them. They were whispering questions. Sometimes we could hear them, sometimes we couldn't hear them. They would get frustrated because they couldn't get what they needed. And more importantly, they were just frustrated because they had to do this.
All right, so that was sort of a summary of the impact on patients. Can you talk a little bit about the impact on you as a clinic employee as well as your staff?
Well, our staff spent a lot of extra time helping patients navigate the state website that they could have spent helping patients with real questions, real problems, real issues, or helping another patient who was sitting on hold while we were trying to help somebody navigate the state website.
All right, so you mentioned patients being on hold. Am I understanding you that patients would be having these conversations with staff members over the phone when they were trying to schedule their appointments, I guess?
Yes.
All right, and did patients ever call back with subsequent questions?
They'd call back with, I'm now in a place where there's internet and I'm starting all over again.
Okay. Did the clinic ever print the forms for patients?
No,
Why not?
because this page says the patient must print the form, and that's my understanding of the law.
Is your understanding that patients were not allowed to print it on the day of their abortion?
No, because the date and time stamp on the bottom, when you print this form, it has the exact date and time that you printed it. It tells you you cannot get an abortion before 24 hours later.
I see. So that's how you prove that 24 hours have passed.
Right. So they couldn't print it on the day of their abortion.
And does that form have an expiration date?
It expires in 2 weeks.
So if a patient completed this requirement but couldn't schedule their appointment within that 2-week window, what would happen?
They had to start all over again.
Did patients ever have to reschedule because they had problems with the printing requirement and the 24-hour requirement?
Often.
In your experience as a clinic employee interfacing with patients, did you observe patients' reactions to the law?
Yes.
Can you describe what you personally observed?
I observed people being frustrated, angry, upset that they had gotten a babysitter or a ride or taken a day off school or work only to be turned away. Or they'd call in the morning and say, I was finally able to get a ride today, but they hadn't printed out their form because they didn't have a way to, and they didn't have a way to get to the clinic to pick up the paperwork. So they were, and they didn't understand why
they had to do this?
Why they had to do this.
Did you personally ever have to turn patients away because they hadn't met the requirements?
Yes.
Can you describe your experience of having to turn patients away?
Really sad. They had gone through a great deal to just raise the money to get there. And then they sometimes they weren't sure when they could come back, pushing them into another gestational limit, or meaning they couldn't get a medication abortion any longer. Just angry that they had wasted their time, but they thought it was us, and they took out their anger on us, and explaining to them that this was a state law. Just, they couldn't understand why the state had anything to do with this.
So you've described what it was like for you to deal with patients that hadn't complied properly with the requirements.
Yes.
For patients that did receive the information 24 hours in advance and did print the form, did you observe their reactions as well?
They also didn't understand why they had to do this, why they had to wait, why they couldn't make an appointment when they wanted, and what business was it of the state, what they were doing.
And so even for those patients, were they sometimes delayed more than 24 hours?
Well, we didn't track it, but I don't know what they had to go through to get a ride, or again, take a day off from school, day off from work, arrange childcare.
Okay, but to clarify, were patients ever delayed more than 24 hours?
Yes.
All right. Can you give an example of a patient to your knowledge that was significantly delayed by the 24-hour?
When I was interviewing the staff, I interviewed our phone staff currently, and one of the staff members confided in me that she was a patient at the clinic prior to working at the clinic.
Hearsay.
Your Honor, this is information that she gained as the corporate representative for the Northland clinics. She was specifically asked by we were specifically asked by intervening defendants to designate a corporate representative who would have knowledge of how long patients were delayed in between their first call to the clinic and their ability to obtain their abortion. And so I'm only asking for Ms. Chillian's personal observations as the corporate representative in gaining that information.
I just respond that that is hearsay when she's testifying about what's else.
Not as the corporate representative, Your Honor.
What is your response to the fact that she's testifying as a corporate representative in her interview of the employees under her care?
I think she can testify about what her knowledge is, but I don't think she can testify the knowledge that she gained through the interview process. But I don't think she can testify directly as someone said.
I'm having a hard time drawing a distinction, especially because she's talking about somebody who is a direct employee of hers. Can you expound on that further, or is that the drawing distinction?
Your Honor, I think that as testifying as on behalf of a corporate representative, that position, she can't do that. This is trial here today. I'm asking that witness who made the statement that that would be more definitely. I have no problem with this witness testifying about what her knowledge is, that knowledge that she gained based on potentially hearsay information. But it has to be like her knowledge is. She can't testify about what those conversations were. She can testify about the knowledge that she has gained through those conversations.
Ms. Green, I think that's a reasonable limitation. I think that Ms. Chillian can testify as to what she learned, but not presented as a testimonial from that employee.
Okay. So Ms. Chillian, apologies, this is the legal, okay. So without testifying to what your staff member told you directly, can you please testify to your personal knowledge of the patient's circumstances that led to a patient being delayed more than 24 hours?
This patient had a condition called hyperemesis gravidarium. She vomited all day and all night, every day. She was extremely sick in bed. No one would drive her because she was throwing up and she couldn't drive herself. So she also didn't have a computer, or a printer. So she needed to get a ride to the clinic to pick up the 24-hour information. It took her multiple days to be able to get to the clinic because she was so ill. And then when she got the 24-hour information, she still couldn't come back in 24 hours because she was so sick. She had to wait until she could get someone to drive her and get back to the clinic to have her abortion procedure. So it was a lengthy time.
Ms. Chillian, in discovery, the state asked for an estimate of the number of patients who were turned away from their appointments because they had not properly complied with the 24-hour state mandated information law. And they wanted that broken down by month. Do you remember providing that information to the state?
Yes,
And sitting here today, do you remember the exact numbers you provided to the state?
I said approximately 10.
But do you remember the exact number for each month that you provided?
No,
Is there a document that would refresh your recollection as to what information you provided to the state?
yes.
Can you turn to what's been marked as Plaintiff's Exhibit 42? Is this the data you compiled for the state?
Yes,
And is that your signature under oath at the end of the document?
yes.
So look at page 6 for me. What data is shown here?
I looked at charts where we had seen patients, brought them into the clinic, started an intake process, and then discovered they didn't have their 24-hour information. And then it was documented on the chart.
Do you document every patient who's turned away?
No, our process is supposed to be that we're checking patients at the window to make sure that they have their 24-hour information. So we often find people who do not have it before we ever give them a chart and fill it out, but we don't track that.
So looking at those numbers, for some months you have 0, some 5, some 10. I think I'm understanding your testimony to be that doesn't capture every patient who is turned away.
No, it's a very small percentage.
Okay, so this is an underestimate.
Yes,
And in the complaint in this case, you alleged that approximately 10 patients per month were turned away, and that's the same estimate you gave today.
yes.
So we've just described why this is an average, right? All right. So still talking about the time before the injunction, when patients came in for their abortion appointment, did they need to fill out any additional state mandated forms on the day of their abortion?
I believe you mean the acknowledgement and consent form?
I do.
Okay.
All right, let's turn to Plaintiff's Exhibit 44, which has been pre-admitted.
I'm sorry, can you repeat the question?
Oh, I'm sorry. Exhibit 44, is this the form that patients had to sign on the day of their abortion before the law was enjoined?
Yes,
And in your personal observations as a clinic employee, did you observe patients' reactions to having to review this form?
well, they'd already gotten the state mandated information. They had already met with a patient advocate and gone over a consent form, had counseling and discussed their options and alternatives, and that they were freely making this decision with a staff member. The doctor has gone over the consent form, had the patient sign it in the room, and asked if she had any questions. And then the physician or practitioner must then start all over again with essentially the same questions, which take 5 to 7 minutes to read this and go through it, because the patient doesn't understand why we're doing this again. She very often they're angry and upset, like, can you just finally do my abortion? But it also sets up a distrust. Suddenly the patients are like, why is the state making you do this? Have you done something wrong that they don't trust you? It sets up a patient practitioner relationship of distrust, or it can.
So taking a step back, to your knowledge, is forcing patients to review all this state mandated information, fill out all these forms, and comply with all of these requirements consistent with NAF guidelines?
Yes.
It is
No,
consistent?
this is not consistent.
Okay.
What we're doing is consistent with NAF guidelines. This is just another form with the same information.
Right. So just to clarify, all of the things we've talked through, reviewing Exhibit 4, filling out these forms, printing the confirmation, are all of those requirements consistent with NAF's guidelines for clinical care?
This is not consistent.
Okay. So I want to turn now to the period of time after the injunction went into place in this case. How has removing the 24-hour mandatory state information requirement impacted your staff at the clinic?
Well, they spend less time on the phone talking about the state website and are able to spend more time with each patient who needs it.
Are you able to see more patients?
We are. And there, which means we've reduced the waiting time for someone who wants to come in.
All right, so how has removing these requirements impacted patients in your observation?
If they get a babysitter today, they can come in. If there's a snow day and they were planning on coming in or they hadn't made an appointment, they can call and they can get an appointment. Or they can call at 3 o'clock the day before when arrangements have been made, their personal arrangements, and come in tomorrow. It makes it much easier for them to get an appointment that they want and have already made up their mind about.
Can you give any examples of patients who you could not have treated before the injunction went into effect that you were able to treat during these last 7 months?
When I was doing my
Foundation.
Your Honor, she's the corporate representative for Northland. She speaks to her staff every single day. I'm asking for her personal knowledge of if there were any patients over the last 7 months that the clinic was able to treat that they would not have been able to treat under this legal regime.
I'm just asking for a foundation to be laid for this testimony. That's it. If the foundation's laid,
Maybe follow up with the questions that you just laid out for me.
Okay. Ms. Chillian, are you the corporate representative for Northland?
yes,
And how often do you speak to your chief operations officer? I believe you testified to this earlier.
daily.
All right. And in those conversations that you did to prepare as a corporate representative and in the conversations that you have daily, do you learn about what happened at each of the 3 clinics on a daily basis?
Yes,
All right. So if a patient was turned away, is that something that you would know? Meaning if a patient was turned away because they were beyond the gestational limit, is that something you would know on a daily basis?
yes,
And if a patient was able to be seen who was very close to the limit, is that something you would know on a daily basis?
yes.
All right, so I'm going to ask the question again. Can you give an example of any patients who you were able to see at the clinic who you would not have been able to see had the injunction not been in place in this case?
Yes, we had a patient with a severe fetal anomaly recently who was 23.6 weeks. The hospital who referred her to us had already faxed over all of her medical records. They knew it was the last day that we could see her. It was the day that we were doing second trimester abortions, and the patient was able to come right from the hospital to the clinic and start her abortion procedure.
And this is a patient that the hospital referred to you?
Yes, directly.
All right. Have you also treated patients, well, has Northland treated patients with severe fetal conditions since the injunction went into place in this case?
Yes,
Have you observed how those patients have been impacted by the injunction being in place?
I have. I spoke with a patient who
Well, without telling me what the patient
Okay.
told you, yeah.
patients with severe fetal anomalies or an anomaly of any kind have a very wanted pregnancy, and to force them to look at fetal development pictures, to force them to read parenting information when they desperately wanted to be a parent, and to read prenatal information is cruel.
And so now those patients are not required to review those materials.
That's correct.
Are you able to see those patients more quickly now?
Yes,
How does Northland typically receive those patients? Are they referred to you by anyone?
they're almost always referred by a maternal fetal medicine physician or a genetic counselor.
All right. Now, Ms. Chillian, the state maintains that the 24-hour state mandated information law requires patients to review information we've looked at all of that, that is essentially the same as the information that Northland has developed and provides to patients. Do you agree with that?
No,
The state also maintains that the 24-hour mandatory delay benefits patients by giving them time and space to make their decision. Do you agree with that?
no,
Have you or your staff ever observed a patient who has benefited from these laws?
no,
To your knowledge, is the current informed consent process that you have now without the laws consistent with NAF's guidelines?
Objection leading.
I'm just trying to lay a foundation for her.
I'm going to allow it.
To your knowledge, is the current informed consent process that you have now consistent with NAF's guidelines?
yes,
Do you believe the patient experience has improved?
yes,
I want to turn now to the provision of the law that was not blocked last year. So this is the state mandated coercion, disclosure, and screening for coercion to have an abortion. You don't have to look any documents yet, although we are
okay.
going to look at a bunch of them, so get ready. All right. You testified earlier that before this law went into effect in 2013, Northland already screened for reproductive coercion.
yes.
In your experience, is reproductive coercion common?
It's rare.
Now, the law requires you to screen for coercion to have an abortion. Are patients ever coerced into remaining pregnant in your experience?
Yes,
And are those two things both part of reproductive coercion?
yes.
In your experience, which is more common?
Forcing a woman into a pregnancy and continuing the pregnancy.
Much more common or less? I don't, give
More
me a
common.
qualifier.
More often.
Okay. In your and Northland's experience, among the minority of patients experiencing I'm sorry. Apologies. Okay. I already asked that. Been up here a while. Okay. Ms. Chillian, the law also requires you to report domestic violence. Is that consistent with your understanding of the law?
Yes,
Have you always reported child abuse and domestic violence at Northland?
Objection, Your Honor. This is a whole line of leading questions. I'd like to.
Okay.
A response to that?
Well, I'm just, so I can have her look at the law, but I just wanted to get her reaction to whether or not she has a policy for domestic violence and reproductive coercion. So I'm just trying to lay a foundation that she does in fact have those policies.
Okay, I'll let you ask about the policies and then get into.
Okay, I'll
The
try
meeting.
and scale it back,
Okay.
Your Honor. Thank you. Does Northland have a policy for reporting child abuse and domestic violence?
yes,
Does that policy exist independent of the law?
yes,
To your knowledge, has Northland ever provided an abortion to someone who is not acting of their own free will?
no,
And I think you testified to this earlier, but have you personally counseled patients about coercion?
yes,
Let's turn to Plaintiff's Exhibit 5, which has been pre-admitted. So I want to talk about the legal requirements of the coercion law. Ms. Chillian, what's this document?
this is a large poster that was mailed to us to hang in the waiting room. There are also smaller ones that were mailed to us to post throughout the clinic.
So the size of the document, this is an 8.5 by 11 piece of paper. Is that the size of the poster?
No, the poster is a poster size. It's big,
And where is the poster?
hanging in the waiting room.
All right, anywhere else?
Oh, the smaller ones are hanging in bathrooms and
All right.
things like that.
Can you turn to Plaintiff's Exhibit 6, which has been pre-admitted? What is this document?
This was part of the packet of information that patients received with the 24-hour information on the website or in the packets we receive from the state.
All right, so the poster that we just looked at, is that currently up in the clinic?
Yes,
But this document, are you currently giving this to patients?
no,
Is that because it was part of the injunction, I guess?
it's not part of the, yes,
Yeah,
that's,
okay. So I want to ask you about the language that's used in both the poster and this document, which seems sort of similar to me. Does the document mention coercion to remain pregnant?
No,
Do you have any concerns about that omission?
yes, it's not fair.
What do you mean by not fair?
Well, it's not accurate. It's patients, it only addresses part of it, part of the pregnancy coercion problem.
Now, the materials also talk about the fact that coercion to have an abortion is a crime in Michigan. Do you have any concerns about that language?
Well, first it says it's illegal. And against the law. When patients see this, very often they are afraid of the police. And the first thing that happens is, I can't talk to anybody. They're going to put my loved one in jail, and they shut down.
Now, other than this poster in the waiting room, is there anything else that the clinics are currently required to do under the part of the law that isn't enjoined?
A screening for each individual patient.
All right, can you turn to Plaintiff's Exhibit 7, which has been pre-admitted? What is this document?
This was the produced, I don't know who produced it, the health department, and mailed to us to use as a tool for screening patients for intimate partner violence and coercion.
Is that screening, does that have to be oral?
Yes.
So I want to look at this document with you. I'm going to read some of it and then ask you some questions. So on the first page, it says screening questions should be direct. Explain that the state law requires you to ask every patient seeking abortion if she is being coerced to have an abortion. And then if you look at the second page, it looks like there's some additional suggested screening questions here. So I want to read a couple. Number 5 is, and this is a question you're suggested to ask of patients. Has anyone threatened to hurt you or made you feel unsafe if you don't have an abortion? And then number 6, the suggested question. Has anyone threatened to harm you legally or financially if you don't have an abortion, like threatening to have you arrested, deported, or destroy your legal documents, or threatening to get you fired, kicked out of your home, or taking away your financial support? So my question is, when you are a patient advocate, would you ask patients direct questions like this?
No.
Why not?
Well, first of all, we haven't set a rapport with them. There's other things that we do to build a rapport, but if we ask these questions directly right off the bat, they're not going to tell us because they're afraid of what's going to happen to the people they love.
So if you ask a direct question like this, do you get an honest answer in your experience?
No.
In your experience, are patients ever reluctant to share information about domestic violence or coercion?
Can you ask me that again?
Sure. In your experience, are patients ever reluctant to share information about domestic violence or coercion?
Not using the counseling that we do, they talk to us pretty freely.
But in general, is that something that is hard for patients?
It's they're ashamed, they're embarrassed, and they're afraid. So it's a difficult topic to broach.
Why are they afraid?
But they're afraid of their abuser. They're afraid that their abuser may go to jail. They are often financially dependent on them. They're afraid if it's reported that the abuse will be worse later. They're afraid of a number of things.
Do you personally find this document useful?
No.
To your knowledge, does anyone at Northland find it useful?
No.
To your knowledge, are the requirements that we've just run through, the poster and the oral screening with these tools, is that consistent with NAF guidelines?
No.
I'd like to turn now to Northland's procedures and patient resources for coercion screening. So putting the law aside for now. Generally speaking, how does Northland go about detecting potential signs of reproductive coercion?
In multiple ways. We ask patients a series of questions in different ways on two different sets of forms mixed in with her medical history, looking to get an answer that will help us figure out where she's at, how she's feeling. We definitely try to read body language, pay attention to the person who's with her, how they're interacting and their behavior. Whether the patient whether she's talking to us, whether she's not getting up out of her chair. I mean, all of her behavior.
Okay, you just mentioned two forms, so let's look at those forms together. Can you turn to Plaintiff's Exhibit 13 that's been pre-admitted? What is this form?
We've recently started using electronic medical records, but we have a half electronic record and a half paper chart. This is sent to every single patient to fill out electronically before she comes in and before she fills out her paper chart.
So this is a form every patient has to fill out?
Every single patient.
This is a medical history, is that what you said, a medical history form?
Well,
Or what kind of form is it?
It's called a medical history
Okay.
form.
All right, so on the second page, there are several questions that a patient can answer yes or no to. I'm just going to read them. It's very small, so I'm probably going to read all of it into the record. Yes or no, I am confident in my decision to have an abortion and do not need to discuss it further. Yes or no, I would like to talk more about my decision. Yes or no. All right, then you can check off as a patient any one of the following list of things. I am scared and or nervous, but sure of my decision to have an abortion. I previously thought abortion was wrong, but I feel it is my best choice. I am not sure about my decision to have an abortion. I am feeling pressured into having an abortion. I am worried that if I have an abortion now, I won't be able to have children in the future. I am concerned about pain during the abortion. I am concerned about the decision to have an abortion and my religious or spiritual beliefs. I do not have the support of my partners, friends, or family. I am concerned about how the abortion will affect my relationship with my partner, friends, or family. I have not discussed my decision with anyone. I would like to have more information to make the best choice. Ms. Chillian, why do you ask these questions? Why do you phrase them this way?
To try and determine how the patient is feeling emotionally and to try and figure out if this is something that she's doing of her own free will and if she's sure about her decision.
Why do you weave these questions into the medical history form as opposed to having a dedicated coercion to abortion form or something like that?
It's less threatening. It just feels more natural that, oh, I'm answering these questions. Here's some more. But it's not separated out.
In your experience, do you get honest answers to these questions to the extent you're able to observe that?
Yes.
All right, can you turn to Plaintiff's Exhibit 14? Is this the second form you mentioned?
Yes.
And do all patients have to fill this out?
Yes, this is part of their paper chart.
All right, so it's another medical history form that's part of their patient chart. All right, so like the prior form, there's some fill in the blank yes, no questions. So I want to read some of those. So there's a box there that says you will be talking with a staff member about the abortion procedure. And then there's some more text. Let us know how you're feeling today. Then it says primary reason for choosing an abortion, fill in the blank. What matters most to you today? Fill in the blank. Is there anything you're worried or scared about? Fill in the blank. Have you talked to a therapist or patient advocate about this decision before today? Yes, no. And then another series of yes, no questions. Are you being coerced or forced to have an abortion? Are you the dominant decision maker regarding your abortion today? Would you benefit from a referral for counseling or other help for any form of sexual or physical violence or verbal emotional abuse? And was your pregnancy the result of forced intercourse? So similarly, Ms. Chillian, what is the purpose of these questions?
To get to the same information, to make sure that they have an opportunity to answer different kinds of questions that get us to the same place. Is she sure of her decision? Is this decision hers, or is she being coerced by someone? And is she really ready to have an abortion today? That's the primary reason.
So you just said you ask similar questions in different ways. Why do you do that?
Because if you ask them in different ways, if somebody didn't answer the first one because she didn't understand it or felt like, I'm not sure that applies to me, there's another question that may apply to her that she feels more comfortable with. But ultimately, patients fill this out and they're pretty honest.
So in your experience, are these questions effective at detecting potential indicators of reproductive coercion?
Yes.
And in your experience, which is more effective, direct questions or more oblique ones?
These more oblique ones.
All right, can you turn to what's been pre-admitted as Plaintiff's Exhibit 17? You testified earlier that Northland maintains various policies and procedures. Is this one of the, well, and training materials? Is this one of those? Well, I guess, what is this?
It's a training material.
Okay, all right. So looking at this document, it starts with the header emotional assessment. Can you describe what is meant by emotional assessment?
Once again, to see if the patient is sure about her decision today. And does she need more time to think about her abortion because she's not sure? Irregardless of the 24-hour information, patients have come in and been unsure. And to screen for to screen for coercion.
Is part of that screening oral between the patient and the patient advocate?
Yes, all of this is oral.
At the bottom of this page, there's a header that says a patient should be referred for head and heart's options if they appear highly conflicted or uncertain of their decision. What is head and heart's options?
It's what we've named our counseling technique. A patient may be very sure in her head that she wants an abortion. This is the best choice for me. I don't have any money, for example. But her heart is breaking. And based on the questions and the body language, we're able to say to her, unless you connect your head and your heart, you won't heal emotionally after an abortion the way we hope that you would. So we want you to take more time in making your decision. And it would be just as irresponsible for us to do your abortion today as if you had a fever, and we wouldn't proceed with it then. And patients get it because sometimes they just need help in figuring out what to do.
How does a clinic staffer know if a patient appears highly conflicted, as this document indicates?
Well, going back through all of the things that I mentioned, how they've answered the questions, leads to conversations. What we're hoping for with those questions is to be able to say, you checked this off. What do you think? What are you feeling about that? What does that mean to you? And having a conversation while observing, is she really talking? Is she not communicating with us at all? Is there a partner hovering at the window, or she's looking to see if someone is watching her? It gives us a chance to look at the patient as a whole person, not one little part.
In your experience, is head and heart counseling effective at screening for coercion?
Yes.
All right, can you turn to what's been pre-admitted as Plaintiff's Exhibit 18? Is this another one of your training documents?
Yes.
All right, so on the first page under number 2, the document gives more explanation for how Northland identifies coercion. So I'm going to read. Another helpful way to determine what the patient is saying is to describe to the patient the difference between pressure versus coercion. Pressure can be experienced by someone trying to convince her into agreement with their point of view. Pressure is an attempt to influence or change a person's behavior or intentions. It is different from coercion, which is using force or threats to get someone to do something. So in your and Northland's experience, how does this distinction aid your staff? I guess aid you in teaching your staff how to identify coercion.
So we felt like we always knew how to do that, but when the law was passed, there was a great fear among our staff that we might be doing something wrong and that we might be violating the law. And so we started talking about definitions to help them. So initially it was to help the staff understand. And then we found that this language resonated with patients sometimes when you give examples.
So if you or your staff determine that a patient is being pressured to have an abortion, how do you decide if she can proceed with an abortion that day?
We don't do abortions on anyone being pressured into an abortion.
Okay. Can you say the last
Repeat
answer?
your last answer. You've sort of drifted from the microphone.
Oh, I'm
No,
sorry.
that's okay.
Could you hear the last?
The last answer, if
That
you can repeat
last
it.
part of your answer.
Can you ask the question again?
Yeah. If you determine that a patient is being pressured to have an abortion, how do you decide if a patient can proceed with an abortion that day?
We don't do abortions on anyone who's conflicted about their abortion on that day.
All right, one more document. Can you turn to what's been pre-admitted as Plaintiff's Exhibit 12? All right, so what is this document?
It is another training tool, part of our training.
Yeah. So it says coercion law at the top and then domestic violence, followed by, it looks like a list of questions to ask the patient. Do you integrate the law into at this point, I guess, do you integrate the law into your policies for handling suspected domestic violence?
Yes.
Would you have these policies no matter what,
Yes.
even if the law were enjoined?
Yes.
All right. Returning to the state's requirements for just a minute. In your experience, do the state's materials aid Northland in identifying domestic violence?
No.
All right, I lied. Go back to Plaintiff's Exhibit 7 for a minute. This is the state's materials. Okay, on the second page here, these are the suggested questions. So I want to read number 9. Have you been, oh, I'm sorry. I'm sorry.
All right, thank you.
Okay, I want to read number 9. Have you been hit, slapped, kicked, or otherwise physically hurt by someone in the past year or since you have been pregnant? Ms. Chillian, would you suggest asking a question like that to a patient?
No.
In your experience, how do the state materials for coercion and domestic violence impact your staff when you're training them to identify these things?
We explain to them that it's the law and that we have to follow the law, but we still use our own counseling questions and all of the things they've been trained on. They need to be aware of the law so that we're not, I mean, I don't know how we would violate it in any way, but they don't really aid them at all. We use our own policies.
So based on your 50 years of experience running Northland, if the remaining provisions of the law challenged in this case were permanently enjoined, would that improve patient care?
Yes.
Why?
Because these shut patients down. The way that we have been doing this for a long time, we know encourages honest dialogue with patients. They feel safe to talk to us, as opposed to a question like, have you ever been punched or slapped? That doesn't open up a conversation.
I'll pass the witness.
Okay, thank you very much. Mr. Asmussen, should we take a short break before?
Thank you.
Okay, you're welcome. Let's take a 10-minute recess and then we'll be back. Thank you.
I'll be recess. Michigan Court of Claims now, so.
Welcome back. Sorry, did I catch you mid-bite? Take a moment, please finish chewing. Do not, don't rush yourself. We've got a minute. Didn't time that perfectly, didn't I?
Thank you, Your Honor.
Please proceed. Welcome back. Ms. Chillian, you are still under oath. So I'll just
Yes,
give that
thank you.
admonition.
Good morning, Ms. Chillian. How are you this
Morning.
morning?
I'm good, thank you. How about you?
I'm well.
Actually, before you get started, can I ask you to pull the microphone maybe closer to you and maybe
Yep.
just underneath your, that way you're not reaching up to,
May I approach the witness briefly to help with the microphone?
sure.
Thank you. Okay,
Okay,
thanks.
thank you.
That better?
I think so.
Very good.
Okay, great.
Can
thank
you hear me better?
Good morning again, I guess. My name is Kendall Benson. And we met a few months ago at your deposition. You remember that?
Yes.
Very good. I've been on Northland's website and I've read your story there and I've listened to you give your story on NPR before. I know you've heard this from me before, but I want to reiterate it to you again here in open court that I'm sorry for what you went through with your own experiences in the 1960s before Roe versus Wade.
Thank you.
And I'm also sorry that you have experienced over the years threats of violence. That's unacceptable in any context. And I want to say that.
Thank you very much.
And I want to personally acknowledge today the bravery that it takes to sit in that seat right now as a
Objection,
witness.
Your Honor, I don't know what cross-examination.
This is just my introduction, Your Honor.
I think I'll allow it.
Thank you. And as you know, I don't work for an advocacy organization. I work for the Michigan Department of the Attorney General. I'm a career civil servant. I'm not a political appointee. I'm in this case representing the people of the state of Michigan, and I'm simply here to defend the challenged laws. And it's my job to question you and perhaps from time to time
Objection,
be
Your Honor.
skeptical
The-
of what
the
you say.
attorney is testifying.
I think he's providing a little background about what his role is before he starts questioning. Ms. Chillian, I'll allow it.
So again, I'm simply here to defend the challenged laws. It's my job to question you and perhaps from time to time be skeptical of what you say. But with that, I want you to know that I'm going to treat you with dignity and respect through this entire cross-examination.
I appreciate that.
I'd like to start with just, I know a little bit about you, and I just have some basic questions. Is it important to you that Northland provide medically accurate information to its patients?
Yes.
Is it also important to you that Northland follow best practices?
Yes.
You believe coercion for abortion is wrong, don't you?
Yes.
And it should be illegal to coerce someone to have an abortion, shouldn't it?
I'm not a lawyer. We don't do patients who are coerced, so I can't address a legal issue.
You know Michigan's constitutional right to reproductive freedom, though, correct?
Yes.
And that's a right to make and effectuate decisions related to pregnancy, is it not?
Again, I'm not a lawyer, so I know how they affect me. I know what it does for women, but I'm not sure I can answer your question or that I really thoroughly understand it.
In your opinion, should coercion for an abortion be illegal?
Objection, Your Honor. She's a fact witness, not an expert.
I'm not asking for an expert opinion. I'm asking for a
Just
personal
ask
opinion.
her.
You asked whether she thinks that you thought that something should be illegal.
Whether or not she personally believes that coercion should be illegal.
It also calls for.
I think it does call for a legal conclusion.
All right, so
And
okay. You testified about the coercion screening that Northland does. Do you recall that?
Yes,
And has Northland conducted any specific studies into what the best practices are for coercion? Like, have you done that personally?
only our experience.
Um, and I guess just to be clear, you believe that coercion is wrong in the abortion context. Is that correct?
I don't believe that anyone should be coerced into anything against their will.
All right. Does the process that Northland employs currently for coercion screening, does it violate the laws?
I don't believe so.
And this is the kind of screening that Northland would do regardless of these laws. Is that correct?
Yes,
You control 3 clinics, is that correct?
yes.
But you cannot testify here about what any other clinic could do, can you?
A plaintiff for Northland Family Planning.
So you can't testify about what some other clinic can do, is that correct?
I suppose so.
Okay. Now, we talked about, or you talked about some signage.
I'm sorry, about what?
Signage
Okay.
regarding coercion. You recall that?
Yes,
You talked about some bigger signs and some smaller signs. Does the law require you to provide those larger signs?
the state sent us that large sign
Okay.
and said, hang it in a visible place. I believe the suggestion was the waiting room right after the law came out.
Does the law require that?
I
To your
believe
knowledge?
so.
Okay. Now, you're the director of several businesses, is that correct?
I'm the the executive director of Northland Family Planning Clinics. Yes,
And there's 3 different businesses there.
yes,
You also post signs telling your employees that it's illegal to discriminate. You understand those laws, that you have to post those kinds of signs as well, correct?
I post all of the posters that ADP sends us that have to do with laws regarding employees. Yes,
And those posters, do they have things to do with employee rights?
yes.
And it's not a burden on those employee rights to post those signs that you're sent by ADP.
Our staff isn't afraid of us breaking the law by posting those posters. They know that we're meeting those laws and those requirements, so there's no element of fear or threat.
Very good, but it's not a burden on those rights to be free from discrimination in employment or to have those other employee rights. It's not a burden to post those in your offices, is it?
I've never asked this, you've asked me before to get certain information, but I've certainly never quizzed my employees about how they feel about the workplace posters.
And you don't have a problem posting those signs about discrimination and so forth, do you?
No. They are posted in the staff kitchen.
Regarding signs, do you have any problem providing patients with hotlines for domestic violence or abuse?
No, they're on our website. We have a handout to give to patients should they need those referrals.
And the laws that we're talking about, the coercion screening laws, they allow you to do screening in a way that you believe and feel is appropriate, don't they?
Yes,
And you believe that every single abortion clinic should do coercion screening, don't you?
I believe that following a standard of care is screening for coercion. And I believe that my colleagues are following ethical standards in screening for coercion and intimate partner violence. Um, it's a part of standard medical practice.
And that's something that every clinic providing abortion should do.
Yes.
Now,
And every doctor's office who sees pregnant women,
and every hospital that,
and every hospital and many other places.
and do you have any problem with posting signs with hotlines to call for women, say in bathrooms or in other locations?
We have hotline cards sitting out and people can pick them up if they want.
Okay. All right, let's talk briefly about, you indicated that you get a lot of your standards from the National Abortion Federation. Is that correct?
Yes.
Or NAF? And I'm going to pass the witness the binder. May I approach, Your Honor, the witness? Are exhibits.
So I don't need this book anymore? Or just put it aside?
Already provided. We are going to look at Exhibit A.
Brought me a dictionary here. Oops.
Turn to the tab labeled A, please.
A?
Yes,
Was this previously admitted as an exhibit?
it was not.
Okay.
Have you seen this document before?
Yes.
What is this document?
It's the National Abortion Federation Clinical Policy Guidelines for 2024.
Very good. And have you used this document?
It is part of our standards and guidelines.
And so this is a document that you use at Northland?
Yes.
Is it a document that you have used in developing your guidelines?
Yes. It
And-
changes every year
Mhm.
and we make the appropriate changes and do the appropriate training if that's necessary.
Very good. And if you notice in the bottom corner, there's some numbers down there. Do you know what those numbers are? The Bates stamp?
Actually, no.
Okay. Those are just numbers that attorneys put on the documents when they produce them, and these were produced by your attorneys in discovery.
Okay.
Your Honor, I would like to move for the admission of Exhibit A at this time.
Plaintiffs object. This is a learned treatise. The fact that we produced it in discovery doesn't mean it's admissible as evidence. Ms. Chillian is familiar with NAF, but she certainly did not write this document. She can't authenticate it. And moreover, it's not admissible because it's a learned treatise. It's also hearsay.
I'm not admitting it for the truth of the matter asserted. I'm admitting it or asking to admit it because Ms. Chillian relied on this document and she provided it to me. I'm asking that it be admitted as the document that Northland relies on, not necessarily that it's authentic from NAF, but that it's the document that Ms. Chillian relied on and that her attorneys provided me in discovery.
And Ms., go ahead.
Apologies, Your Honor. She's not an expert, so the fact that she relied on documents relevant, she's a fact expert. And it's not evidence that she relied on informing any opinions because she's not an expert. And so the fact remains that it's a learned treatise that's not admissible.
I understand it's a learned treatise, but Ms. Chillian did just testify that she is familiar with the document and that as it forms the basis of a lot of the policies in Northland. So I'm going to allow the document to be admitted to form the basis of Ms. Chillian's testimony.
Thank you, Your Honor.
Your Honor, may I ask that it's admitted not for the truth of the matter asserted, but just for her lines?
Yes.
1 moment, let me get the same document in front of me. Can you turn to the page numbered 4?
Page number 4 is blank.
There should be page numbers in the center of the page. Keep going. It's about page 6. It's
Oh, mine
physically
do
about
not
page
have-
16.
Have a number on the bottom of this. It's not base stamped.
May I approach?
Yes. This is the document that I have in this binder.
All right. So there's a
I
bunch
still
of,
have
there's,
blank pages.
very good. I apologize. There's a bunch of page numbers because this document has been through a couple of things. Do you see down at the bottom Exhibit A?
Yes,
Can you please go to page 16? Do you see the page numbers after that Exhibit A?
yes.
And it should be.
I
All
have
right.
it.
Very good. Give me 1 moment. All right. So there's a number of different standards. Do you see the standard 2.2 there?
Yes,
And standard 2.1 says that the practitioner must ensure that accurate information is provided about the abortion process and its alternatives and potential risks and benefits. Do you see that?
yes,
Do you agree with that statement?
yes,
The alternatives to having an abortion would be having a baby. Is that correct? Or
there's one alternative,
what are some others?
putting a baby up for adoption.
Very good. If we go on, it states here that a person must give voluntary informed consent prior to an abortion and express understanding. Do you see that?
No, where are you at?
Well, let's start with
Is it under standard 2?
under standard 2.1, we've already looked at under the policy statement up above. Do you see that statement?
Oh, the policy statement.
Yep.
Okay,
A person must give voluntary informed consent prior to an abortion and express understanding. Do you see that?
yes,
You agree with that statement, correct?
yes,
And every patient should be provided with the risks that are associated with a procedure or medication abortion that they're undergoing. Is that correct?
I don't think that's what it says in there.
Well, do
It
you,
says they need the abortion education to give people the knowledge they need to make an informed decision about whether to have an abortion. It doesn't mention risks.
okay. Do you believe that patient education is important?
Absolutely.
If we go down to standard 2.2 now, it states documentation must show that the patient affirms their decision to have an abortion. Do you agree with that statement?
Yes,
That their decision is voluntary and that they are aware of the potential risks and benefits of the abortion procedure. Is that correct?
yes,
And do you believe that statement?
yes,
Although other risks may be addressed, at a minimum, the following risks must be included. Do you see that?
Yes.
And what are those risks?
Hemorrhage, infection, continuing the pregnancy, and death.
And do you believe that every patient should have that information?
It is in our consent form, along with other things, so I guess I would say yes.
And that information is also in the DHHS materials, is that correct?
Yes.
Now, there's a recommendation 2.2.1. Do you see that?
Yes.
And it states for abortion procedures, uterine aspiration or dilation and evacuation, the additional risks must be included. And what are those risks?
Perforation, damage to organs, including hysterectomy.
And those are all things that you disclose to the patients. Is that correct?
Yes.
Those are also things that are listed in the DHHS materials. Is that correct?
They're duplicated, yes.
So I'd like you to set that binder aside, and if you would go back and take the other binder that you have there. And go to Exhibit K1, if you would. Let me know when you're there.
I'm working on it. Okay.
All right. And this is the current medication abortion consent form. It's already been admitted into evidence. Is that correct?
Yes.
I'd like you to go ahead and read. Do you see the portion that's in bold there? How well does medication abortion work?
Yes.
What does that say? Can you read that?
Medication abortion works over 95% of the time. Medication abortion is more effective after 9 weeks when 2 doses of misoprostol are used. 5% of people who use medication abortion will need further treatment to end the pregnancy or manage complications or side effects.
And what could that further treatment be?
It could mean another dose of the medication abortion. It could mean another dose, Mifeprex. It could mean another dose of misoprostol. It could mean a suction procedure.
So it could mean that the patient might need another abortion procedure, a surgical procedure. Is that correct?
If that's what she opted for, when given those 3 alternatives, if those 3 alternatives were available to her, but.
And so in 5% of the people who take the medication, who have a medication abortion, according to your forms, 5% may need further intervention.
Yes.
What are some of the other risks that you provide to patients or that you tell patients on this form?
We have listed continuing the pregnancy, incomplete abortion, hemorrhage, infection, allergic reaction, and death.
Okay. Now, before the abortion, the medication abortion is performed, you don't know which 5% of patients may need further intervention, do you?
No, and in our own statistics, it's far less.
Your own statistics. Do you maintain your own statistics?
Well, no, I don't have it documented, but we rarely have failed abortion.
Okay. Let's go ahead and look at exhibit J2. And if it's not in there, it's in the
Oh,
bigger
it's in
binder.
here, I'm
Okay.
sure. I'm just, somehow. Sorry.
Not, I think there's J1 and J3, but not J2. Is that correct?
I have J1. J3, yeah,
Okay.
all right. Where do I find J2?
Give me 1 second. So J2 is going to be in the bigger defendant's exhibit binder. Is that one that you have, Your Honor?
The plaintiff's binder, you mean?
No, the defendant's binder.
I have the defendant's binder too.
I apologize for making you switch between binders. I was prepared to display things electronically and
Got it right here.
very good. All right, J2 was stipulated to. Do you see J2?
I do.
Very good.
Can
All
you
right,
just tell me what it says so I make sure that I really have the right thing.
sure. This is the the Dunco medication guide.
Okay.
We
Thank
on
you.
the same
I have
page?
it.
Very good. So if you go to page, and if you're looking at exhibit J2, page 3 of 7, do you see that?
Yes,
So it says here under heavy bleeding, 1 out of 100 women, in about 1 of 100 women, bleeding can be so heavy that it requires a surgical procedure, surgical aspiration or DNC. Do you see that there?
yes.
Um, and what would are those 2 procedures that Northland provides?
What 2 procedures?
Surgical aspiration.
We do
and DNC.
aspiration. Yes.
Okay. And it states here also if we turn to the next page, page 4. In the first box on the left-hand side, do you see that box? What is mifeprex?
Yes.
At the bottom of that, it says about 2 to 7 out of 100 women taking mifeprex will need a surgical procedure because the pregnancy did not completely pass from the uterus or stop bleeding. Is that correct?
Well, I'm trying to find where yes, I see where it says that. Yes, in the Danko booklet, that is what it says.
Very good. And Northland, based on your understanding, is that an accurate statement?
Danko says it's accurate.
Do you have any reason to dispute what Danko says?
No, but I mean, I can't tell you if it's accurate or not. I didn't write it.
You did testify that about 8,000 abortions are provided every year by Northland. Is
I
that
said between 7 and 8,000.
between 7 and 8? So about 45% of those abortions you testified were medication abortions. Is that correct?
45% of first trimester abortions are using medication abortion.
All right. And so about how many would that be?
I don't know off the top of my head.
I guess about how many of that total 8,000 are first trimester abortions?
The majority.
Okay. Do you have any?
I just can't give you an exact number and I'm under oath.
Yeah.
So
No,
there's a
I-
small number of second trimester abortions. We do between 7 and 8,000 abortions. And by now I've forgotten what you asked me.
About how many of those 7 to 8,000 abortions you provide every year are first trimester medication abortions?
Of the first trimester, I testified, I believe 45% were medication abortion
Okay.
for a particular year.
All right. And then potentially 5% of those patients then would be experiencing some of the complications that may require surgical intervention.
Based on Danko's booklet, I mean, you know, I'm not a physician. So I can tell you what Danko's booklet says. I can tell you how many patients we see, but that's all I can tell you. This is what Danko's booklet says.
So is it approximately 6,000 abortions that are medication abortions that you provide?
Objection.
I'm not gonna, sorry.
Sustained.
Is there any estimate that you can give me?
Objection asked and answered. She doesn't know.
Is that your testimony that you don't know the answer?
I don't have a calculator and been sitting down and figuring this out. And it was never asked of me before. And I'm not perjuring myself by taking a guess.
I'm
And
not
you
asking.
wouldn't want me to.
No, I would not. I'm not asking the witness to do
So I
that.
think you can ask your question. I think I know where you're headed, without getting into the specifics of the numbers. Also, I'll just, a slight admonition, be careful not to ask her to testify as to the truth of the, what's in the NAF as opposed to the application to, Northland policies,
Very
which she
good.
can't testify to.
All right. So I guess, let's talk about some other, abortion procedures for a moment.
Okay.
Um,
We're,
You don't need to have that in front of you.
okay,
The dilation and evacuation procedure.
okay. I'm just going to close this book and move it.
Sure. You may close that book. Let me take a step back. Medication abortion, some other side effects could be nausea and vomiting. Is that correct?
Could be, yes.
Um,
From one of the medications, either the misoprostol or the mifeprex, or the pregnancy.
and incomplete abortion could be one of the risks with medication abortion. Is that correct?
Yes,
And for medication abortions, is it true that Northland used to ask patients whether or not they resided within 1 hour of Northland or the hospital?
we used to for, actually, I don't know that we asked that for medication abortion. But maybe we did, because if they had a problem, we wanted to make sure that they could get to a hospital. But I don't know if that's in our, I don't believe that's, I don't know if that's in our current instructions or not. You know, the longer medication abortion has been approved, the safer we have found it to be, and the less problems and complications we have. So what we might have had in there 5 years ago or 10 years ago may not be there now. I don't know. Can you show me something that says we have that now?
Sure. Go ahead and turn to Exhibit K2. It's not admitted, but I'm going to just present it to you to refresh your recollection. It's not in that binder. It's in the other binder.
It's in here?
Other binder.
Okay. Okay.
All right. Do you have K2 in front of you? It says
Yeah.
patient consent for medication abortion at the top of the page.
Yes.
Doesn't look like we're on the same page.
It says K2, page 2.
Can you flip over the page to page 1? Other way.
Oh, sorry.
All right. Do you recognize this form?
I believe this is the paper consent form for medication abortion.
And down in the bottom right-hand corner, there's a date.
Or
These-
23.
And for medication abortion treatment, if you look under,
Was this the most recent version you had?
no, this is not. This is an outdated one.
Thank you.
But I'm
That's
asking does this refresh your recollection about when
about an
Northland,
outdated form. Yes.
when Northland asked patients, do you live within 1 hour of a Northland Family Planning Center or 1 hour of a hospital. Do you see that under point 2 under medication abortion treatment?
Yes,
All right. And was this the form that was in effect in April of 2023?
yes,
And at this time, I would like to move to admit K2.
Okay, so admitted.
All right. So in 2023, Northland did ask that question. Is that correct?
yes.
Okay. Now, I'd like to talk briefly, and that's for medication abortion. I'd like to try to move on now and talk about dilation and evacuation procedures.
Okay.
With these procedures,
Do I need a book?
no, you don't.
Okay.
With these procedures, you don't dispute that there can be pain. Is that correct?
There can be what?
Pain
No.
associated. So there can be pain associated with these procedures?
Yeah.
Thank you. And what are some of the other risks that are associated with dilation and evacuation?
Bleeding.
Mhm.
Retained blood clots. A need to repeat a suction procedure. I mean, all of them are listed in the consent form, so you're asking me to do this from memory. Hysterectomy, death, uterine perforation. From memory, that's what I remember.
Okay. And if we turn to K7, you can just stay in that binder. K7, it's already been admitted. Yes. Let me know when you're there.
I'm there.
Perfect. Now, this form indicates that the physicians who perform your abortion, we're in the 3rd paragraph, medical procedures and anesthesia are independent contractors and non-employees. We talked about that. You talked about that in your direct exam. Do you remember that?
Trying to find where it says it, the 3rd paragraph. Maybe I'm looking at the wrong page.
Are you on exhibit K7, page 1?
No, I'm on page 2. Okay, page 1.
So the form indicates that the physicians are not employed by Northland Family Planning's as Northland Family Planning, East West, or the other entity that is a plaintiff in this lawsuit. Is that correct?
Yes.
So there is no plaintiff in this lawsuit that provides abortions. Is that correct?
Well, the independent contractors provide the abortion.
But those are staff that are employed by an entity that is not a plaintiff in this lawsuit. Is that correct?
That's correct.
And it's the physicians who provide the abortions. Is that correct?
Yes, but it was the clinics that were licensed by the state of Michigan, not the PC.
Right. But just to be clear, there's no one from the plaintiffs in this lawsuit who physically conduct the abortion. Is that correct?
That's correct.
Let's go down to the 4th paragraph there. You understand that the facility maintains, excuse me, we've already talked about that basically. Do you see point number 4 there?
Yes.
It indicates, I understand that the type of ultrasound performed at the facility is done to determine the length of pregnancy only. Do you see that language?
Yes.
And the ultrasound may range plus or minus 2 weeks. Is that correct?
That's correct. That is correctly written in there.
Okay. And this form is accurate. Is that correct?
Well, our ultrasound machines are really good, and can, I mean, but we have to make sure that patients understand it could be off by 2 weeks. And there's a lot of reasons why it could be off for 2 weeks.
You don't always determine gestational age to a precise date, do you?
Well, the ultrasound prints out a precise date when you do the measurements. But again, I'm not a physician, and perhaps a physician who is familiar with ultrasound can explain to you that a patient has a fibroid or, you know, some other anomaly of her uterus. You might not get an exact reading, and it's in the clinic that you need a more diagnostic ultrasound in a hospital. That's why we're making sure that people understand we're doing gestational dating.
And that date that is printed off by the ultrasound machine could be off by plus or minus 2 weeks. Is that correct?
It's not likely, but it could happen.
Would you agree that after the loss of a pregnancy, it can be common to feel anger, grief, guilt, or shame?
I think that those are common feelings for women who have miscarriages, who put babies up for adoption, who have abortions, and who have deliveries.
And
So it's a pregnancy. It's common in pregnancy. Or I don't know that it's common, but it can happen in pregnancy.
and that's something that Northland indicates on its website too.
Yes.
If someone was contemplating an abortion, would they recommend that you visit their website?
No,
Why not?
because if they weren't seeking additional information, there's no reason to send them to get information that they don't need. Otherwise, just like the 24-hour informed consent, patients seek the information about the procedure that they want. They seek the information about what they're feeling.
So your position is that patients should only get information that they seek. Is that correct?
Or that they need.
And you determine what information they need. Isn't that correct?
No, they determine what information they need.
You said there that they seek information, they should have that information, or that they need.
I don't think what I just said was inconsistent. It's not up to me. It's up to the patient what she feels that she needs.
It's up to you, though, to decide what information goes into those consent forms that a patient receives. Is that correct?
But you were asking me about the website.
I am, but I'm trying to ask you questions about the difference between what a patient needs and what they're seeking.
The informed consent is a legal document, as you know. It's developed using the standard of care, best evidence, based on best evidence-based practices and medicine. Websites are developed to give patients a variety of information on topics. It is not informed consent.
I understand. So there is information, though, that all patients need to have before they have a procedure. Is that a correct statement?
And that's what's in their consent form.
All right. And they need that information whether or not they seek it. Isn't that correct?
If they're going to have a medical procedure, whether it's an abortion or brain surgery, they're going to get a consent form that has to do with the procedure they're going to get. I'm not understanding what you're expecting of me.
Just that answer that you gave. Perfect. Now, patients don't necessarily know all the possible information that is available regarding abortions. Isn't that true?
You mean, do they know everything about abortion?
Correct.
Only if they choose to seek that information out.
Okay. But a patient coming into Northland Clinic doesn't know necessarily what they don't know. Does that make sense?
That's why we give them the information page that we give them about their procedure.
And for example, Northland does have a fetal development chart. Isn't that correct?
Yes.
But you don't tell every patient that you have a fetal development chart, do you?
Most patients don't ask about it. They can ask to see their ultrasound if they want. Most patients, actually, some patients ask, some don't. It is up to the individual patient what she wants.
Some patients ask and some patients don't. Were you referring to the ultrasound or to the fetal development chart?
Well, rarely do they ask to see the fetal development chart.
But some patients do.
Well, usually it's when they want to see fetal tissue after, and then we show them the fetal development chart, and we actually show them pictures of what the tissue will look like before they view the tissue.
Do you inform each patient that that is an option for them?
I don't know if that's in the consent form anymore or not, but if a patient's interested, they have no qualms about asking.
If a patient didn't know about the fetal development chart, they couldn't know to ask to see it, could they?
Fetal development charts are available in their doctor's office. They're available on the internet. They're available in so many places. Apparently, they must, if they are seeking that, getting that information prior to coming in. But it is not something they're asking us about. And we don't give them that because they don't need it if they're there for an abortion and they don't want it.
But a patient, if they don't know about the fetal development chart, can't ask for it, can they?
I guess that's an obvious answer.
Okay. The same goes for information about adoption, isn't it?
Patients who are coming to Northland are coming for abortions. If they are not sure of their decision, if they fall in that small number of people, we go over those options with them. But we do not go over all those options with patients if they don't want that information. And most patients who are seeking abortion don't want that information.
Now, a patient can change their mind up until the point that the abortion has started, isn't that true?
Oh, absolutely.
And there are a number of patients every week that come to your clinic and decide not to go through with the abortion at that time. Isn't that correct?
They change their mind generally in counseling, not when they're in the room with the doctor, right up to the point where the abortion is going to be done. It's someone who was confused or not sure of her decision. And after talking to someone who is completely unbiased, not invested in their decision, only in helping them see their situation based on all of the things I've already testified to, yes, they change their mind. And we want them to change their mind, or we ask them, we tell them that we won't do an abortion that day, that they're not ready.
And about how many patients, well, actually, you estimated to me, I believe at the deposition, that about 10 patients a week change their mind. Is that correct?
I don't remember if I said that number or not, but there are definitely some patients every week.
Do you dispute that number?
I don't dispute it. I'm telling you, I don't remember what I said. Can you show me?
Do you recall, or sitting here today, how many patients do you believe every week?
There are some patients every week, but I would have to go back and look that up so that I'm giving an answer under oath that's accurate. I'm not trying to be difficult. I'm trying to be honest.
And I appreciate that.
Okay,
I understand that you are under oath and I'm not trying to trap you in any
I
way.
don't break the law.
I was not even hoping to
No,
accuse you of
but-
that.
I want
Um,
to assure you of that.
I appreciate that. And at your deposition, you were under oath. Do you remember that?
Yes,
May I approach to refresh the witness's recollection? It would be her deposition transcript from October 29th, 2024, page 52, lines 6 and 7.
six or seven, 6 and 7.
I'm not object, just my review of the transcript here is wrong estimate. This was the number of patients turned away.
Mr. Aspenson, while you're looking for that, quick question. How much longer do you think your examination is going to be?
You know what? How about, shall we take a lunch break now and I will make sure to have that ready on the other side of that?
Does that work for you? Okay, then
Perfect.
that is what we'll do. Is that work for everyone? Okay, let's take a lunch break until 1:30. Is that acceptable? Or okay,
One of whom has a flight that she needs to get, they're wrapped out. Would it be possible to take a slightly shorter lunch break to 1:15?
yeah, let's do a half an hour lunch break to 1:10. Does that work?
Very good. Thank you, Your Honor.
Everyone eat quickly and we stand recessed. Thank you.
All being recessed.
That abbreviated lunch. Please be seated. We will pick up where we left off before our lunch break. Ms. Chillian, you are still under oath.
Yes.
And Mr. Aspenson, if you'd like to continue your cross-examination.
Thank you, Your Honor. I want to talk briefly, and I appreciate opposing counsel pointing out that I was directing you to the wrong page there. I'm going to ask you this question. Approximately how many patients, based on your recollection, are turned away every month or were turned away every month because of the 24-hour requirement in the law?
Approximately 10 was the document that I gave you, but I also testified it was more than that we couldn't document.
Okay, about 10 documented turnaways. And do you recall at your deposition what you told me was the number of approximately how many patients per week changed their mind after coming to your clinic, changed their mind and decided not to have an abortion?
Several
Okay.
is what I think I said.
Would roughly 5 or 6 be accurate?
It's several between 3 clinics. You know, I would have looked, but I don't know exactly what I told you.
Okay. I'm going to turn to page 98 of your deposition transcript just to refresh your recollection.
I'm that.
I'm going to give that to
Oh,
you if I
okay,
can approach
thank
the
you.
witness, Your Honor.
Sure.
Go ahead and read that.
We have roughly 5 to 6.
You can read it to yourself. You don't have to read it out loud.
Sorry.
No worries. And so, does that refresh your recollection about what you told me at your deposition?
Yes,
And so at your deposition, what did you tell me about how many patients changed their mind
about 5 or 6 patients a week between 3 clinics.
between clinics? And those 5 or 6 patients a week, do some of them eventually return and have an abortion?
Yes, but we don't track that either.
Okay. But there's 5 or 6 a week that decide at your clinic to not have an abortion.
Yes, and that's after the 24-hour. It's when we do our counseling.
Right.
Oh. Hello? I'm sorry.
That worked.
I will speak louder and into the mic. That's after they've had the 24-hour information prior to the injunction that 5 or 6 patients a week change their mind after their counseling and speaking with us.
All right. And that number of 5 or 6 who changed their mind, you haven't seen any significant change in that number, have you?
No,
So it's basically the same before and after the injunction.
it's been the same for years.
Okay. Now, it's true that some patients need to take time and space to think about their decision to have an abortion. Is that correct?
Yes, and most do before they make their appointment. Am
Um,
I too close now? Okay.
Fine. Thank you.
and on your website, you provide links to materials to help patients who are considering that decision. Is that correct?
Yes.
If you can go ahead and turn to the document in the binder right in front of you, marked Exhibit H. And Your Honor, while the witness turns to Exhibit H, I'll retrieve my other binder from the witness. Do you recognize this document?
Yes.
What is this document?
It's called the Pregnancy Options Workbook. It is information, it's exercises, it's things for people to fill out to help them with decision making.
And is this something that Northland provides a link to on its website?
Yes.
Did you have any role in this workbook?
In the original workbook, yes, but it was rewritten recently and I didn't have a part in that.
Okay. And I would like you to go ahead and turn to, do you see Exhibit H down there at the bottom of the page? That says page 1 of 16. Or excuse me, 116.
It's still H.
Yes, it is still H. You're on H. Do you see the page? I just want to make sure you see the page numbers at the
Yes.
bottom. Very good. So if you can turn to the one that is page 12 of 116. Twelve of 116 at the bottom of Exhibit H.
Okay.
And so as part of the pregnancy options workbook, it says there in,
Objection, this document is hearsay. Unless he's using the document to impeach the witness, he can't just read.
let me lay a foundation. So is this the document then, based on your experience, that Northland provides to patients from time to time?
From time to time, yes.
And I'm going to move to admit Exhibit H as a document that Northland uses and counsels patients with from time to time.
Yeah, still object to the admission of this document. It's still hearsay. It is not a document that it wrote and produced. Did not put it into evidence, and it is still hearsay, and there's no exception to the hearsay that applies in the file of adjudication documents.
What is your response to the fact that this is a document that Northland, the website links to? So it is endorsing and directing patients to it.
Yeah, but I acknowledge that this is a document that is linked on their website, which, you know, Ms. Chillian has testified there's no relationship to that. I don't know the relevance, but the more important reason that it's not admissible as evidence is that it's still hearsay. Just the fact that the links to it on their website doesn't mean that any of the exceptions to the hearsay apply.
If I'm not mistaken, the witness testified that this is a document that Northland provides to its patients, not exclusively online. But this, I'm not offering it for the truth of the matter asserted in the document itself. Just the fact that this is presented, this is something that is presented to patients, not for the truth of the matter asserted in the document.
And is that the reason for admitting it as an exhibit as opposed to just talking about it with the witness?
Correct.
Witness has not testified that this is a document that's presented to patients. The only foundation of the document is linked on Northland's website. So I still don't see how any of the exceptions to the hearsay rule would apply.
Why don't you lay a few more questions of foundation and then.
If memory serves, and I might be wrong, my memory is not perfect, but we talked about this document at your deposition. Is that correct?
I believe we did.
And my recollection is that you testified that this is a document also that is provided to patients sometimes in the office. Is that correct?
I don't remember what I testified to,
Okay.
but it is offered to patients who are unsure about their decision.
And you have physical copies of this document at your office or print them off at the office sometimes.
We don't print them, but we have copies.
And you provide those copies to patients.
Yes, if they need them or want them.
I think that sets the proper foundation. I'm going to allow the exhibit to be admitted into evidence,
Thank you, Your Honor.
but not for the truth of the matter asserted.
Very good.
You're welcome.
And so this document says in bold there, giving yourself time and space to think. Do you see that heading?
Yes.
And do you agree that that is an important part of the decision-making process for some patients?
For the small number of patients who are undecided or who really don't know how to make decisions on their own, it's some suggestions for them on how they might do this. It also could be used for a number of other things in life situations.
And eventually, well, right, thank you. So let's talk about your intake process for patients for a few minutes. That typically starts with a phone call to Northland by the patient. Is that correct?
Yes,
During that phone call, I presume there's a confirmation that the patient is pregnant. If they're making an appointment for an abortion, there's confirmation that the patient is pregnant on that phone call.
yes,
And there would have to be some kind of assessment of what kind of abortion is going to be conducted when the patient comes in, isn't there?
based on what she can tell us about the length of pregnancy. Yes,
And so on that phone call, there's an assessment of what the approximate gestational age is.
yes,
And those are standards that you have developed with physicians and with best medical practices. Is that correct?
that's correct.
And you inform the patient of what abortion options are available to that patient. Is that correct?
Not on the phone call. She's calling because she says, "Hi, I want to make an appointment for an abortion." And that's the information we give her. There's no reason in the world to say, "Well, let me give you information about parenting or adoption." She's not asking about that. If she asks about that, we're happy to provide her with that.
And maybe I misspoke, but I don't think that was my question. You inform the patient on the phone call about what abortion procedure would be available to her based on her gestational age.
Okay, I didn't understand your question.
I think we did.
Yes,
Okay. So the patient knows when they arrive if they're going to have a medication abortion or an aspiration abortion or a DNC.
if she's correct in her gestational limits and she makes her appointment on time, the day that she's supposed to, yes,
And one of the reasons that assessment needs to be made is that the appointment times are going to vary depending on the procedure. Is that correct?
not necessarily. It's more the procedure. What she will be prepared for. Will it be 1 day or 2 days? You know, she's got to arrange childcare, rides, all of the same things.
And of course, the clinic has to make sure that there's a doctor there to perform that particular abortion.
Yes,
And Northland doesn't perform all abortions every day of the week, do they?
each clinic provides abortions a substantial number of days, but not 7 days a week, no.
And the kinds of abortions that are available on a particular day, vary. Isn't that true?
I think you're asking me if we do D&Es every day.
That is what I'm asking.
We have 4 days that we do them in different locations, but if a patient has extenuating circumstances or is very near the gestational limit, our doctors will accommodate that patient's schedule. So we don't really turn people away because of our schedule.
And, I don't need a very mathematically accurate answer, but medication abortion, the appointment time is roughly 2.5 hours, roughly.
Roughly.
For an aspiration abortion or a suction abortion, those are the same thing, correct?
We tell people 3 to 4 hours in case there's a wait. But it could be anywhere from 2 to 4 hours, depending on patient's needs. How many questions? Did they come in with money? As I've already testified, so many of our patients need funding and they show up on a wing and a prayer. And we have to stop and look for funding for them. So times vary. However, it has slimmed down the time since we don't have the 24-hour waiting period.
And for the 1-day dilation and evacuation procedure, the DNE, that takes approximately 6 hours. Is that correct?
Yes,
And for a 2-day D&E, day 1 is approximately 3 to 3.5 hours, correct?
usually.
And day 2 is approximately 3 to 5 hours. Is that correct?
It, there's a rule, you always listen to the cervix. I'm not a doctor, but I totally understand that. And it could be 3 hours, it could be 6 hours. She could be there all day. It's checking the patient, adjusting her medication, and making sure that we're doing her abortion at the safest time.
And I noticed on Northland's website, there's a list of pre-abortion procedures. Do you remember that page on the website?
Instructions or procedures?
I think it's titled procedures. We can go ahead and look at Exhibit I in that binder in front of you.
Your binder?
Yes.
Okay.
And this one was stipulated too. Oops, I am looking at the wrong, I apologize. Give me 1 second. No, I was actually right. It is Exhibit I. And you are correct. It's titled instructions.
Okay.
Do you recognize this exhibit I?
Yes.
And it says before your appointment, no aspirin products 48 hours before your appointment.
Yes.
As well as no street drugs, marijuana for medical use, or alcohol 24 hours before the appointment.
Correct.
Are those standard procedures?
Yes.
All right. And so if someone were to have aspirin within that 48-hour window, could that be problematic?
Again, I'm not the physician.
Okay.
So if she admitted to it, then the physician would make an assessment and a decision.
When patients leave and are done with their procedure, you provide them a 24-hour phone number to call in case of emergencies. Is that correct? It wouldn't be a burden to provide that phone number to the patient at that initial phone call, would it?
She's not going to remember it. She's not going to keep it. She may not have even made the appointment. And it seems like we're telling her we expect her to have problems before she even makes an appointment. So it's more appropriate, as with every other kind of medical procedure that's done, when a patient is discharged, you give her home care instructions and a telephone number, a contact telephone number on who to get hold of and how in case there is any medical problems. And that's when we give it to the patients.
But I mean, Northland could say something along the lines of, we here at Northland care so much about your health and safety. We want you to write down this phone number or put it in your phone right now. It's a 24-hour emergency phone number in case there are any complications, but we want to make sure that you have that right now. That's not a burden, is it?
So if we talk to 75 patients a day, that just took at least 1 minute. That was unnecessary for somebody to go get a piece of paper and a pencil and write something down when they may not even be interested in making an appointment.
Okay.
So it is a burden. And it's not done in any other medical practice.
Northland informs patients that help is available if they're being threatened or intimidated. Is that correct?
Oh, you're switching subjects.
I am.
Okay. I'm sorry. I was still on home care. Can
No
you
problem.
just repeat
Sure.
that?
You inform patients that help is available if they are being threatened or intimidated.
If we have reason to believe that they are threatened or intimidated, yes.
All right. And Northland makes referrals to domestic violence shelters if it is appropriate. Is that correct?
Yes.
And it's not a burden to provide patients with hotlines that they can call in case of domestic violence or sexual assault. Is that a burden?
It's rare. And so it's necessary, but there's no reason to give it to every single patient.
It's rare, but any case of sexual assault or domestic violence is important, isn't it?
Yes, that's why earlier when you asked me about the wait time, and I said, it depends on the individual patient, what's going on with her. Of course, we would spend the time with her and give her those referrals if it was someone who needed them, but very few patients need them.
And we're all humans, right?
Yes.
And so there are times when we may not know if someone is experiencing violence or assault. Isn't that true?
Correct. But just like in hospitals, you've probably never gone in the women's room in a hospital or gynecologist office, but there are posters hanging and there are cards with help for domestic violence. We have the same kinds of things because I don't know that it is sort of a standard of care to provide patients with that information in a safe place. They can slip a card, they can take a photograph with their cell phone, but they can do it without being embarrassed or ashamed and get the same phone numbers for the same reason we have it on our website.
Exactly. And so it's not a burden to the individual, the patient, to see those posters hanging up on the wall. That is a safety net, isn't it?
Yes, if she chooses that information, of course.
Now, I'm going to switch gears just a little bit again.
Okay.
We've kind of overall been talking about the patient intake process. You indicated that there are a number of forms that are emailed to your client and your patients. Is that correct?
Since we started using electronic health records, we email some basic information to the patient to fill out before she comes in. Yes.
And that doesn't burden your patients, does it?
It shortens their visit, so they're usually pretty happy about it.
And you collect email addresses and phone numbers when the patient makes the appointment?
Yes.
And you could technologically send a link out to other materials to that patient at that email address, couldn't you?
We don't send something out that the patient doesn't request or need.
That wasn't my question.
But that is my answer. We don't send something out to people that they don't request.
You're here as the representative from Northland.
Yes.
Technologically, you could send a link out to the state material to your patients. Isn't that true?
Yes.
Northland can receive electronic communication from its patients. Is that correct?
If they want to email us, yes.
And Northland has printers, is that correct?
Yes.
And Northland could print the state forms from the website technologically, isn't that correct?
The form says the patient must print the form and bring it in with her. It does not say, email it to the clinic and they can print it for you. It doesn't say that.
I understand.
That is not the way the law was written. And I'm not going to break the law.
My question was technologically. Does Northland have the ability to print something that a patient emails them?
Of course.
All right. And does the law itself specifically state that the patient must print the document? Actually, I'll withdraw that. It's a legal question.
Thank you.
after that initial call with the patient, most abortions are scheduled more than 24 hours after that call. Is that correct?
Most.
Few are scheduled within that 24-hour window now that the injunction is in place. Is that correct?
Yes.
But it's not the majority of patients that are scheduled within 24 hours, is it?
No. But I don't know how many. It's a lot, but I haven't counted them. I'm not tracking them.
That was going to be my next question, and now I don't have to ask. Thank you. Also, during this time, Northland could offer information about birth control during that phone call in a non-stigmatizing way. Isn't that true?
We could if the patient wanted it, but she's calling to make an abortion appointment. That's what's foremost on her mind right now. And if she asks about birth control, we're happy to answer any questions. But generally, the appointment takes in a lot of information and gives out a lot of information. And the patients aren't concentrating on birth control usually when they call to make an appointment. That's my experience.
If you can go in that binder to Exhibit A.
This
and-
binder?
Yes, that binder. And it's the National Abortion Federation guidelines.
Got it.
Can you go to recommendation 2.42?
You don't happen to have a page number, do you?
I believe it's page 17 if you're going by the Exhibit A, page 17. I gave my copy to opposing counsel and I don't have it right in front of me, but I believe that's correct.
What was the number?
2.4.2.
Yes.
Are you there?
Yes.
And that one says evidence-based guidelines for contraception counseling should be followed. Do you see that one?
Yes. I was just looking at the one before it. Sorry. It is a recommendation that evidence-based guidelines for contraceptive counseling should be followed. It's not a standard, it's a recommendation, so there is a difference. I'll just point that out.
Right. But following the NAF standards is not a burden on patients, is it?
Well, they also aren't talking about on the phone. They're talking about patients in the clinic who've already had an abortion, which we do.
And so you counsel patients after their abortion on contraceptive?
If they want contraceptive information. Many of them already know what they're going to do. Some don't want to hear what we have to say. Just like after a delivery, some of them say, I'm never having sex again. You know, we do our best to remind them that they probably will. But it's up to the patient what she wants. We don't force information or coerce her into taking information she doesn't want.
So I think that leads into the next topic that I want to talk about. If you can look at Exhibit 4 in the other binder that you have in front of you, not the one in front of you. And let me know when you're at Exhibit 4.
I'm there.
All right. And you have had an opportunity to review these MDHHS informed consent for abortion materials. Is that correct?
Yes.
Why do these forms not comply with the NAF standards?
Which page are you talking about?
I would like your opinion based
all of them?
on, yes, on all of them. What do you find violate the NAF standards?
Well, for starters, we do not have to, it's not a recommendation from NAF or any other medical organization to give a patient needing a particular method of abortion, every method of abortion. It is not a standard or any kind of standard of care to force patients to have a fetal development chart. It is not a medical standard of care to provide every single patient with prenatal care and parenting information. It is a standard of care to screen for coercion, but to do so in a way that makes a patient comfortable, makes her open and available to talk to you, not hand her a piece of paper or read her a set of preset questions that actually may scare her away or stop her from talking to you. Did that answer your question?
All right, so you said a number of things there.
Okay.
However, if a patient requests a fetal development chart, it doesn't violate anything to give that chart to them, does it?
If she requested it, no.
If a patient asks for adoption information, it doesn't violate any standard to give her that information, does it?
No.
If she is interested in parenting material, there's nothing wrong or burdensome about giving her that material. Is that correct?
No.
And the coercion protocols that the state has drafted, there's nothing that mandates that you follow those. Those are just guidelines. Isn't that true? In other words,
The suggested questions feel like part of the law. And in a hostile administration, I don't want to be breaking the law.
but there is no requirement, based on your understanding, that you follow every single question that's in those guidelines, correct?
I don't know. I'd have to read them again. And actually, I need to know exactly what the law says.
All right.
Once again, there's a lot of laws. There were a lot of laws in Michigan, and we try to be very careful not to break any of them.
So it seems to me that what you're saying is that this DHHS material, the reason you believe that it's inconsistent with NAF standards is that this information should only be provided if a patient asks for it. Is that your opinion?
There's no other medical procedure done in this state where a patient is required to look at alternatives to the procedure they're going to have. It's biased. It's unnecessary. It burdens the patient. There's no reason for it.
But I want to point you back. Go ahead and reopen that binder to Exhibit A. And it's page 16 of 79.
Oh, this binder?
Yes, I'm sorry.
That's okay. Which section?
Page 16 of 79 at the bottom of Exhibit A.
Oh.
We're
We're
looking
back
at.
to the NAF standards.
Mhm.
Okay,
It says there, under the policy statement, a person must give voluntary informed prior consent to an abortion and express understanding. And then if we go down to section 2.1, the practitioner must ensure that accurate information is provided about the abortion process and its alternatives. NAF says that patients have to be informed about alternatives. Isn't that true?
in a discussion with the patient, if she's ambivalent about her procedure, we go over every alternative with her. I have yet to meet someone who's pregnant who doesn't know that if she doesn't have an abortion, she's going to have a baby. We meet the patient where they're at. We provide her with information that makes it comfortable for her to talk. And I don't believe we're inconsistent with the NAF standards at all.
But if a woman doesn't ask, you're not going to provide information about adoption. Is that correct?
That's why we have all of the screening questions and all of the things that we do. It's not just for coercion. In fact, coercion is so rare that most of the screening tools that we use, the techniques that we use, are to find the ambivalent patient who may not be sure about her abortion. We work with an adoption agency. We certainly are happy to provide that information, but it is insulting to give it to someone who's there for an abortion, because then she thinks we are trying to influence her. We do unbiased counseling. We don't lead a patient, unlike the anti-abortion sites. We don't lead a patient one way or the other. If she has an abortion, fine. If she doesn't have an abortion because she doesn't want one, I am happy about that. I don't want her to do something that is against her own best interest. And neither does anyone on our staff.
And again, providing accurate information to a patient is not a burden on that patient, is it?
Objection, we've gone around this.
I don't think that particular question has been asked and answered.
Okay, limit it to that question and then move on.
I feel like I am going around in circles. I feel like I've explained in the very best way I can to you that what our ethics are, what our principles are, how much we care about our patients, how much we want them to have good information, but we don't want to coerce them or force information that they don't want, because then they don't trust us.
But you didn't answer my question.
Okay, what is your question?
It's not a burden on a patient to give them accurate information, is it?
You don't know if it's a burden on a patient. I don't know if it's a burden on a patient. I give them accurate information that they request, but it is not fair to make an assumption that they want something because you happen to think it's not a burden, or someone else happens to think it's not a burden. You don't know where her head is. That fetal anomaly patient, do you think she wants information about parenting or prenatal care or any other alternatives? No, she wants to have that baby and she can't.
Court's indulgence for 1 minute. I think I'm just about done. I'd just
Okay.
like to check my notes. isn't it true that you already use your own coercion screening process right now, currently with the injunction in place?
Yes,
And that process would not change if the injunction were to change, would it?
no,
So you are currently doing all of the screening just the way that Northland thinks is best, isn't that correct?
Objection mischaracterizes.
She can say no.
we've always done this screening.
And nothing would change if the coercion element of this law was struck down from what you're doing today.
If it were struck down, nothing would change.
No further questions, Your Honor.
Very much.
Thank
Ms.
you.
Chillian. Appreciate you. Oh, do you have any redirect? Yes.
Yeah, I don't have any questions.
You need my name.
Yes.
So my name is Daniel Ping. I'm representing defendant Hertel. We have no questions.
Okay,
for this
thank you.
witness.
All of us to approach.
No, is there anybody who has any questions from the remaining defendants? Okay, and redirect, Ms. Swain.
Hello again, Ms. Chillian.
Hello.
All right, so you were asked a few questions by Mr. Benson about the functioning of the clinic and who provides which services at the clinic earlier. So you testified that obviously the abortion providers, the physicians are the ones who do the abortions. Do Northland staff assist physicians in performing abortions?
Yes,
Does that include nurses and medical techs?
yes. Every patient, everyone is a patient advocate.
And are the nurses and the medical techs, are they employed by the management companies that are the plaintiffs in this case?
Yes,
And you testified earlier that the patient advocates are also employed by those entities?
yes,
And you testified that they perform the bulk of the counseling for abortions, correct?
yes,
And does that include the coercion screening?
yes.
And which staff members have to verify that patients have completed the requirements of the 24-hour mandatory state information law?
Everyone who checks a patient in.
So would those be the patient advocates?
Yes,
You were asked some questions about the alternatives to abortion. Do you recall that testimony? Well, you were asked a lot of those questions. So I just want to confirm, if a patient comes in who's sure of her decision to get an abortion, is carrying the pregnancy to term an alternative for her?
no,
Your Honor, objections leading.
It's not a leading question, Your Honor. I'm asking, yeah. Would you give such a patient information about parenting or adoption?
no,
And you were also asked some questions about the pregnancy options workbook earlier. Do you recall that testimony?
yes,
Do you give that workbook to every patient?
no.
Object again, Your Honor. This is redirect. The attorney cannot lead witness either yes or no questions. I'm allowed to do that on cross-examination.
This is not a leading question. It's squarely within the cross-examination. I want to
I
ask
think-
some more questions about the pregnancy options workbook.
Yeah, I think that the subject matter is within the what you can allow, what you're allowed to ask, but try to give her answers that she can give answers to as opposed to just yes or no answers.
Okay. What do you do with the pregnancy options workbook?
We give it to patients who are unsure about their decision, and either they choose to come back another day and think about it, or we have said to them, you can't have an abortion today. You need to do some work before we would see you.
Do you have concerns about giving the workbook to every patient?
Yes,
What was the exhibit number of the workbook? H. Can you turn to exhibit H in the big binder in front of you? All right. And then I think it's page 3 I'd like you to look at.
Do you want me to read it to myself?
No, I want to read a quote and ask you a question about it. So it starts, "Dear reader, if this workbook is in your hands, you are probably pregnant and not sure what to do. You're in the right place. Read on." Then it goes on, "If you are having a difficult time with your decision, you may think," oh, I'm sorry. Yes, that's all I wanted to read. So is that characterization, what's your opinion about that characterization of the purpose of the workbook?
This is exactly who the workbook was written for. Someone who's having a difficult time with their decision, but they end up in the clinic, and it is a safe place to get information and resources.
All right. And earlier, Mr. Benson showed you the Mifeprex label. That was, I think, J2 in the binder you're holding.
Sorry, I went to J1. Okay.
Do you provide the Mifeprex label to all patients that get a medication abortion?
It's an FDA requirement.
The question was, do you provide the Mifeprex label to all patients that receive a medication abortion?
Objection.
Objection
Yep.
was placed. I object because the question is,
No, let the objection go first. Yes.
I'm sorry.
no worries. Your Honor, objection leading. I've tried to limit my objections to leading questions. Questions needs to be not yes or no questions.
Swain,
Your
can you
Honor.
reframe the question?
Ms. Chillian, what do you do with the Mifeprex label for patients that are getting medication abortion?
It's an FDA requirement to give this booklet to any patient getting Mifeprex.
And you testified earlier that the label discloses the possibility of complications like needing more misoprostol and the possibility of needing a procedural abortion or an aspiration afterwards. Do your consent materials for medication abortion also disclose those possibilities?
Yes.
Okay, can you turn to exhibit Exhibit K1?
In this book? Or your? Or the
I think
small
it's in
book?
both, actually.
This one's just easier to handle.
All right, so after the big box there's a header that says risks of medication abortion, and then there are a few bullets. Can you read the first bullet that starts continuing pregnancy aloud, please?
Continuing pregnancy, incomplete abortion, hemorrhage, infection, allergic reaction, death.
Hold on.
Am I reading? the
No,
right
so
one?
what I'd like you to read is everything that comes after continuing pregnancy in that first bullet. May I approach the witness?
Yes,
Yes, the first bullet there.
Oh, okay. In some cases, the pregnancy does not end after taking the medications because misoprostol can cause birth defects. If this happens, you may need to take more medicine, or have a procedure called a DNC or aspiration abortion to complete the abortion. This is ours, but the package insert is like you get with any prescription where risks and benefits of medication are included. The pharmacy
Right,
has
so
to
that's
give
one
it
of-
to you.
This is one of the risks that's included. Yeah.
Yes,
Okay. Now, if a patient has a medication abortion and returns and needs a aspiration procedure, does she sign additional consent forms at that point? And which
Yes.
ones would it be?
it would be for the,
Please continue.
Yeah.
it would be for the suction abortion.
Okay, I think, was that K7?
We'll find out. Yes,
Now, you were asked earlier about patients filling out the online medical history forms before their procedure. Do you recall that testimony?
yes.
If a patient comes in and hasn't completed those forms, what happens?
We give her a tablet and she fills it out there at the clinic.
Can she get her abortion that day?
Yes,
You were asked some questions about emailing with patients earlier. Do you recall that testimony?
yes.
I don't know if you know the answer to this, but is your email system set up to be HIPAA compliant?
No. And there's always a concern that someone will see someone else's email. So without express permission, and if the patient has no concerns that someone else may see her phone, or a computer if she has one, we wouldn't email anybody anything.
You were also asked earlier some questions about which parts of the state materials were burdensome. Do you recall that testimony?
Yes,
In your opinion, is it a burden to give a patient accurate information that's irrelevant?
yes.
All right, can you turn to Exhibit A in the big binder again? And go back to page 16. All right, do you see standard 2.4 at the bottom of the page?
Yes.
Can you read that, please, aloud?
A person must undergo the abortion as expeditiously as possible in accordance with good medical practice.
I believe you testified earlier that the recommendations in this document are not required.
There are standards and there are recommendations.
So what's the
Standards are
difference?
not required.
Standards are not
I'm
required.
sorry, recommendations are not required.
And what about standards?
Standards are absolute.
Or what?
Standards are absolute. We must follow those.
No further questions.
Okay, thank you very much. Any recross?
Miles set?
One second.
No. I knew not to put my glasses away.
I apologize.
That's okay.
You indicated that,
Oh, do I need the book?
no. Accurate, irrelevant information shouldn't be provided to the patient. Should
Accurate, irrelevant.
information should not be provided to a patient, correct?
It doesn't need to be, no.
Who decides if the information is relevant?
the patient.
All right. No further questions.
Thank you very much. Thank you, Ms. Chillian.
Thank
You are
you.
excused. All right.
Clean up my mess.
Do you want to call your next witness?
Yes, Your Honor, at this time, it's called Dr. Sharice Loer.
The perjury of the testimony you're about to give.
Yes, I swear.
Your Honor, may I approach just to clear those out of the way for the witness?
Yes, absolutely.
Thank you.
Your Honor.
Yes,
I wanted to give this spelling with that.
Oh, yes.
sure.
CHARISELODER. LODER.
Mr. Asmussen?
In the pre-trial statement. Or any other witnesses.
Your Honor, every remaining witness for plaintiff is an expert witness. The sequestration rule does not apply to experts. Additionally, this is being live streamed on YouTube. Plaintiff's witnesses, defendant's witnesses are not here. There is no prohibition on them tuning into YouTube. It is no different them sitting in the courtroom than it would be if they were sitting at home watching this on YouTube.
I don't know that this is a situation where sequestration of witnesses is necessary, especially since I think during discovery, all the information was shared between the various witnesses and has been commented upon. Do you have anything else to add to the argument on top of that that would militate towards sequestration?
I have that.
Okay, thank you.
May I proceed, Your Honor?
Please go ahead.
Yes, Megan Kelly for the plaintiffs. Hi, Dr. Loder.
Hi,
Are you a medical doctor?
I am.
What kind of medical doctor are you?
I'm an obstetrician gynecologist.
And I know you're getting over a cold, so
Mhm.
if you need a second for coughing or need more water, just let me know, okay?
Thank you.
Where'd you go to medical school?
Penn State College of Medicine.
Did you graduate?
I did.
What'd you do after you grad?
Dr. Loder, could you pull the
Oh, sorry.
microphone close
Yeah.
to you? Is
How's that?
that good? Okay.
Penn State College of Medicine, and I graduated.
What did you do after you graduated from medical school?
I attended residency at University of Rochester Strong Memorial Hospital in obstetrics and gynecology.
Did you do any additional training after your residency?
I did. I completed a fellowship in family planning at University of Michigan.
What's family planning?
It is the study of abortion care and contraceptive care. Additionally, the study of research methods and advocacy.
Beyond
It is the study of abortion care and contraceptive care. Additionally, research methods and advocacy.
do you have any degrees other than your, I assume you have a bachelor's degree,
Correct.
other than your bachelor's degree and your MD?
Yes, I completed a master's in health and health science research.
Are you board certified?
I'm board certified OBGYN.
Did you ever practice obstetrics?
I did
for how long did you practice obstetrics?
for 8 years.
Do you have any board certifications other than in obstetrics and gynecology?
I do. I have a subspecialty certification in complex family planning.
And have you been board certified consistently since you first obtained that?
I have.
Are you licensed to practice medicine in the state of Michigan?
I am.
What do you currently do, Dr. Loder?
I am an associate professor at the University of Michigan, which involves providing clinical care and teaching to medical students, residents, and fellows at the University of Michigan, Michigan Medicine.
Do you have a position at the University of Michigan's Family Planning Well, let me ask you this. Are you the Director of Clinical Family Planning Services at the University of Michigan?
I am.
Do you have a role in the University of Michigan's Complex Family Planning Fellowship Program?
Yes, I'm the program director.
In your time and in your work as an associate professor at Michigan, do you have any role in training residents to provide abortion care?
I do. I do train residents in clinic and in the operating room to provide abortion care.
Are you familiar with something called the Ryan Residency Training Program?
Yes, I was the director of this until this fall.
What is the Ryan Residency Training Program?
It's a national program where residencies have elected to provide abortion training and contraceptive training to OBGYN residents.
As an associate professor, do you have a role in teaching medical students, residents, and fellows?
I do.
Can you tell us about what you do to teach?
Yeah. Teaching of medical students can be in the classroom, but can also be in clinic. I do teach some electives to medical students, but mostly I'm teaching them hands-on in the clinic when they're seeing patients with me or in the operating room.
You mentioned you also have a clinical practice. Is that at the University of Michigan?
It is.
What's your clinical practice focus on?
Yeah, I provide a small a small clinic of gynecologic care, seeing patients for annual exams, birth control, concerns about bleeding, but most of my practice focuses on complex family planning.
What percentage of your professional life is spent providing clinical care?
About 65%.
Can you describe the demographics of the patient population you see when you're providing complex family planning care?
Yeah, most of my patients are underinsured or insured by Medicaid. About 25% of patients identify as Black or African American, and many are low income.
So the patients that you see in the complex family planning clinic, are they all local to the Ann Arbor area, or what's their geographic sort of spread that you pull from?
Yeah, patients are referred from all over the state, often by another provider, but sometimes self-referred. They come from all over the state of Michigan and can also be referred from out of state, most commonly from Ohio.
I won't comment on Ohio, given that we're here in Michigan.
Me either.
Can you describe the types of care that you provide for your patients in the complex family planning clinic? What sorts of things do you do when you see them?
Our complex family planning clinic focuses on preoperative care, seeing patients who seek pregnancy termination, but when they're referred for complex medical reasons or when they've received a fetal diagnosis and have decided to move forward with dilation and evacuation. But we also see patients for contraceptive care, so birth control care, like having an IUD or implant inserted. And then we also see patients who desire surgical sterilization.
In your role as an associate professor at the University of Michigan, have you authored any clinical guidelines?
I have.
What's a clinical guideline?
A clinical guideline sets the standards for the provision of care for a patient with a certain diagnosis or workup. Typically, it would say, what the workup should be, lab work, studies, and how to take care of a patient with that clinical problem.
What types of clinical guidelines have you personally written for clinicians at the University of Michigan?
I've written the medication abortion clinical guideline, the early pregnancy loss guideline, the pregnancy of unknown location clinical guideline.
Was it pregnancy of an unknown location?
Yes.
That one was tough for me to catch too.
And then labor induction for fetal loss or pregnancy termination.
Do you provide any clinical care outside the University of Michigan?
I do.
Can you tell us about that?
I take call at Chelsea Hospital, which is part of the Trinity Health system. That's home GYN call.
What does that mean, home GYN call?
That means I'm at home and can talk with a physician assistant who has evaluated a patient who's needed a GYN consult in the emergency department. We discuss the reason for presentation and workup and whether I need to come in to operate on that patient.
Do you provide abortion care outside the University of Michigan health system?
I do. I provide care at Planned Parenthood of Michigan.
How often do you do that?
About twice a month.
Did you ever have any affiliation with the Northland Clinic that we heard about earlier today?
As a fellow in family planning, part of my clinical training involved learning dilation and evacuation at Northland Family Planning's clinics.
And we're going to get into in a minute some of the specifics about different types of abortion, but I want to get some information about your practice and how frequently you perform those procedures or abortions, okay?
Yep.
In the course of all the clinical work that you do you perform medication abortions?
I do.
How many medication abortions do you personally provide each year?
About 100 per year.
Do you provide dilation and suction abortions?
I do.
We heard about aspiration abortions from an earlier witness. Are dilation and suction and aspiration the same thing?
Dilation and suction aspiration are equivalent.
Okay. How many dilation and suction abortions do you perform each year?
About 150.
Do you perform dilation and evacuations?
I do.
How many a year?
About 100.
Do you provide care for patients dealing with early pregnancy loss?
I do.
What kind of care would you provide for a patient who's having an early pregnancy loss?
Early pregnancy loss is typically a miscarriage less than 12 weeks. Patients can manage that medically with mifepristone and misoprostol at home, or they can undergo a suction aspiration procedure to empty the pregnancy tissue out of the uterus.
Do those procedures for early pregnancy loss, either the medication version or the procedural version, differ in any way from when those medications are prescribed or that procedure is performed for abortion care?
The medications are identical and the procedure is the same.
For about how many patients do you provide care for early pregnancy loss each year?
About 50.
Are you a member of any professional societies?
I am.
Can you tell us what those are?
The American College of Obstetricians and Gynecologists, or ACOG, the Society of Family Planning.
And what's the Society of Family Planning?
It's a professional organization of researchers and clinical providers who focus on complex family planning. The SFP offers clinical guidelines and standards, education, and continuing medical education.
Why do you belong to these different organizations?
They help with furthering my education, creating a community of providers I can rely on, but also I use their clinical guidelines every day in my practice.
Why do you use them?
Because they set the standards of care.
Have you published anything in the peer-reviewed medical literature?
I have.
You're our first doctor. Can you just explain at a very high level what peer-reviewed published literature, what does that mean?
That means that I have conducted some research or study, and I've submitted this to an academic journal. The journal has a set of reviewers who will review the integrity of my article and the strength and merits of the article and decide whether that article will be published in a journal.
What types of topics have you published on in the peer-reviewed medical literature?
I've published on medical education for medical students on the topic of reproductive justice, and I've published on abortion care.
About how many peer-reviewed published articles do you have?
20.
Congratulations.
Thank you.
Are you also a reviewer for any peer-reviewed journals?
I have been a reviewer.
Can you tell us about some of the journals you've reviewed for?
Yeah, I've reviewed for academic medicine, for women's health issues, reproductive health matters, all reproductive health journals.
Have you ever testified as an expert witness before?
I have not.
You're doing a great job. Are you a little nervous?
I'm fine.
Good. Are you being compensated for the time that you spent on this case and that you're here in court away from your practice testifying for us today?
I am.
How much are you charging an hour?
$200 an hour.
And I would like to ask Dr. Loer, can you agree that all of the opinions that you're going to offer in your testimony today, both when I question you and when any other attorney questions you, are opinions that you hold to a reasonable degree of medical and scientific certainty?
Yes, I can attest to that.
All right, so we're going to start by talking about abortion generally. What's medication abortion?
Medication abortion is typically something that can be offered to someone who's 12 weeks in pregnancy or lower. It involves taking 2 medications, mifepristone, a hormone blocking medication, and misoprostol, a medication that causes the uterus to cramp and contract and push pregnancy tissue out.
I want to take a little detour. We heard when Ms. Chillian was talking about this idea that you can do an ultrasound, but there might be a 2-week gap. And she suggested that we might talk to someone who's a physician who performs that. Are you a physician who performs ultrasounds to date pregnancies?
I am.
Can you explain why the ultrasound might say it might be off by 2 weeks?
Yeah, well, typically we use actually a number of factors to date a pregnancy. One of the most accurate ways to date a pregnancy is through the last menstrual period, or LMP. So typically we're able to compare that LMP estimation with an ultrasound measurements, and usually they're about the same. So that makes us reassured that the pregnancy dating on the ultrasound is accurate.
In your experience, is pregnancy dating by ultrasound for most patients accurate?
Yes, it's very accurate.
What are some of the common complications associated with a medication abortion?
Patients can experience bleeding, infection, retained tissue, and the possible need for a repeat procedure.
In your opinion, despite those complications you just identified for us, is a medication abortion a safe procedure?
It's safe
Why do you say that?
because 99 out of 100 people do not have a complication.
For the 1% of patients who may have a complication from a medication abortion, are those typically serious complications, not serious complications, something else? Can you describe that for us?
They're typically not serious. Serious complications would require hospitalization or further invasive surgery, but a not serious complication would be one where someone has bleeding that needs to be tamponaded or treated with medication.
How does the safety of the medications used in a medication abortion compare to the safety of other commonly used drugs?
Those medications are safer than some other commonly used drugs like aspirin or Tylenol.
Are you familiar with different procedures other than medication abortion, procedural abortion? Are you familiar with that?
I am.
Okay. We talked before, what's a dilation and suction abortion?
A dilation and suction abortion is typically performed under 14 weeks of pregnancy. It involves a pelvic exam, dilating the cervix, and using a straw or suction curette to remove pregnancy tissue. Yes, I will slow down. A dilate.
Usually the one who gets that.
Yeah, you're
Dr. Loer,
fast, so
I'll slow down.
yep. A dilation and suction abortion involves a pelvic exam, dilating the cervix, inserting a straw or suction curette to remove pregnancy tissue.
Is a dilation and suction abortion a surgery?
It's a procedure.
What's the difference between the two?
A procedure can be performed in the office. This can also be performed in an operating room, but surgeries are typically only performed in operating room suites.
Where do you perform dilation and suction abortions typically? Is it in an operating room or in an outpatient setting?
It's both in a clinic room and in the operating room.
What's the recovery like for patients who undergo a dilation and suction abortion?
So typically we observe patients for 15 minutes to half an hour after their procedure, assess that their pain is improving, that their bleeding is stable, and then they're able to go home right after the procedure.
What are some of the common complications associated with a dilation and suction abortion?
They're similar to the medication abortion: bleeding, infection, possibility of retained tissue. And then because it's a procedure, there's the possibility of damage to the cervix or uterus.
Do you have an opinion about whether a dilation and suction abortion is a safe procedure?
It is a safe procedure because 99 out of 100 people do not have a complication.
For the 1 out of 100 person who may have a complication from a dilation and suction abortion, how would you describe the severity of the complications that are most commonly seen?
Those complications typically are not severe, meaning that they can require medications or small interventions and not require hospitalization, blood transfusion, or invasive surgery.
All right, let's move on to dilation and evacuation abortions. Can you describe that for us, please?
Yes. A dilation and evacuation involves a pelvic exam, dilating the cervix, inserting a straw or suction curette to remove tissue, and inserting additional instruments to remove pregnancy tissue from the uterus.
Can a dilation and evacuation procedure be performed outpatient?
It can.
How late in pregnancy can a patient undergo a dilation and evacuation abortion?
We offer that procedure to patients up to 24 weeks in pregnancy.
What are some common complications of a dilation and evacuation abortion?
Common complications include bleeding, infection, damage to the cervix or uterus, the possibility of retained tissue.
In your opinion, is a dilation and evacuation abortion a safe procedure?
I believe that it is safe because 98 out of 100 people do not have a serious complication.
Have you heard dilation and suction and dilation and evacuation abortions referred to as procedural abortions?
I have.
Okay. How does the safety of procedural abortion compare to other outpatient gynecological procedures that a woman might undergo?
They have similar safety to other commonly performed procedures like inserting an IUD, putting a camera in the uterus.
Of the three types of abortions that we just talked about, which one is most commonly performed in the US?
Medication abortion.
Do you have an opinion as to whether there are advantages for patients who are eligible to have a medication abortion of undergoing a medication abortion versus a procedural abortion?
The advantages are typically for the patient and what their preferences are. So patients prefer to start or take the medication in the privacy of their own home or other location that's safe for them. They can have support people with them while they take the medication. They can be in a comfortable place where they can eat and drink as they wish. And they can dictate some of the timing around taking the medications, which can be timing around work, childcare, et cetera.
Do you have any patients in your practice for whom undergoing a pelvic exam or having instruments inserted into their vagina causes problems?
So many patients prefer to avoid an invasive procedure or a pelvic exam. Unfortunately, I have a number of patients who have experienced sexual trauma or sexual abuse. And so just undergoing a pelvic exam itself is re-traumatizing, and their preference is to avoid that whenever possible.
How does the safety of medication abortion and procedural abortion compare to the safety of carrying a pregnancy through childbirth?
Abortion care is safer than continuing a pregnancy through childbirth.
How does the risk of death from abortion compare to the risk of death from childbirth?
Fewer than one person in 100,000 will die during or related to an abortion procedure. In Michigan, 14 people die during childbirth amongst 100,000.
Are there racial or demographic groups for whom the risk of childbirth is even higher than 14 out of 100,000?
Yes. So in the state of Michigan, Black women are 2.8 times more likely to die during childbirth than their white counterparts.
You've told us that it's your opinion that all of these means of obtaining an abortion are safe. Is there any risk that changes over time, whether they're safe or not? Does the risk associated with any type of abortion change as pregnancy progresses?
Well, as the pregnancy progresses, the uterus becomes larger, and so the procedure can have additional risk, or the procedure can change because the gestational age has increased.
When you're caring for a patient, do you have a preference for when the patient should have an abortion related to when the patient makes the decision to have an abortion?
Generally, I recommend that the patient seek care as soon as possible, and that means that that's when they're sure of their decision and able to seek care.
Why do you recommend that?
Because that allows me to offer the lowest risk intervention like medication abortion or dilation and suction aspiration.
In your opinion, is there a medical reason why any patient would need to wait before undergoing a medication or procedural abortion after they've made their decision to have that?
There's no medical reason to wait before having abortion care.
Are there any risks associated with making patients wait?
There are risks in delaying the care, meaning that the pregnancy continues to grow, the gestational age increases, and the patient could need a more extensive procedure.
All right, I'm going to hand you what's already been marked in evidence as Plaintiff's Exhibit 1. Your Honor, do you need another copy? I have one handy if you want.
Sure.
All right, may I? May I approach, Your Honor?
Sure.
The witness, I'm sorry, I should have been clear on that. I could never reach you. All right, Dr. Loder, are you familiar with Exhibit 1?
I am.
How so?
This is the law that we're here to discuss today, dictating the requirements for providing biased materials to patients 24 hours before abortion. Biased materials to patients 24 hours before abortion care.
We're going to get to the substance of the materials. I want to start by focusing on this 24-hour in advance requirement that we've already heard a little bit about. Are patients who carry their pregnancies to term, and you told us you did OB practice until recently?
Yeah, actually, I continue to offer prenatal care. I just don't deliver on labor and delivery anymore.
For your patients who you're providing prenatal care for, or patients whom you've provided obstetrical care for in the past, are they subjected to these same requirements?
No, there's no information that the pregnant patients who are planning to continue their pregnancy must receive 24 hours before having care.
For patients whom you're treating for early pregnancy loss, patients who are having a miscarriage, is there any requirement that you provide them with this or any other information 24 hours before you can treat them?
No, there's no requirement.
And are the procedures, we already covered this, but just to be clear, are the procedures you provide to treat early pregnancy loss the same as the ones that you offer when you're providing abortion care?
Yes, they're the same.
Does the law, in your understanding as an abortion care provider in the state of Michigan, require a specific way that you have to confirm that your patients have looked at this or received this information 24 hours before you can provide an abortion? She's not testifying as a legal expert, Your Honor. She's a abortion care provider in the state of Michigan who has to ensure compliance with these laws. I'm asking her what her understanding is as someone who is literally the person who these laws imposes requirements on.
I'll allow it.
Do you remember my question?
My understanding of this law, by reading it, is that the patient can receive this packet of information in person by picking it up, by registered mail or certified mail, by being faxed the information, or by reading through the state website and printing a form that confirms that they received the information.
Do the patients for whom you're providing abortion care, do lots of them have faxes?
They do not have fax machines.
Does the Complex Family Planning Clinic at Michigan that you're the director of offer the option to send these by certified mail?
We evaluated whether that would be a viable workflow, but because many patients are not home to receive certified mail, we decided not to include that in our workflow.
Okay, so let's talk about the other two options, and I want to start with this pickup. Can you describe what that entails, what the staff at your clinic do in order to provide those materials?
So the materials are printed in a packet, and the patient would have to come to our clinic and stop at the front desk staff. The staff would hand them a packet, but also they use a time date stamp to show what date and time the patient picked it up. And then we keep a sheet that's similar so that we can keep a record of when those materials were handed to the patient.
In your experience treating patients and providing abortion care, for those patients who have to come in 24 hours in advance, does that impose any burdens on them?
Yeah, I don't know how many people have tried to park at University of Michigan, but it's not easy. So there's definitely a burden in having to drive to our clinic, find parking, and walk up to the front desk staff. At the other clinics that I work with, there are clinics throughout the state, but they're not clinics in all parts of the state of Michigan. And so patients may still need to drive hours, take time off of work, arrange childcare just to pick up a packet of information.
And to be clear, when patients come to pick up the do you need some more water? We'll make that
shortly.
happen. Okay. May I, Your Honor?
Yes.
Thank you.
Thank you.
When the patients come pick up that packet, understanding that the law has been enjoined previously, could you provide abortion care that same day, or did they have to come back for a second visit?
Before the law was enjoined, the patient needed to come back at least 24 hours after picking up the packet.
Okay. I'm going to hand you what's already in evidence as Plaintiff's Exhibit 45. Dr. Loder, what's Plaintiff's Exhibit 45?
This is the confirmation page that patients print after they've reviewed all the materials on the website.
And this obviously is not filled out. It's a example form. But is this the same form that, do you actually get this form from your patients?
This is the form that most patients give to me to confirm that they reviewed the state materials.
And the Exhibit 45 has a in the third paragraph from the bottom, where it says by using this form, an abortion cannot be performed before, then there's some brackets that say current date. When you get this from a patient, what's actually in place of that current date?
Yeah, when the website was functioning, it automatically created a date and time by which the patient received the information and the date and time where the patient could receive abortion care 24 hours later.
And we heard earlier about the 2-week expiration date on this form. If you have a patient who comes in and you're more than 2 weeks after this has been stamped and you're past the expiration date of the form, what do you have to do as a provider?
Yeah, this has definitely happened to my patients where they printed the form, made the appointment, but maybe had to reschedule. And by the time they come to their appointment, their form is expired. So then we have to start from scratch. Either we have to provide a new packet and wait 24 hours, or we ask them to reprint it and reschedule to 24 hours from then.
As a physician who provides abortion care in the state of Michigan, do you have an understanding of whether this form has to be physically printed out?
Yes, that is my understanding.
Did you do anything to come to that understanding? What did you do?
Yeah, we considered a workflow where the patient might be able to send this electronically or via our electronic medical record. And I consulted with my Office of General Counsel at University of Michigan.
And did you ever implement that electronic workflow?
We were unable to.
Does the requirement that this be printed, in your experience, impose any burdens on your patients?
It does.
Can you tell us what are burdens that you've observed?
So patients don't have printers or need directions about how to find printers, like going to an office supply store, going to a library, which is in a very private location to be printing something about their healthcare. Sometimes patients actually print the wrong form from the website. There used to be a very similar form on the website that wasn't quite correct. And so it was not valid. And then, patients have lost their form or left it at home when they came to their appointment. So a variety of factors.
If someone were to come in and testify that, well, the way around this is just your clinic could print these forms for your patients. Would you agree with that?
I don't agree with that.
Why not?
Well, coming to the clinic, as we stated before, imposes a barrier to my patients driving long distances, having to take off of work. Also, the law does say the patient needs to review it and print it themselves. So I don't see how.
All speaks for itself.
Documents and evidence, Your Honor. A witness may comment on and discuss her understanding of a document that's already in evidence.
My interpretation of the law.
1 second, Dr. Loer.
Yeah, I would say limit it to your interpretation of the law or your experience with it.
She doesn't have the foundation expertise to testify how legally is. That's not an expert.
She's a physician who is subjected to these rules, and I'm asking what her understanding is as someone who is required by state law to comply with it. Her understanding is certainly relevant as the only abortion provider who's going to be testifying in this case.
I think the testimony is relevant in that context. Thank you.
Thank you, Your Honor. What's your understanding, Dr. Loer?
Can we go back to the point we were discussing?
Yeah, and I don't remember what it was at this point.
My understanding is that the patient must print this form themselves and that the clinic can't print it for them.
Thank you. I appreciate that. Have you personally, well, let me ask you this. Do you personally interact with each patient who you're seeing who comes into the clinic for an abortion procedure or a medication abortion?
Yeah, every patient who's scheduled in my clinic must be seen by a physician. And so I see every patient, no matter if they're proceeding with abortion care that day or not.
In the course of those meetings, have you ever personally had to turn away patients who didn't have the form with them or didn't have the correct form, or it wasn't dated correctly or some other reason?
Yes. Okay. So this informs how I know why they didn't have the form or what the barriers are.
How common is it that you have to turn away patients because of issues with this form back when it was required?
every day.
Is it one patient every day, more than one?
It's at least one, if not more.
Based on your observations from when you personally have to turn patients away, what impact have you observed that to have on patients?
There's a strong negative emotional reaction, frustration, anger. Patients often misunderstand, thinking it's my requirement or my clinic's requirement, and don't understand why the state has made this a requirement or why we have to comply with it.
What happens after you have to turn a patient away because of issues with this form? What happens next?
So often we're able to provide them with the packet, but then we have to reschedule the patient.
What's the time frame typically when patients can be rescheduled if they don't have the form the first time?
It really depends on the patient and what kind of care they were planning to receive, what day of the week it was. So if it's a Friday, they can't come back the next day because our clinic isn't open on Saturday. If they were at the end of 12 weeks in pregnancy, then we need to schedule them for dilation and evacuation. And that may only happen with certain providers, certain days of the week.
Do you in your schedule always have openings the next available day, or does physician scheduling sometimes play a role in how soon patients can come back?
If only. My schedule is very tight and it's very challenging to add on patients when I don't have openings.
In your experience, have you ever seen patients who were unable to return for their rescheduled appointment after they didn't have the right form the first time? Am I making sense?
Yes, I think I know what you're asking. So when patients have rescheduled, they sometimes do not come to that follow-up appointment. And in some cases, the patient has given me information that leads me to understand why. So for example, they traveled from out of state on the first day of their appointment and can't make that trip again.
Aside from the burdens associated with having to print the form, do you have an opinion about any other burdens that this 24-hour advance requirement imposes on patients?
Can you repeat the question?
Sure. So we talked about the fact that some folks just don't have printers and can't physically print it. Does this idea or the requirement that this information has to be completed 24 hours in advance? And we talked about this a little bit, but can you just describe what kind of burdens that 24-hour advance requirement, the delay period, puts on your patients?
Yeah, I mean, so this means that I can't offer abortion care to a patient if they haven't reviewed this information. So they may have come to the clinic prepared to have an abortion, meaning they took off of work, they arranged for the financial cost of the appointment, they brought their support person who also took time off of work, they arranged for childcare, they were fully prepared to come to that appointment, and then need to pivot and rearrange all of those things again for a second appointment because of a delay.
Do you have patients for whom trying to find childcare or being able to afford traveling from where they are to Ann Arbor is more difficult than it is for some of the rest of us?
Definitely.
Have you ever personally experienced patients who are delayed more than 24 hours because of this requirement?
Yes, patients can be rescheduled several days.
In some cases, does that impact the type of abortion care available to your patients?
Yes.
I want to talk a little bit about this 24-hour delay requirement and emergency abortion care. In your opinion, does the 24-hour delay period ever lead to confusion about the provision of emergency abortion care?
Your Honor, objection. This question is a leading question. Very quiet, but suggests yes or no.
So, Your Honor, the standard for leading isn't whether a question suggests a yes or no answer. It's whether a question suggests a specific answer. There are certainly questions that need to be asked where the answer can be yes, no, I don't know. That doesn't make a question leading. Leading is when the question suggests what the answer should be. For example, there's no way to ask Dr. Loer the necessary question of whether she has an opinion on an issue without her saying yes or no. It's not a leading question. Just because a yes or no answer may be appropriate doesn't make a question leading. It's whether it suggests an answer. So I'm not saying to her, this delay leads to confusion, right? That suggests an answer and is leading. Asking her, does it ever cause that, is not a leading question.
I would state, Your Honor, that the reason for direct examination, witnesses testify themselves, and these questions are closer to an attorney testifying for the witness and just enforcing.
I think it's close, but I do agree that it's setting up the stage for your follow-up questions, which are more expansive and will allow Dr. Loder to expound on her opinions. So thank you.
Thank you very much, Your Honor. So Dr. Loder, does this 24-hour delay ever lead to confusion about emergency abortion care?
Yes, there can be confusion about the provision of emergency abortion care because providers are unsure if they need to wait 24 hours to comply with this law. And physicians have consulted with me or transferred patients to my hospital because of a misunderstanding of the law.
If an expert on behalf of the intervening defendants were to testify in this case that the law mandating the 24-hour delay period allows women the opportunity to try and find financial and other support that would allow them to parent, is that something you'd agree with?
I don't agree with that.
Why not?
My patients know what's right for them and have reflected on their circumstances, talked to their support people, reflected on their financial situation already before making an appointment with me or printing this 24-hour consent form. And so the additional 24 hours does not allow them to do that any better than they've already done for themselves.
If an expert for the intervening defendants were to testify in this case that the 24-hour delay period is consistent with generally accepted practice because it's shorter than the typical pre-op practice that other OBGYNs work within, would you agree with that?
I don't agree with that. So
Why not?
for example, I see patients who have been diagnosed with an early pregnancy loss the same day, and I'm able to offer a dilation and suction procedure or medication to treat that pregnancy loss the same day. I'm not able to do that for patients who are seeking abortion care.
If experts on behalf of the intervening defendants were to testify that the 24-hour delay is necessary because abortion is a non-emergent, irreversible intervention with high rates of regret, and so women have to have 24 hours to make a considered choice about having an abortion, would you agree with that?
I don't.
Why not?
Patients have made their decision when they come to my clinic. And if they haven't made their decision, then we discuss how they can take more time to make an informed decision. But almost universally, patients have reflected on the risks of pregnancy and not being pregnant and know that abortion care is the right thing for them.
Does forcing a patient to wait 24 hours before receiving abortion care improve patient decision-making in your experience?
It does not.
Why not?
Patients have already considered their options, talked with trusted people, sometimes their physicians, about their options before seeking care with me.
Do you use the 24-hour waiting period either for abortion care or other care that you provide to screen for additional medical problems?
No, because we don't see the patient during that 24-hour period. So we only see them at their visit, at which time we screen for those medical problems and order tests.
You talked about your role educating medical students, residents, and fellows. Do you have an opinion on whether the 24-hour delay interferes with medical education and training of medical professionals in the state of Michigan?
I do. So
what's that opinion?
When I moved from New York to Michigan, I had to edit the slides that I give to medical students and residents on abortion care. Previously, I didn't have to include any slides about how to comply with laws or waiting periods. But now I have a significant number of teaching tools to teach our medical students and residents how to comply with this law. And it takes up a significant portion of my lecture time.
What would you do at that time if you didn't have to talk about this stuff?
I would love to focus on the clinical care instead of administrative burdens.
As you've heard and we've talked about, and I know you're aware, the 24-hour requirement was enjoined a few months ago. Have you seen a change in patient care since that happened?
Yes, I've seen an improvement in patient care.
Can you tell us what you've seen?
Yeah, so we no longer have to reschedule patients because they haven't printed the wrong form or things are inaccurate. The first patient I saw after the law was enjoined was pregnant with intrauterine device in place. She had already made the decision to not be pregnant. That contraceptive method had just failed. So I was able to see her, evaluate her. And at the end of the visit, she said, "Can I have an abortion today?" And I realized, yes, you can. We don't need to wait 24 hours. You've already told me all the information I need to know to be able to offer you this care.
In your opinion, as a board certified obstetrician and gynecologist who provides abortion care in the state of Michigan, does the 24-hour requirement burden patients' ability to receive abortion care?
It does.
How?
It forces patients to review information that may not be pertinent to them. It delays appointments. It delays their ability to receive care in a timely fashion, and it pushes their gestational age further.
Does the 24-hour delay protect patient health?
No.
Why not?
I mean, it only puts the patient at more risk for being further along in pregnancy than they were when they made the decision to make an appointment.
So the clinical guidelines that we talked about that before that you wrote related to abortion, do those include a 24-hour delay?
There's no medical reason to delay care for 24 hours.
So you didn't put them in the clinical standards?
They are not in my clinical guidelines.
In your opinion, is the 24-hour delay period consistent with accepted clinical standards of practice?
There's no other reproductive health care that I provide that mandates that a patient review state mandated materials and wait 24 hours.
So is that a no?
No.
Is the 24-hour delay consistent with evidence-based medicine in your opinion?
No, I've seen no evidence to suggest that care is improved with this delay.
And in your opinion, does the 24-hour delay infringe on patients' autonomous decision-making?
Yes, I believe it does.
Okay. So we're going to pivot away from the 24-hour delay and talk about the specific materials that patients were required to review 24 hours in advance. But I want to take a little detour before we get there and talk about something called informed consent. Are you familiar with informed consent?
I am.
What's informed consent?
Informed consent is a discussion between a patient and their healthcare provider to discuss the risks, benefits, and alternatives to a treatment or procedure.
And I feel like you just told me this, but are there necessary components to obtaining informed consent?
The necessary components are that you review the risks, benefits, and alternatives with a patient who has the capacity to make decisions for themselves.
Are you familiar with something called the standard of care?
Yes.
And as a doctor, not in the legal sense, what's your physician's understanding of what standard of care means?
It's an outline of counseling, lab tests, and a workup for patients in a variety of clinical situations.
Is there a standard of care for informed consent?
Yes.
Okay. And what is that standard of care?
That is what I just described.
Now, is the information that you provide to patients, you told us it was risks, benefits, and alternatives. Is that information exactly the same for every patient and every procedure?
It's not.
Why not?
So a patient may have already told me in our counseling, I'm here for an abortion. I thought about being pregnant, but I decided not to be pregnant. And that makes it clear to me that they considered the alternative. But are their health history, lab values, ultrasound, give me other information that allows me to counsel a patient specifically about their own risks of complications. And so every patient can be different.
Why can't you just tell every patient exactly the same information about the risks, for example, that might be associated with an abortion? Why isn't that good enough?
Well, my patients are unique and they have individual medical histories and medical problems that can change how I quantify those risks to them.
How about alternatives? Are the alternatives to abortion procedures exactly the same? Or let me strike that and ask you a better question. Do you give every patient the same alternatives when you're providing informed consent for abortion care?
I do not.
Why?
Well, in the example of a patient I cared for recently who was diagnosed with a fetal lethal skeletal anomaly, she was counseled about the risks of this pregnancy and that pregnancy not being able to survive childbirth. So it would be cruel to give that patient information about prenatal care, parenting and adoption when she'd already been counseled that that wasn't a possibility for her.
Setting aside the abortion context, I want to talk about your GYN care. If you have a patient who comes in, for example, for a well woman exam, do you just say, hey, let me talk to you about getting an IUD inserted if that's not something that they raise or they don't raise contraception?
Not typically.
Why not?
Well, typically I would say, do you want to talk about birth control today? And if they said no, I would respect that interest. Now, sometimes I have a patient who comes in and says, I want an IUD, and they tell me, I've tried these other methods, but I know that IUD is best for me. It wouldn't really be appropriate for me to then try to talk them into another method if the IUD was a safe and reasonable option for them.
Is that the same way you approach informed consent when you're providing abortion care?
It is.
Okay, let's take a look at the information that's been marked as Plaintiff's Exhibit 4. Yeah, you're on. Dr. Loder, what's Exhibit 4?
This is the information that's given to patients about amongst the 24-hour materials that reviews abortion, coercion, adoption, parenting, etc.
All right, so I want to go through some subsections of this. Let's take a look at page 6 of Exhibit 4,
Yes,
which
I'm
talks about medication abortion.
looking at page 6.
Okay. Does page 6, the section on medication abortion, also include information on the risks and complications associated with pregnancy and delivery?
It does.
There's another section in here that starts on page 9, which is about a suction curettage type of abortion. Do you perform a DNC?
The curettage refers to the use of a sharp metal rigid curette to scrape the uterus. That's not typically used in abortion procedures anymore, but is used for evaluation of postmenopausal bleeding.
And if you look on page 8, well, that's the title of the section. Then the first sentence says this is called a vacuum aspiration abortion. Is there just like a little lingo issue with how this is described?
Apparently.
Okay. Does page 9, though, this section on aspiration abortion also include on page 9 risks and complications associated with pregnancy and delivery?
It does.
Do both page 6 and page 9 of Exhibit 4 include the statement, most pregnancies are normal. Most women who have good care during pregnancy and delivery will give birth to a baby without problems?
Just a moment. I'm finding the pages. Oh, I'm sorry. I'm looking at the wrong.
No, that's okay. They're the bait.
Very good. Thank you.
Yes, that is.
Multiple page numbers on it.
Yeah, I'm sorry. I'm using the exhibit pages, not the bait stamps.
I apologize
Sorry.
for the confusion. I appreciate the clarification.
Oh, no, please feel free. And I can't see you, so throw something at me.
No, I meant really-
No, please don't.
A light paperclip wouldn't hurt. Maybe not a binder. Dr. Loder, did you see the part that I just read into the record?
I do see that.
Do you agree that many pregnancies are normal and most women who have good care during pregnancy will give birth to a baby without problems?
Some pregnancies are normal, but many pregnancies do have pregnancy-related complications.
Is this information contained in here, in your opinion, harmful? Well, let me ask you this. Are there patients for whom reading this information can be harmful when you're providing abortion care?
Yes, there's definitely psychological harm in reading this information for a patient who has already been diagnosed with a medical comorbidity in pregnancy, or a fetal anomaly in pregnancy, or a patient who has already experienced an unsafe pregnancy before.
What sort of emotional impact have you observed in patients who have fetal abnormalities or any of the other complications you just discussed when they hear about this information?
Yeah, my patients, through our interactions, it's clear they're tearful, upset, frustrated that they had to review information that didn't pertain to them. They feel like they haven't been listened to. And then particularly patients who are quite sick or their pregnancies are quite sick, they feel like this is just kind of like digging the knife in, essentially.
In your opinion, do these counseling materials describe abortion-related risks in greater detail than the risks of pregnancy and delivery?
They do.
How so?
In the risks of pregnancy and delivery, there is a summary of a number of things such as miscarriage, excessive vomiting, bleeding, infection, preeclampsia that aren't quantified for the person reading it. Some of these pregnancy complications are actually quite common. Miscarriage is quite common in pregnancy, and so is nausea and vomiting in pregnancy. And so by listing them just all as one, it makes them seem like they're equivalent or they all have low risk. And those risks are actually greater for someone than the risks of having an abortion, which are quite low. Fewer than 1 person in 100 has a complication with an abortion, although there's a lot of detail about the heavy bleeding and infection and serious complication here.
How does the risk of heavy bleeding, well, I want to be specific so we're clear for the record. Let's take a look at page 6 of Exhibit 4. That's talking about medication abortion. And if you see in the second paragraph under risks associated with medication abortion, it talks about too much bleeding may require blood transfusions, treatment with medication, and/or surgery. Then it goes on to identify other risks like infection. How common is heavy bleeding that requires blood transfusion, treatment with medication, or surgery for patients receiving a medication abortion?
That happens in about 1 person in 100.
Looking at the risks listed for pregnancy, how common is something, what's preeclampsia and eclampsia?
Preeclampsia is when a pregnant person develops high blood pressure and protein in their urine.
How common is that?
That can happen, high blood pressure in pregnancy can happen to 1 in 12 to 1 in 17 pregnant people.
It also references diabetes as a potential pregnancy complication. How common is diabetes during pregnancy or gestational diabetes?
Gestational diabetes occurs in 2 to 10% of pregnancies.
Is there anything, in your opinion, in these materials, Exhibit 4, that makes it clear that some of the risks here happen in double-digit percentage of patients who are pregnant versus the less than 1 in 100 risk for medication abortions?
No, I think it would be very difficult for a patient to know those statistics and be able to compare them in pregnancy versus the risks with the medication abortion.
Are these issues that we identified related to quantifying risks present just in the portion of Exhibit 4 that talks about medication abortion, or is it in the sections that talk about procedural abortion too, in your opinion?
These risks are continued in the section curettage section and the dilation and evacuation section.
Okay, let's take a look at page 16, please, of Exhibit 4, which is the fetal development section.
Yes.
Are you with me? And you'll see on the left side, it looks like there are pictures of fetuses at specific gestational ages that runs from page 16 of Exhibit 4 up through and onto page 22 of Exhibit 4. Do you see that?
I'm familiar with them.
Are these fetal development pictures accurate in your opinion?
In my opinion, there's a problem with them not being to scale and being overly detailed compared to how large they are in real life.
Why is that a problem?
Patients misunderstand, thinking that their pregnancy is more advanced than it actually is. And they frequently ask questions about whether they will see tissue that looks like this, although clearly it's microscopic, being 1 millimeter in size.
And the 1 millimeter, what's shown as an example of what's 1 millimeter on page 16 of Exhibit 4?
Apparently a single poppy seed, but I may need glasses, but I'm having trouble seeing it.
Is that a jar of poppy seeds?
And there is a jar of poppy seeds next to it.
Is a fetus at 4 weeks the same size as a jar of poppy seeds?
No.
Okay. And these comparisons between fetal size and food objects, does that continue through pages 16 all the way to page 22 of Exhibit 4?
Yes, unfortunately.
Are you aware of any evidence-based medical reason to provide patients seeking abortion care with images comparing the size of their fetus to food objects?
At no point during my medical training was I recommended to compare a fetal size to a fruit or vegetable.
What were you recommended to compare it to?
I've always been trained to just give the size of the pregnancy or the uterus in centimeters or inches to my patient, or describe it maybe compared to sometimes maybe a ball or some other inanimate object.
Why wouldn't you use food?
It just doesn't seem appropriate to me to compare an organ to a piece of fruit.
You'll see under week 28, there's a comparison of a fetus to a butternut squash.
I do see that.
Do you have patients who don't know what a butternut squash is?
I do.
How about avocados? Are there cultural issues with some of the food choices that are selected in here as points of comparison beyond whether we should be comparing fetuses to food? I'm sorry. Beyond whether we should, are there issues with cultural awareness of some of the types of food that has been selected beyond whether we should be comparing fetuses to food at all?
Object outside of the scope of the expertise.
In your experience treating patients, have you seen that be an issue?
And my patients don't necessarily know what all these fruits and vegetables look like or what the size is.
In your experience, do either the fetal images on the left part of Exhibit 4 or the food comparisons on the right part cause confusions to patients about the nature of abortion?
They do. Patients think that the tissue that they're going to pass will be larger or more advanced because of the detail in these pictures.
There was some discussion with Ms. Chillian about fetal development charts. Do you recall that?
Yep.
You familiar with fetal development charts?
Mostly only through this packet of information.
When you provide prenatal care, do you give patients prenatal fetal development charts?
We don't.
Why not?
It's never been a standard in our practice.
In your opinion, is it the standard, an accepted clinical standard of practice to provide fetal development charts to pregnant people seeking either prenatal care, miscarriage care, or abortion care?
It has not been a standard to hand a patient a fetal development chart in any point in pregnancy.
If an expert for the intervening defendants was to testify that requiring that abortion patients see these fetal development images and food comparisons is necessary because women don't understand the size of the fetus at different gestational ages, would you agree?
No, I find that my patients do understand how big the parts of their body are. When I treat patients for miscarriage, I do not show them these charts or compare the size of their uterus or their fetal tissue to fruits or vegetables. I describe the amount of bleeding they might expect, the clots that they might experience, the amount of tissue they might see, but I don't use any of these materials here provided.
If an expert for the intervening defendants was to testify that it's necessary to provide these fetal development images and food comparisons to improve patient comprehension, would you agree with that?
I don't.
Have you seen these charts improve patient comprehension when you were required to use them, or patients were required to receive them, I should say?
No, I think patients have only asked more questions that weren't actually relevant to their medical care.
Does whether or not the images in Exhibit 4, the fetal development images and the food comparisons, does whether or not they're accurate affect your opinion about whether or not they're useful and an accepted clinical standard of practice?
No matter what, I don't think it is an accepted standard clinical practice in OBGYN to provide a patient with a fetal development chart.
How about the images in Exhibit 4? If we somehow made them to scale, that was one of the points you made. If these were just changed and made to scale, would that fix what you've identified as your opinion for why these are problematic?
It would not.
Why?
Because does not contribute to any further understanding for my patient about the size of their pregnancy or what they will experience during their abortion.
If an expert for the intervening defendants was to testify that these images are necessary so that a patient can understand the size of the fetus that they may pass when having a medication abortion, would you agree with that?
No, I find that we counsel our patients and describe the size of the tissue that they will pass, and that is perfectly adequate for our patients.
Going to this education and training part, do the materials and the existence of Exhibit 4 interfere with medical education and the training of physicians and other medical professionals in the state of Michigan, in your opinion?
I think having these materials suggests to a medical student that they might be a standard when they are in fact not, or might suggest that the medical student should describe a pregnancy compared to the size of maybe one of 3 olives. I'm not really sure. And so I think it does lead to educational issues because that is not standard in OBGYN. I would like medical students to use accurate measurements and descriptions to describe a pregnancy to their patients.
When you were required to use the materials in Exhibit 4, did that help improve the process of informing your patients about the risks and benefits of abortion?
It did not.
Did it have an impact on, well, let me ask you this. In your practice, is it important as a healthcare provider to develop trust with your patients?
Yes.
Why?
Establishing trust allows us to gather accurate medical and social history from the patient, and also makes for the patient having a more positive procedure and outcome. What we're talking about are involving very private personal areas of someone's life, but also their body. So trust is essential.
When you were required, when patients coming to see you were required to review the materials in Plaintiff's Exhibit 4, did that have any impact on your ability to develop trust with a patient as a healthcare provider?
Patients frequently misunderstood that I was the one requiring the patient to review this information, and they expressed to me that they felt misled or forced to review information that didn't apply to them, and that affects the trust between the patient and the provider.
I want to take a look specifically at page 27 of Exhibit 4, which is the section dealing with pregnancy and infant health education.
Yes.
Are you familiar with this section?
I am.
Did you have patients in your experience for whom this portion of Exhibit 4 was especially detrimental to your relationship?
Yes. So as I described before, a patient who is experiencing a serious medical issue for which they couldn't continue the pregnancy has expressed, the patients like that have expressed to me feeling dissatisfied with having to receive information about pregnancy and infant health that didn't apply to them.
Can I just ask what I missed? Which part of that?
The parenting information, which starts on page 27 of Plaintiff's Exhibit 4.
I apologize.
No, you're fine.
3:30 in the afternoon. I'm trying to keep up. Thank you.
Since this requirement was enjoined last year, have you continued to provide Exhibit 4 to your patients?
I have not.
Why not?
Because I find this exhibit to be biased and unnecessary and provides information to my patients that I don't think helps inform them about their care.
How, if at all, has your relationship with your patients changed since you've stopped giving, since they've had to stop receiving Exhibit 4?
I feel like I'm able to establish trust and really listen to my patients and listen to why they're coming to me for care. And we aren't burdened by discussing these documents or what was in the documents or if they printed a form. And so my relationship with my patients has improved.
Is what's been marked and admitted into evidence as Exhibit 4 the only version of the MDHHS materials that you have used or been required to use, or has this changed over time?
There were edits made to these materials in the last few years, and MDHHS did reach out to providers for feedback.
In your opinion, is there any way that these can be modified, changed, edited, made more accurate, done something to be rewritten to meet the standard of care for informed consent?
No.
Why not?
While these have been edited and improved, they still contain unnecessary information that doesn't apply to a patient. I think what's best is for a patient to discuss their care with their provider and their provider to provide resources to them that are relevant to their situation.
And you said that's what's best. Is it your understanding or is it your opinion that that's actually what's required by the standard of care? To provide patient-specific information rather than general information?
Yes, that is standard of care.
Okay, I want to take a little detour here to ask about some things that Ms. Chillian was asked about. She was asked about some questions about the rate of medication abortions that may require follow-up procedures. Do you recall that part of her testimony?
Yes.
If someone were to offer the opinion or testimony that it's necessary for patients who are getting a medication abortion to learn about the risks and benefits of procedural abortion, because there's this 5% risk that maybe later they'll need to have one of those. Would you agree with that?
I don't agree with that.
Why not?
So if a patient comes in and wants to learn about all of the methods of abortion, they can. But if a patient had chosen a medication abortion and only wanted that based on their personal preference, it's not common then to discuss the risks, benefits of another procedure that they've already told us they don't want.
If a patient comes to you and they have a medication abortion and they're one of the whatever percentage it is, well, let me ask you this, in your practice, is that 5% number accurate, or do you have a different experience?
Yeah, it's about 1% in my practice.
Okay.
Of people who need to have a suction procedure after a medication abortion.
Okay. So in your practice, if I'm one of the 1%, well, I won't use myself because that could be objectionable. If you have a patient who's in the 1% of patients who's getting a medication abortion, and I need to, that patient then needs to have a follow-up suction procedure, do you do another informed consent before you do the suction procedure?
If the patient is advised to have a suction procedure to remove any remaining pregnancy tissue, we review the risks and benefits of that and sign a consent form.
That's a second consent form that you would
Yes.
sign? Okay. There were also some questions of Ms. Chillian about, well, can't you just give patients information over the phone when they call in before they come to their first visit? Do you recall that?
I do.
Is it the clinical standard of practice to provide medical advice or medical care over the phone to someone who's not an established patient of your practice?
No. In the scenario described, it was a clerk or administrative assistant answering the phone and scheduling a patient for their appointment. It wouldn't be appropriate for that person to provide any counseling or medical advice or resources at that time, especially since the patient hadn't been established as a patient in the clinical practice.
Do the folks who you supervise as the director of Michigan's Complex Family Planning Clinic, would you permit them to provide that sort of information over the phone when somebody calls in for the first time?
No, I've advised them not to give medical advice to a patient who is not established in our practice.
In your opinion, as a board certified obstetrician and gynecologist who provides abortion care in the state of Michigan, does the law's information and counseling requirements that we've been talking about burden patients' abilities to receive abortion care?
It does.
Does it protect the health of patients seeking abortion care?
No.
Are the information and counseling requirements consistent with accepted standards of clinical practice?
They are not.
Are the law's information and counseling requirements consistent with evidence-based medicine?
No.
Do the information and counseling requirements infringe on your patient's autonomous? Oh no. Do the law's information and counseling requirements
Counselor,
infringe?
I think you are moving towards leading questions.
Okay.
So try to set a foundation and let the witness answer.
Do you have an opinion on whether the information and counseling requirements infringe on patients' autonomous decision-making?
I do not.
Do you have an opinion?
I do have an opinion.
What's your opinion?
I don't believe they help my patient make an autonomous decision.
I want to turn now to the coercion screening requirements.
Yes.
Your Honor, do you want to keep going? Well, I'm happy to. I just didn't want to know if I was missing the high sign for a break.
No, I think that we can all keep going at least.
Perfect.
How much longer do you think your direct will be?
I'm winding down, Your Honor.
Okay, let's finish direct.
Okay. Are you familiar with the coercion screening requirements?
I am.
Do your patients for whom you provide prenatal care, do you have to do any coercion screening for them? Let me ask you this. Does the law require, or are you aware of any regulations that require you to screen your pregnant patients for coercion?
My interpretation of this law about reproductive coercion is that it only applies to abortion care, and then I'm not required to screen patients during their prenatal care for coercion.
Is it part of your regular practice to screen patients for a variety of things?
It is.
What sort of screening do you do?
So many patients receive social determinants of health screening, making sure that they can pay for their household expenses, groceries, transportation. We screen for safety, intimate partner violence, domestic violence, through a variety of different methods in my clinic.
What are those methods?
So some patients receive a questionnaire on the tablet or on paper that they fill out, and my medical assistant might give that to me before I see the patient. Sometimes my medical assistant may do some screening themselves about safety when they're in a private area. And then I ask my patients a number of open-ended questions when I'm sitting and talking with them about why they're presenting for care. But additionally, there are some physical exam findings that might point me to one direction, like human trafficking or sexual assault, that might not be immediately apparent by those other methods.
Is it important for you to be in the same room with patients when you're screening them for these issues?
Yes.
Why?
So that I can establish trust. I can ask questions in a way that makes sense, or meets my patients at their needs. And we can have a private conversation.
Do you observe what patients say and how they say it when you're screening patients for things?
I do.
Why?
It's important to observe their body language. If they're like looking to the side to a partner for any kind of check-in about whether what they're saying is correct, to make sure they're comfortable, and so they can pick up on any clues that if something might not be right with them.
Do you screen patients for these issues, including coercion, just at U of M? Do you do it at Planned Parenthood? Are there other places you're aware of that do the screening?
It's standard practice to do the screening in OBGYN.
Do you have an opinion on what the most effective way is to screen patient for sensitive issues like coercion?
There's no one most effective way. There are a number of tools that providers can use, but I think it's important for the provider to use what's comfortable to them, but also what they anticipate may be also comfortable for the patient.
What's your understanding of the way that you need to screen for coercion under the law in this case, which is in evidence as Exhibit 2?
My understanding is that there's been guidance provided about some ways to ask about coercion. In general, the interpretation from the clinics that I work in have been to explicitly ask a patient, have you been forced to have an abortion?
Now, I wanted to ask you a super direct question. You told us this is something you screen for anyway.
Mm-hmm.
Doesn't that mean that the law in this case is a good thing and just reinforcing what you already do?
Well, it's unnecessary because it's already standard of care.
And let me hand you Exhibit 2. May I?
Yes, please.
And I've handed you what's been marked as Exhibit 2 already. Do you see under number 1, the requirement that the physician shall orally screen a patient for coercion?
Yes.
Do you have an opinion on whether orally screening every patient for coercion has an impact on patient-provider trust, or can have an impact on patient-provider trust?
Well, having orally screened thousands of patients for coercion over the course of my work, I can tell you it's quite jarring to them to be asked directly, are you being forced to have an abortion today? Especially when the patient has often already told me, this is my choice, this is the right decision for them. There's usually a strong reaction when I have to ask this question.
What do you mean when you say a strong reaction?
Patients are caught off guard, surprised, suspicious, like, why are you asking me this? Especially when I already told you confidentially that this was my decision and I'm sure of it.
Have you had patients for whom having to satisfy the requirements laid out in Exhibit 2 has had a negative impact on their trust in you as a healthcare provider?
I perceive that there's a negative impact on the trust relationship, yes.
I want to talk for 1 second about the poster that you heard about.
Yep.
Did your clinic receive the big poster that Ms. Chillian talked about?
My clinic was also mailed posters, and there was a follow-up phone call to ask if we had posted those posters in our clinic space.
Who mailed it to you?
MDHHS.
Who called you?
I believe it was someone from MDHHS.
Did you put them up? Did you put the poster that MDHHS mailed you and then called you to make sure you put up? Did you guys hang that up?
We had several meetings with the clinic manager and staff to discuss where would be the best place to hang this poster and the locations, and we did hang it, yes.
You already talked about patients that you treat who want to be pregnant but are seeking abortion care because of issues with their own health or fetal abnormalities. Is it your understanding that you're required to screen them for coercion under the law?
Yes.
Can you describe what you've observed when you've had to do that?
Right. And this patient, often has been given some devastating news about their pregnancy or about themselves. They've had to make the difficult decision to end the pregnancy when they wanted to continue it and give birth to a live baby. And then me asking them if they're forced to is quite upsetting, because this wasn't a decision that they made lightly. Often the decision was made through consultation with several healthcare providers and discussions with family and support people. And they've already told me that information. And so this does erode at the trust that I've established with these patients when I have to ask that question.
Do you have an opinion regarding whether the law's coercion screening requirements burden a patient's ability to receive abortion care?
I believe it burdens the patient by creating extra negative emotions related to their care.
Do you have an opinion on whether the screening requirements are consistent with accepted clinical standards of practice as laid out in Exhibit 2?
With other screenings, we aren't mandated to post posters or use a certain language or even have the screening be performed by the physician themselves. So I don't find this to be standard of practice.
In your opinion, are the law's coercion screening requirements consistent with evidence-based medicine as laid out in Exhibit 2?
I've seen no evidence to suggest that.
And do you have an opinion on whether the law's coercion screening requirements infringe on your patient's autonomous decision-making?
I believe they do.
Why?
The patient has already often told me about their decision-making, and my further questioning about their decision-making and whether they're being coerced interferes with the trust and relationship we've established to ensure that they've made the right decision for themselves.
Okay, last section, Dr. Loer, the physician-only requirement. Do you provide any training for advanced practice clinicians like certified nurse midwives, nurse practitioners, or physician's assistants in your work as an associate professor?
Yes, I work very closely with both students in those areas, but also people who have achieved those degrees.
Beyond formal education, do you have an understanding about how advanced practice clinicians become trained and develop the necessary competency skills to provide care?
My understanding is that APCs receive mostly on-the-job training. So they have some training in their formal education, but then mostly when they're in practice, that practice helps to train them in the skills that are necessary for that practice.
Is that similar or different to how you developed clinical skills as a physician?
Yes, I did have to do 4 years of on-the-job training in my residency.
Do you work with APCs in your clinical practice?
I do.
What do the APCs that you work with, what types of care do they provide?
Yeah, APCs are essential to the healthcare teams that I'm a part of. We have nurse practitioners in our clinic providing contraceptive care and well women care. I work with certified nurse midwives who deliver babies, stabilize patients in OB triage. And the PAs I work with at Chelsea Hospital not only evaluate patients in the emergency department, but they also operate with me in the operating room. I've even worked with PAs who run ICUs overnight and PAs who have obtained special training to do robotics, to be a robotic surgery assistant.
How would you describe the importance, if any, of APCs in the clinical care that you provide and that are provided in the settings that you work in?
Their APCs are an essential part of the healthcare team.
Are you aware whether APCs in the state of Michigan are permitted to prescribe and oversee the use of misoprostol and mifepristone in certain circumstances?
Yeah, so our midwives routinely use misoprostol on labor and delivery for labor induction, but they also use mifepristone and misoprostol in the same doses as medication abortion, but to treat early pregnancy loss.
Do you have an opinion on whether APCs can safely provide medication abortions?
I believe that the APCs can safely provide medication abortions.
Why?
Because I've already seen them use the same medications, counsel patients, and do follow-up care for patients with early pregnancy loss, which is no different for patients who are pursuing medication abortion.
Can APCs in the state of Michigan insert an IUD?
They can.
What's an IUD?
It's a birth control device that's placed in the uterus.
How does the insertion of an IUD compare with abortion procedures performed in the first trimester?
Both are invasive procedures involving a pelvic exam and a less than 5-minute procedure.
Do you have an opinion on whether APCs can safely provide first trimester abortions procedurally?
I believe with the appropriate training, credentialing, and supervision, APCs can provide dilation and suction aspiration procedures.
Why do you say that?
Not only have I worked with APCs in New York who had those credentials, but through my professional organizations, I have an understanding of APCs across the country who routinely do so.
In your expert opinion, can trained APCs provide medication and first trimester procedural abortion just as safely as physicians?
Yes.
Do you have an opinion on whether the physician-only law contributes to abortion provider shortages in the state of Michigan?
I believe it does contribute to shortages in the state of Michigan.
Why?
Well, most abortion clinics and abortion providers live in the southern part of Michigan, or specifically southeast Michigan. And so there's a need for providers in northern Michigan and the Upper Peninsula. I know from talking with my patients that they already travel long distances to get to my clinics. But I also know from talking with the health department in the Upper Peninsula that the health department relies on APCs to provide contraceptive care there. And so if they could expand to abortion care, patients would not have to travel long distances like they are now.
Do you have personal knowledge on whether there are APCs in Michigan who would want to train for abortion care if this were not the law?
Yes, APCs in Michigan do want to train to provide abortion care.
How do you know that?
Well, before the injunction, we had sent out a survey about mifepristone and misoprostol and asked APCs if they wanted to provide that care, and they did tell us that they wanted to. But then since the injunction, APCs at Planned Parenthood of Michigan have provided abortion care, and then APCs at University of Michigan have also done so.
If an expert for the intervening defendants were to testify that allowing APCs to provide abortion care creates patient safety issues because APCs aren't sufficiently trained in the recognition and management of abortion complications, would you agree?
I don't agree. So, for example, our midwives recognize labor complications and manage labor complications. They recognize pregnancy loss complications and manage them. I believe they're equally able to manage abortion complications.
Do you have an opinion on whether the physician-only law burdens patients' abilities to access abortion care?
I believe we could expand access to abortion care if we could expand abortion care to APCs.
And do you have patients for whom it would be who would have to travel shorter distances to, if they were able to have, for example, an APC provide abortion care in a more rural area rather than having to come to southeastern Detroit, southeastern Michigan?
Yes, so I already have patients who have trusted APCs who are their primary care providers in rural areas of Michigan or even islands in Michigan. And if they did not have to leave those areas, they could go to their own trusted APC to receive abortion care.
Do you have an opinion on whether the physician-only law protects the health of patients seeking abortion care?
I don't see how it protects the health.
Do you have an opinion on whether the physician-only law is consistent with accepted clinical standards of practice?
Accepted clinical standards of practice have shown that APCs can be involved in all sorts of care when trained. And so I believe this violates that.
In your opinion, is the physician-only law consistent with evidence-based medicine?
You know, I've seen evidence to support APCs in provision of abortion care.
And do you have an opinion on whether the physician-only law infringes on patients' autonomous decision-making?
I believe it does by preventing them from being able to get the care they want in the location and with the provider they want.
Second, Your Honor. No further questions at this time, Your Honor. Thank you.
Okay, thank you very much. I think that we will take a short recess before we reconvene. Can we come back at 4:05? So just short of 15 minutes? You want 15 minutes? Okay, then let's come back at 4:10 then.
Or will be every.
I'm good.
Yeah. I think that's
So she encourages to make alternative.
I'll take it.
All rise.
Be seated. Welcome back. Before we continue with the cross-examination of Dr. Loder, a couple of housekeeping matters. I know that plaintiffs, you had indicated that you had another witness to call today. Realistically, I don't think we're going to be able to get to a third witness.
We understand, Your Honor. We wanted to see because she's from out of town. We will work on rearranging flights and everything and confer with counsel for the intervening defendants and other defendants about the plans for tomorrow, because I think it's probably going to require
An
a
additional
little
day.
additional reshuffling. I don't think we'll have an extra, well, I'm trying to be optimistic, Your Honor, but we were going to have a short day on Tuesday anyway with only
Okay.
2 witnesses. So maybe there's a way that we can still fill up Tuesday, but
Okay.
can we have a little time to confer and then use as much time now?
Okay.
We'll do it overnight.
Sounds good.
Thank you.
I appreciate that. Also, because of the way our court works, the court hours are the hours that we have to keep, which so court will be in session from 9 to 4:30. Most days. We'll go a little longer today, but I don't think that's something that we're going to be like longer days was something that I was anticipating, but is not something that I can actually promise I can keep to you. So that might also necessitate going longer or to another day than we anticipated. But luckily, I have reserved this courtroom for the entire week next week, because I was not as optimistic as all of you. But anything else, any other housekeeping matters that we need to discuss
Just to
before?
clarify, how late can we go tonight?
How late can we go tonight? I would prefer, okay, I would prefer to finish the examination of Dr. Loder today, if everyone is amenable to that. Okay, and Dr. Loder too, as well,
Yep.
since you are, so let's do that. But I do want you to also have your full time in examining her, and I don't want to interrupt the flow of the trial in that way. Okay, anything else? Okay, Dr. Loder, you are still under oath. Mr. Absenson, you may continue.
Very good.
Or begin your cross.
Good afternoon, Dr. Loder. I am hanging in there.
Dr. Loer, I'm sorry to interrupt. You just want to move the mic up.
Yes, thank you.
Thank you. I would like to start with plaintiff's exhibit number 4. You have that in front of you.
Yep.
So you've testified that these documents are biased. Is that correct?
I have.
What do you find biased in these documents?
I think my interpretation of these documents are that because the risks of pregnancy itself are downplayed, while the risks of abortion are overly emphasized, there is a bias in these documents, and they are not presented equally.
And remind me, what was the statistic that you cited for the risks for pregnancy? For death in particular, I think was the...
So risk of maternal mortality is in Michigan, 14 people per 100,000.
And let's go ahead and take a look then at, if you can flip to page 9.
Yes.
About halfway down, it says maternal death occurs approximately 17 times out of every 100,000. That number is actually higher than what you quoted, isn't it?
I see that, yes.
All right. And I'd like to talk about, is it appropriate? Are you familiar with the National Abortion Federation standards and requirements?
I am familiar with them, but do not use them in any of the clinics where I provide care.
Okay. Do any of the clinics where you provide care have informed consent forms?
Yes, they all do.
They all do. Do you have different forms for each kind of abortion procedure?
We do.
Do you list hemorrhage as a possible risk?
For each abortion procedure? Yes.
Do you list infection as a possible risk?
Yes.
You do that because those are in fact possible risks.
Yes.
Do you, well, let's go ahead and take a look at, give me one moment. May I approach the witness? The defendant's exhibit binder. I'm going to ask you to turn to exhibit K1, which has already been admitted.
Yes. K1.
Go ahead and take a moment to look at all of the different risks listed there.
Can you describe what this document is to me?
This document is the medication abortion consent form from Northland Family Clinic.
Thank you.
Did you use consent forms when you were at Northland Clinic?
I actually was not part of the consent process when I provided clinical care at Northland Family Planning.
Okay.
So no.
But you do use consent forms today.
Yep.
And it lists here continuing pregnancy as the potential risk. Is that correct?
I see that, yes.
And it doesn't ascribe in that particular place a percentage.
Hmm.
Is that correct?
No, it's typically part of the discussion that a provider and patient has, that it's that where the particularities to the patient's case are described, and if increased risk is present, that happens in that conversation, not written out in a form like this.
Okay. So that's not always described in every consent form, correct? The percentage for every possible risk, is it?
No, it's not usually.
Okay. But that doesn't make the information inaccurate, does it, medically?
Right, the information in the consent form can be accurate, but it's not tailored to the patient and their own circumstances. So the patient may not realize their full risk of any of these potential complications.
And the law never told you don't tailor information, did it?
No.
And in fact, physicians were supposed to tailor information under the law to the patient. Isn't that correct?
Just objection to vague, what law and what information are we
Yeah.
talking about here?
Sure. In particular, the law that is the cause for this trial, in particular, 333.17015 of the MCL. That didn't prohibit you from tailoring information to your patients, did it?
I don't remember seeing anything specific about tailoring information related to the provider. So if you could point me to that, then that would clarify things for me.
When was the last time you reviewed the law? That's at issue right here, the one that we're just talking about that I cited.
I thought recently, in fact, just half an hour ago, but I don't remember seeing that clause.
Okay. How long did it take you to review the law?
45 minutes?
You have a copy. Do you have a copy of the law?
This is Exhibit 1.
Very good. One moment. All right, if you can go to subsection 6, let me know when you're there.
What page is that on? 2?
I think it's the second page.
Mm-hmm.
And so let's talk about what the law actually requires the physician to do under subsection 6. It requires a physician to provide the patient with the physician's name. Is that correct?
I see that, yes.
You do that when you enter a room with a patient. Isn't
I
that
do
correct?
introduce myself.
Okay. That's not a burden, is it?
That's standard practice.
Very good. And then B says to orally describe in language designed to be understood by the patient, taking into account the patient's age, level of maturity, intellectual capability, the following. You take those things into account, don't you, when you're providing advice?
Yes, as I stated before.
And that's not a burden to the patient, is it?
Being part of the informed consent discussion.
Taking into account the patient's maturity, intellectual capability, and age. Isn't that appropriate?
That is.
And then it says here, you must describe each of the following. Little Roman numeral I, the specific risk, if any, to the patient of the complications that have been associated with the procedure that the patient will undergo, based on the patient's particular medical condition and history as determined by the physician. Isn't that exactly what you're describing that you do?
That is what I do, but I can do it without waiting 24 hours.
I understand, but isn't that the advice that you provide to your patients?
Yes.
And it says here that the specific risks of complication, if any, to the patient if the patient chooses to continue the pregnancy based on the patient's particular medical condition and history as determined by the physician. My question, I suppose the first one is, it's appropriate to talk to patients about alternatives to procedures, isn't it?
Yes, it's very common to talk about alternatives to procedures just when having an initial conversation with the patient. But I may not bring up that alternative again if the patient has already told me they considered it and decided that it wasn't the right thing for them.
And if you were to talk to a patient about continuing pregnancy, would it be appropriate to discuss the risks of of continuing the pregnancy? Would it be appropriate to talk with a patient about the risks associated with continuing pregnancy?
If the patient chooses to continue the pregnancy, I do think it's appropriate to talk about those risks.
All right. So I'd like to talk about the DHHS informed consent material, and that is Exhibit 4. Let's start with medication abortions, and that's on page 6. Are we all on the same page?
Page 6.
So it states here, there are some risks and problems that can occur with medication abortion. Do you see that?
Just under risks associated with medication abortion?
Yes.
Yes.
And it says, talk with your provider about potential risks. It's appropriate to have that conversation, isn't it?
Yes.
It next says, following a medication abortion, vaginal bleeding and uterine cramping will occur in almost all patients. Is that sentence accurate?
That's accurate for a patient who's having a medication abortion.
Very good. In some cases, bleeding can be very heavy. Is that accurate medical information?
It's accurate.
This can feel like heavy cramping. This can feel like a heavy crampy period. I apologize. It's late in the day. I'm struggling to read. Is that medically accurate information?
Well, my patients feel pain in lots of different ways, so not everyone feels the pain as described here.
Do some?
Some do.
Okay. For it to be appropriate medical advice, does it have to pertain exactly to every single thing that that individual patient will experience?
I think the reality of clinical care is that there's a discussion between the provider and the patient. And as the provider, I typically gather history that would allow me to have a more nuanced discussion about this. For example, if the patient told me I have intense period cramps that make me lay down in bed for several days, I'm unlikely to describe their cramping as described here. So when someone undergoes medical care, it really requires some nuance and discussion about the patient's own experiences already.
So the cramping could be actually worse than described here.
Okay.
Is that the majority of cases where the cramping is worse than described here?
No.
Okay. Do you use patient educational materials in your practice?
So it's typical that I would conduct the visit and the patient would decide on a treatment plan, and then I would select patient materials that were specific to that treatment plan and not provide materials that were unnecessary to them.
And are those pre-printed materials, isn't that correct?
We have standard materials that Yes, describe procedures using average descriptions. Yep,
And in fact, you use those average description materials, isn't that correct?
I do.
You may make notes on those documents if there are things that are particular to that patient, isn't that correct?
I do.
Is it the case that someone seeking an abortion should be informed of these risks? And I'd like you to go ahead and continue and read that entire paragraph under risks, the second paragraph. You don't have to read it out loud, but just take a minute and read that entire paragraph. Because my question will be, what information is medically inaccurate in that paragraph?
Mhm. I've reviewed the paragraph.
Excuse me?
I've reviewed the paragraph.
All right. There's
So
nothing medically inaccurate in that paragraph, is there?
some of what's described here may not be accurate to some of my patients because of their own medical history or circumstances.
And
so
that is the case for every single.
I would just ask that the witness be allowed to finish her answer before possibly intervening. That starts asking his next question. She was in the middle of thought.
It was a yes or no question. She's expanding beyond the answer that I asked for and elicited. She can go ahead and finish.
Dr. Loder.
Lost my train of thought.
All right. Isn't it true that any standardized medical form will not apply to every patient in every particularized circumstance?
True. It's why we rely on the conversation between the patient and the provider to have that more detailed description.
And wouldn't it be fair? I think you said that some of this information might not apply to some of your patients in some cases. Is that basically accurate?
That's what I said.
And that could be said of all standardized medical information, isn't it?
It's true.
Now, the second paragraph, I guess the third paragraph under the risks associated with medication abortion, it says it's rare, but some individuals may experience feelings of sadness, guilt, anger, trouble sleeping, or doing daily activities after an abortion. Is that a medically accurate statement?
Yes.
These symptoms can occur after the birth of a baby or after a miscarriage. Is that a medically accurate statement?
It's accurate.
It says here, call your provider, community health authority, local health department, or local human services office for help if you have any of these symptoms that are strong or lasting. Is that medically accurate advice?
That's the advice I would give my patient. Yes.
Going on, and it talks about complications associated with pregnancy and delivery. It states most pregnancies are normal. It states that, right?
Yes. And I've discussed why I don't agree with that statement.
I understand. Not all pregnancies are normal. Is that correct? Not all pregnancies are normal. Is that correct?
Not all pregnancies are normal.
In fact, according to you, 14 in 100,000 pregnancies can result in death in Michigan.
Yes.
That does not make the statement, though, that most pregnancies are normal and accurate, does it?
My criticism was about how the facts were described and underemphasizing the risks in pregnancy, which are greater than the risks in abortion.
And the material bears that out. It says 1 in every 100 abortions, if we go back up to the middle paragraph of risks associated with medication abortions, 1 in every 100,000 abortions, death occurs in less than 1 in out of every 100,000 abortions, correct?
I'm just curious why those numbers aren't used in the pregnancy complication section.
Well, then let's turn over to the next page. It says maternal death occurs 17 times out of every 100,000 births. Doesn't it?
Yes, but the more common complications aren't enumerated.
It does enumerate some of the pregnancy problems that may lead to hospitalization. Do you see at the top of that page, page 7?
I don't know what number can be attributed to some pregnancies.
Okay. But that's the same descriptions that we find in the abortion risks section, isn't it? It doesn't just attribute a percentage or a number. And we looked at the documents that Northland uses, and they don't always attribute a percentage or number. It's not inaccurate to leave off that percentage, is it?
Right.
And the problems described here in the DHHS materials, pregnancy growing outside the uterus, that can be a problem with pregnancy.
Sorry, what are we referring to?
At the top of page 7, some of the pregnancy problems that may lead to hospitalization include a pregnancy growing outside the uterus, tubular pregnancy. That's correct, right?
That's a tubal pregnancy is a pregnancy complication that can happen. Yes, but I wouldn't give that information to a patient after I had confirmed an intrauterine pregnancy. That would be confusing.
Miscarriage is another example. Excessive vomiting during pregnancy. These are all, go ahead and read that paragraph.
Yes, I've read it.
What's that?
I've read it.
Is that medically inaccurate?
It is medically accurate.
I note that in the, well, we'll continue. Let's go ahead and look at the next description. Suction and curettage. Do you see that? It's on page 8.
Yes.
I would like you to go ahead and read the first 4 paragraphs there. You don't have to do it out loud. Let me know when you're done.
I'm ready.
Is there anything medically inaccurate in those first 4 paragraphs?
In general, it's medically accurate. It just may not be specific to my patients.
And that is a critique that could be leveled against any kind of standardized information, isn't it?
True, I just don't usually provide standardized information before seeing a patient and evaluating them.
Okay. Go ahead and take a look at the risks and complications associated with this abortion. Let me know when you're done reading that section.
Yes.
There's nothing medically inaccurate in that section, is there?
There are concerns about some of the data about preterm birth and the number of abortion procedures a person has had and the risk there. And so I think because that data has been questioned, I wouldn't choose to include that in this information.
And specifically, what are you talking about?
The publications have suggested that.
I'm sorry, I meant, what are you talking about on the page?
Yep. The possibility of early delivery, having a low birth weight baby, or a condition in which the cervix opens up too early, increasing the risk of miscarriage in a future pregnancy.
Okay. And you've seen these materials be updated over the years?
Yes.
To take into account changing understandings?
Yep. That data existed before this update.
Okay. Do you know if that data is required to be in there by the law?
My understanding of the law is that MDHHS should review peer-reviewed literature and consider that in creating these, this information. But it's possible they didn't consider that particular study or studies when they developed these materials.
Okay. Were there studies that found that to be the case?
There are studies that have refuted the concern for preterm birth with abortion, with having an abortion, yes.
But this is something that, all right. Let's go ahead and look. I won't have you go through the pregnancy and delivery stuff again, because that's the same as under the previous one, previous procedure. But let's go through the second trimester labor induction abortion. Let's start with the description there. Can you read through that and tell me if there's anything you believe that is medically inaccurate?
I'd say this description isn't up to date with the current standards for labor induction.
All right. And what do you say is out of date?
So with the use of mifepristone for second trimester labor induction, we've been able to shorten the labor induction time. Most patients don't have to stay 3 days and usually only stay 1 day in the hospital. Additionally, we have not had to use Pitocin through the IV to induce labor because the standard protocols put forth by Society of Family Planning and the clinical guideline that I helped create use mifepristone and misoprostol only.
Okay, so specifically it says 2 or 3 days. And is that what you're saying is not accurate?
Right, I'm saying that that length of stay is shorter in current practice.
But it still could be 2 or 3 days.
As I don't have the ability to predict if someone will stay longer.
Okay.
But the average is 1 or 2 days.
And it says down here in the last paragraph, some women stay for a few hours, other women stay for 1 or 2 days. Isn't that exactly what you said?
People stay 1 or 2 days in total for the whole delivery and after delivery care. I think this is specific to the post-delivery care.
Okay. And it does say 2 to 3 days, but the length of stay can vary, right?
Yes, I'm just saying this isn't according to the materials that we would have created for second trimester labor
And do you
induction.
think that that is biased?
I think it's inaccurate.
Okay. Go ahead and take a look at the risks and complications section for second trimester labor induction abortions.
Going from page 10 to 11.
Yes.
Yes.
Is there anything inaccurate in that section?
I think, as I discussed with the previous sections, the data around preterm delivery is refuted by current literature.
Okay. Anything else?
No.
Okay. Let's turn to dilation and evacuation. I'm sorry, I'm struggling to read again. Go ahead and read through the description of the procedure there.
Yes,
Is there anything medically inaccurate?
yes. The description of pain with the dilation and evacuation seems to actually minimize the pain and the pain relief options that we typically offer patients with dilation and evacuation.
So it minimizes the pain. That's biased in favor of the procedure, wouldn't it be?
I think it just, if it's inaccurate, then patients come confused and not understanding what they are about to have. So there needs to be clarification.
Which is why you counsel every patient, isn't it?
That's one reason.
Go ahead and look at the risks and the complications.
I think I have the same critique as the prior sections.
Okay.
But nothing different.
So just the one area where you say that it's been refuted.
Mhm.
What study has refuted it?
I'm not prepared to cite that reference at this time.
What is biased about the information that appears in the text of what you have just reviewed?
Excuse me. I believe there's a bias when some statistics are minimized over others, specifically the comparison of risks of pregnancy compared to the risks of abortion. There's a bias in selection of the studies to describe the risk of preterm birth. And there are inaccuracies in describing labor induction and the risk of preterm birth after abortion.
All right. Turn to page 7.
Back to page 7.
Yes.
Yes.
Do you see the footnote there, IV, little Roman numerals?
Mm-hmm.
The source was the CDC pregnancy mortality surveillance system. That's a reliable source, isn't it?
I believe that's the source specifically for the maternal mortality data. And so far it has been reliable.
And in fact, the text above in Roman numeral III, management of unintended and abnormal pregnancy. That's a textbook you have on your desk, isn't it?
It's true. I don't see a source for the risks related to pregnancy-related problems.
Okay.
It seems like one must have been consulted to create these materials, but it wasn't cited.
But you don't know what source was cited or
Well,
reviewed.
I don't. I only know what is cited here, and it's common to cite all the sources that contribute to information like this.
Is that what you do on your informed consent forms?
Our informed consent forms don't typically cite materials like that, no.
Okay.
But a note that I write may cite materials like that if I'm counseling a patient.
Do you, never mind. Providing a patient with medically accurate information is not a burden to that patient, is it?
I don't agree with that statement.
It's a burden to provide medically accurate information to a patient?
I think it's a burden to provide medically accurate information that is not relevant to the patient. For example, if I provided you with information about female reproductive health, that would seem unnecessary.
Are you the one who controls what information is necessary for your patient?
Through discussions with my patient, I'm able to ascertain what information might be relevant to them. And if a patient has already told me that they've made a decision and don't want a certain procedure, it is not standard to offer them additional information about the procedure they've decided is not wanted by them.
All right. Would you agree that genuine informed consent must be obtained before an abortion is performed?
I do agree.
This requires both knowledge, comprehension, and voluntariness. Isn't that correct?
Yes.
You would agree that it is important for a health professional to ensure accurate information is provided about the abortion process, wouldn't you?
I agree. The patients need accurate information. It is not always written.
But writing down the information isn't a violation of any standard of care, is it?
I'm just telling you what the care is like. Often this comes about through a conversation with a healthcare provider and is not written down in a material.
Now, providers can also have their own biases, isn't that correct?
Yes.
In fact, people and doctors can have unconscious biases, can they not?
True.
And so that advice that a doctor provides could be biased in
It
that one-on-one individual situation, isn't it? That true?
could be biased.
Is it helpful for patients to have information about abortion before they have the procedure?
Some patients find it helpful. However, they could have accessed information about a procedure that is not available to them or relevant to them because of a variety of medical factors.
We've talked about medication abortion before. Are there cases rather, where some kind of abortion procedure or surgical intervention might be required after a medication abortion?
Are you referring to when a patient has a complication and has retained tissue and needs a further procedure?
Yes.
Yes.
What are those procedures?
The suction aspiration procedure typically.
Could there be a requirement for other procedures? Go ahead, sorry.
Not usually.
Okay. Go ahead and turn to J2.
The Mifeprix medication guide.
Go to page.
Mifeprix medication guide, which is mifepristone. Which page?
Page 3 of 7. On the left-hand side, down at the bottom, the last line says 1 out of every 100 women, in about 1 out of every 100 women, bleeding can occur so heavy that it requires a surgical procedure, surgical aspiration, or DNC. Those are surgical procedures, is that correct?
Well, we treat them as office procedures also.
Okay. Those are procedures that are listed in the state material, is that correct?
They are.
And so An individual undergoing a medication abortion may subsequently need a surgical aspiration or a DNC. Isn't that correct?
Yes.
And that's for 1 in 100 patients.
Yes.
Isn't it important for them, that 1 in 100 patients, to know what they might have to go through to complete the abortion before they take the medication?
So when we discuss medication abortion, we discuss the risks, including the potential need for aspiration. And I may discuss what that would involve, but it would be excessive information to provide a patient, to every patient, especially because only 1 out of 100 might need that procedure.
So you shouldn't tell a patient about what might be involved in an aspiration or a DNC because it's only 1 in 100. Is that what you're telling me?
That's not how I described it. I said it's not our standard to review every single procedure for a patient undergoing a medication abortion. Patients may ask, well, what would that suction procedure be like? And I wouldn't withhold that information. I would, of course, review that with them.
So you would only tell them if they asked.
I tell them when they ask, or sometimes if there's an increased risk
And
of
they would have
needing
to
it.
know to ask, wouldn't they?
Well, no, I've told them that they might need the procedure.
For the person who does end up needing a DNC, wouldn't it be helpful for that patient to know what's involved in it before they take the medication? It wouldn't be a burden on that patient, would it?
Patient might consider it a burden.
For the person who gets the DNC eventually?
So, patients are invested in having short, efficient procedures. And if we spend a significant amount of time going over unlikely extra procedures, the patient might perceive that to be unnecessary information or a burden, considering that they're more likely not to need that procedure. If the patient has a complication, we of course review the risks, benefits, and alternatives to needing or having that suction procedure and restart the informed consent process and sign a consent form that's relevant to the treatment that they need.
So is it your position then that if the risk is 1 in 100, then it doesn't need to be explained to the patient?
I believe I said I may explain it in certain circumstances, or if the patient asks about it, but they don't necessarily, the patient may not need detailed information or informed consent at the time of the medication abortion.
You don't know who that 1% is going to be.
Don't.
And in fact, the percentage of individuals who experience death from pregnancy or abortion is significantly less than 1%, isn't it?
Yes.
But you still inform patients that those are risks, don't you? That death is a risk.
Yes.
And that's not inappropriate.
But then I don't in detail describe what that death would be like.
During your deposition, you told me that if a patient, well, I asked the question, I suppose.
Honor, I would just object, to reading her deposition testimony, it's hearsay and not evidence. If counsel for the intervening defendant wants to ask a question and she gives an answer that's inconsistent, he can certainly impeach with it. But him simply testifying to what she testified to in another proceeding is not an appropriate way now to witness the question.
Your Honor, I can just ask the question that I asked you at the deposition.
I think you should do that.
If a patient were to call your office in a non-emergency situation, how quickly could they have an abortion scheduled?
It depends on the openings in our office.
You told me at your deposition,
I would object to her. If he wants to impeach her, then she needs to get a copy of the testimony. Me do too. I need to be able to object if necessary on whether it's proper impeachment. This isn't the way you impeach a witness.
I'm not trying to impeach the witness. There was a statement that she gave during her deposition. If she needs her recollection refreshed, I'm not trying to impeach her. I'm not implying that there's any inconsistency.
Why don't you refresh her recollection and then continue with your line of questioning?
Very good. Give me one moment. Page 15 of your deposition transcript. Pause a moment. You got it. Go ahead and
Here?
Yeah. On page 15.
But just to check, this isn't refreshing her recollection. Dr. Loer testified as to how quickly, she didn't say she didn't remember. She didn't say she doesn't know. She offered her testimony from her oath as to how quickly patients can come in. She didn't need her recollection. So the way you could appropriately use a deposition transcript would be to teach her, consistent, or you can refresh recollection for a witness who says they don't recall. Neither of those happened. There's nothing here that's admissible under the rules of evidence, the way counsel is trying to use this.
Let me go.
Why don't you just ask the question that you asked in the deposition and then see if there's anything that needs to be refreshed or
Very good.
impeached at that point?
So on November 20th, 2024, you had your deposition taken, is that correct?
Yes, that's correct.
You were under oath at that deposition.
Yep.
You were asked at that time, if a patient were to call your office right now in a non-emergency situation, how quickly could they have an abortion scheduled? Is that correct?
I would, again, Your Honor, I would object. What she was asked at her deposition is an evidence. This just isn't the way that you use prior testimony under the rules of evidence.
Didn't you just ask that question of her directly a
I
few minutes
did.
ago?
What was your answer to that question?
The soonest available.
When is the soonest available?
It varies. Since I gave my deposition, we changed some of our practices around scheduling, especially medication abortion. So the soonest available has changed.
Okay. In November, what was the soonest available?
So the soonest available for dilation and evacuation was 2 to 3 weeks.
Okay. Let's talk about your scheduling procedures. You indicated previously that you had approximately, when this law was not enjoined, approximately one patient every day turned away because of the 24-hour waiting period. Is that correct?
Yes, I believe I said that earlier.
And you did not send then patients emailed links to the state mandated materials, did you?
Send them links when?
Before their appointment to visit the material.
Would
on
you
the
like me
website?
to describe our scheduling process?
No, I just asked you a question.
No, we did not send links to the state website.
The University of Michigan Healthcare does have an electronic patient management system, doesn't it?
Mhm.
And you're able to communicate electronically with patients, aren't you?
Yes.
And you can send patients information electronically.
Yep.
And that is a HIPAA compliant system, isn't it?
Yes.
And you were turning away one patient a day and you didn't change your procedures, did you?
So the care that I'm referring to is not only the care that I provide at University of Michigan, it's expansive to the care that I provide at Planned Parenthood of Michigan, where the procedures are different. Mm-hmm. That care that I described was not just at University of Michigan, but also applied to the care that I provide at Planned Parenthood of Michigan. Planned Parenthood of Michigan.
You're not at Planned Parenthood of Michigan every day, are you?
I'm not.
You did not review medical records to arrive at that one a day turnaway statistic of patients at Planned Parenthood, did you?
To make that estimation, I used my.
It really was a yes or no question.
Oh. Can you ask it again?
You didn't review patient materials at Planned Parenthood to determine how many patients were turned away, patient medical records to determine who was turned away, did you?
I did not.
And you're not there every day.
No.
You don't have any studies that were done to determine that there was in fact one patient turned away every day.
No, I'm using my expertise.
Expertise on something that you haven't studied, isn't that true?
On my clinical experience.
Both Planned Parenthood and the Michigan health system have printers, don't they?
They do.
And there's nothing in the law that requires the patient themselves to print out the document, is there?
My understanding is that the website directs the patient to print out the form themselves and bring it to their appointment.
There's not just one way to print a document, is there?
I don't think I understand your question.
Have you ever sent a document to someone and asked them to print it for you?
Yes, there are issues with doing that with this website, however.
And I mean, I sent a bunch of documents to my secretary and asked her to print them for me.
Hmm?
Have you done something like that?
Yes, I've done that with my administrative assistant also.
Go ahead and look at Exhibit 1.
Which section?
Subsection 2J. Says there, provide the patient with a physical copy means confirming that the patient accessed the internet website described in subsection 5 and received a printed valid confirmation form from the website. It doesn't say who printed that form, does it?
It doesn't. Like,
Physicians undergo training about how to talk sensitively to patients, don't you?
yes,
And you utilize this training, isn't that correct?
I do.
Go ahead and take a look at Exhibit 2.
The coercion screening.
Mhm. It talks there in the middle of the paragraph about oral screening. It doesn't prescribe exactly what words you have to use, does it?
It doesn't.
In fact, it would assume, at least I would assume, that you would use that training to do the oral coercion screening in a sensitive manner. Would that be a wrong assumption?
I think it's further confused by the training tools that were provided to do that screening.
Training tools are not mandatory under the statute, are they?
But the provision of them suggests that one should use them.
But Northland doesn't.
I can't attest to that.
You have a fetal development chart in your office, isn't that true?
Not to my knowledge.
Do you have a fetal development chart that you could provide patients if they asked for it?
If a patient asked for it, I would have to seek out a source and to provide them with it.
Just a moment, Your Honor. Let me ask the question this way. Do you have a fetal development chart that you could provide if someone asked for one?
If someone asked for one, I would have to seek one out to provide one to my patient, and I would do that for them.
That's not what you said at your deposition, is it?
Again, I would object. If you want to know what she said, her deposition, you have a recollection, you impeach, she needs to have her deposition in front of her. As opposed like a policy.
I'm going to impeach her at this point. Page 57.
Where am I looking?
Starting at line 8.
Of which?
It's her deposition transcript, page 57. Lines 8 through 19.
It's not proper impeachment, it's not inconsistent with what she said.
I'm going to allow him to develop his questions and see if there is impeachment there or not.
You were asked about fetal development charts at your deposition,
Mhm.
correct? And you testified that you do not have a routine chart that you hand to all patients. Is that correct?
That's correct.
Your Honor, that's not inconsistent with what she said, the way that you impeach it.
And-
And so I would object to counsel who's reading this testimony into the record, unless he can establish inconsistency for impeachment purposes. That's exactly the same thing she testified to under oath to Your Honor.
You were then asked, do you have one that you could provide to someone if they asked for, and you said yes, didn't you?
Again, Your Honor, that's not inconsistent with what she said here. She said she'd go out and get one to give me, not proper impeachment.
She testified that she had one that she could provide.
So
No,
can you explain to me why you think that that's an inconsistent statement with what she testified to here, which was that she may not have one readily available, but that she could go procure one and get that for her patient?
She was asked, do you have one in her office?
That's not what the question says, Your Honor. This is why I think having the transcripts, and I would ask that if we're going to do this with witnesses tomorrow, just like we provided everything to counsel, that he have one for us and for Your Honor. Because the question she was asked was, do you have one that you could provide if someone asked for one? There's no in your office, do you already have it available? Her answer was yes, which is the same thing she said here.
I agree with that characterization of both the deposition as well as her testimony today.
All right.
Is there anything further you want to ask her from there, or?
Not at this time. Going back to Exhibit 4.
yes,
We haven't talked about all of the information there. There's a fetal development chart, though, that is provided. Is that correct?
yes, there is.
And if I'm not mistaken, it's your opinion that this is not necessary then for a patient. Is that correct?
It's my opinion that it's overly detailed and not helpful for most patients.
But when you say most patients, that means that for some patients, it might be helpful. Isn't that correct?
I also stated that no patient had ever asked me for one, so almost all.
And the pregnancy and infant related health education packet, or excuse me, pregnancy and infant health education packet. Did you review that?
I have reviewed it.
And is it your opinion that that packet of information is unnecessary?
It's not necessary for all patients.
And is there any information in there that you believe is medically inaccurate.
I think it's inaccurate to give a patient pregnancy-related information if their pregnancy won't continue or cannot continue.
Your Honor, do you mind if we take just a few minute break so I can collect my thoughts? And think I'm getting pretty close to wrapping up, but I'd just like a few minutes.
Would 10 minutes suffice?
That
Or
would
do
be
you take
great.
10, 15 minutes? Okay.
Thank you.
Recess. Thank you.
Oh, it's just like right here.
Thank you very much. You may be seated. Okay, are we ready to proceed? Okay, Dr. Loder, you are still under oath.
Yes.
So if a patient wanted to view adoption information or parenting information or a fetal development chart, they should have that right. Isn't that correct?
I didn't hear your whole sentence. Can you repeat that? Sorry.
Sure. If a
Dr. Loder,
patient,
can you make sure that the mic
Yep.
is as close to you as possible? Thank you.
if a patient wanted to view a fetal development chart, they should have the right to view that fetal development chart. Isn't that correct?
If a patient asked me for additional materials, I would give them to them if I had them available.
If a patient wanted information about parenting or adoption, they should be provided that information. Isn't that true?
I don't think I'm at liberty to say what someone should or should not be provided with legally, but as a healthcare provider, if a patient wants information, then I provide them with that information.
Okay. So the voluntary provision of this information you're not opposed to then?
And what do you mean by that?
Someone wants the material, then they should have access to the material, correct?
Correct.
And there is no ethical problem with providing patients the option to view medically accurate information. Is there an ethical problem with that?
I think there is a question. So for example, if the patient told me they didn't want that information, it would be unethical for me to force that information on them.
Let's test that a little bit because you provide informed consent forms, correct?
Mhm.
But if a patient said, I don't want to know the risks, I just want the procedure, you still have an ethical obligation to provide them the risks, don't you?
Yes, but I thought we were talking about patient education materials before.
There is some baseline, though, of information that must be provided to every patient before they undergo a procedure. Isn't that correct?
Through the principle of informed consent.
And you don't know when a patient comes in everything that they have reviewed in making their decision, do you?
No.
Is the offering of someone information about adoption just in and of itself, someone who's potentially seeking an abortion, just informing them that if they want information about adoption or parenting or a fetal development chart, that they could have access to that? Is that problematic? Is that a burden on that person?
It could be if they told me they considered adoption and decided it wasn't an option for them. It would feel like a burden if I then further investigated that and offered them information.
But you don't know if that patient in particular, any random patient coming in, you don't know necessarily if they've considered any of those alternatives.
Which is why I ask open-ended questions to find out how they made their decision.
Now, you indicated that APCs can provide abortions. You recall that?
Yep.
And specifically, you were speaking about medication abortions. Is that correct?
I believe I spoke about both medication abortion and dilation and aspiration.
Okay. How about surgical abortions?
Procedural abortions?
Specifically, dilation and evacuation.
What's the question?
How about in the second trimester?
Mhm.
Have you seen APCs provide abortions in the second trimester?
I have worked with APCs who have inserted dilators, which are the first part of the dilation and evacuation, but I have not yet worked with an APC who has performed a dilation and evacuation.
And you indicated that allowing APCs to practice in Michigan could expand access to abortion in the state. Is that your testimony?
Yes.
But you're not relying on any studies for that, are you?
I'm relying on discussions that I've had with providers across the state of Michigan as a healthcare provider here.
Can all APCs operate independently?
My understanding, I'm not an expert on the rules and regulations around APCs, but my understanding is that they have to have a physician to consult with about any clinical questions, et cetera.
And the physician, if the APC was providing abortion, would also need experience providing abortion. Isn't that correct?
Yes.
And so these APCs would also need a physician in those rural areas, based on your testimony. Isn't that correct?
My understanding is that supervision doesn't need to necessarily be in-person supervision.
Okay. And so you don't have any particular studies that would show that allowing APCs to practice in Michigan would expand access to abortion, do you?
Objection, Your Honor, this is asked and answered. Just trying to use the make sure it said yes.
I think you did ask a question a few minutes ago.
All right.
She answered based on her clinical experience and conversations with practitioners.
And I guess my last question then is just that you are a member of the Society of Family Planning, is that correct?
Yep.
And that is a society that does advocate for access to abortion, is that correct?
Yes.
Generally, it would be known as a pro-choice organization, is that correct?
Yes.
Okay, I have no further questions, Your Honor.
Okay, thank you very much. Redirect?
I don't know if any of the other.
Oh, I'm sorry.
I have a few questions, Your Honor, if you want to.
Sure, please put your
Be
appearance
very
again.
brief. Rebecca Abuna, Aboona,
And the defendant that you're representing?
the Attorney General.
Okay, thank you.
Good afternoon, Dr. Loder. As I said, I'm Rebecca Abuna. I represent the Attorney General in this case.
Nice to meet you.
You spoke earlier about reproductive coercion, and I just wanted to drill down on that a little bit. So reproductive coercion generally, is it fair to say, is something that you're on the lookout for in your practice?
Yep.
And reproductive coercion can take many forms, right?
Yes, people can be coerced to be pregnant, to use or not use birth control, or to have an abortion.
And once pregnant, patients can also be coerced to carry their pregnancy to term.
Definitely.
And you've cared for patients who wish to carry their pregnancy to term, correct?
Yes.
And you've ensured that they've made that decision for themselves.
Yes.
In other words, that they were not coerced into doing so.
Correct.
But there's no statute like the challenge coercion screening provision in this case that required you to do so, right?
Can you restate?
There's no statutory mandate to screen for coercion for women who wish to carry their pregnancy to term, correct?
Correct.
It's just based on the standard of care.
Correct.
Now, some patients need to undergo interventions to assist them in carrying their pregnancies to term, correct?
I'm sorry.
Too fast. Some patients need to undergo interventions to assist them in carrying their pregnancies to term, correct?
Yes, invasive interventions.
That can include taking progesterone
Yes.
or placement of a cervical stitch to keep the cervix closed.
Yes.
And providers obtain informed consent for these interventions, correct?
Correct.
And when obtaining informed consent for these interventions, a provider would ensure that the patient's decision is their own
Yes.
and not the product of coercion.
Yes.
But again, this is not done because of a statutory mandate like the coercion screening provision in this case.
Correct. It's just standard of care.
I have nothing further.
Anybody else for the remaining defendants? Okay, thank you. Redirect.
Thanks, Your Honor. Dr. Loder, I'll try to be brief. Do you remember at the beginning of when you were asked some questions, you were asked about whether the challenged laws prohibit tailoring, and specifically you looked at Exhibit 1, subsection 6. It's page 2 of Exhibit 1. And you talked about things like you gave patients your name. Do you remember those questions?
Yes.
Okay. What's your understanding about when the law was enforced that required you to provide Plaintiff's Exhibit 4 about whether you could give some portions, none of the portions, or you had to make sure that your patients had had access to every portion of Exhibit 4?
My understanding was that patients needed all of the information in Exhibit 4.
So was there any ability to tailor the information in Exhibit 4 to a patient's specific circumstances?
Not to comply, not if you're in compliance with the law.
I want to take a quick look at Exhibit 2, the coercion screening. Do you have that in front of you?
I do.
Can you take a look at subsection 1? It's the 1, 2, 3, 4th line down. It states that the person doing the screening shall orally screen the patient for coercion to abort using the screening tools developed by the department. Do you see that?
I see that.
And you were asked if the law required using the screening tools prepared by DHHS. Based on your reading of that language, is it your understanding that you do actually have to use those screening tools?
This explains why I was trained to use that language originally when I started to provide care in Michigan.
You were asked a lot of questions about whether Exhibit 4 had information that was medically accurate or inaccurate. Do you recall that?
I do.
You told us before your opinions about whether the laws requiring the provision of the information in Exhibit 4 burdened patients, protected their health, met accepted clinical standards, were evidence-based, or infringed on decision-making. Did any of the opinions that you offered to the court on your direct testimony depend on whether the information in Exhibit 4 was medically accurate or medically inaccurate?
So being forced to provide information that's not relevant to the patient is the main concern, irrelevant of what's actually in the information.
And is it the same true for whether it's your opinion that it's biased or not? Is the bias aspect of this driving your opinion, or is it having to provide information that may not be relevant to specific patients or something else?
I don't like that it's biased, but more so, I don't like having to provide all of the resources to patients when things don't pertain to them.
When you have patients come in for prenatal care, are you required by law to give them information, all the information contained in Exhibit 4, or even any information at all about abortion if they don't come in seeking an abortion?
No, so if the patient told me they wanted to continue the pregnancy, I wouldn't ask them, do you want information about abortion?
You were asked some questions when you were talking about Exhibit 4 and the Mifeprex medication guide about DNCs. I just want to be really clear. Do you perform DNCs?
I do not perform DNCs for abortion. I use dilation and suction aspiration procedures to empty the uterus in the first trimester.
Is a DNC, are those procedures the current standard of care today for providing first trimester procedural abortions?
They are not.
Why haven't you worked with an APC who is able to perform DNEs?
They haven't been able to in the state, and we haven't had the opportunity to provide that training to do so.
You were asked some questions about, isn't there a set of baseline information that has to be provided to patients? Do you remember that?
Yes.
Can you tell us, is that baseline information exactly the same for every patient, in your opinion?
It is not exactly the same for every patient.
Why not?
Patients are unique and have special circumstances.
You were asked some questions about standardized medical information and whether standardized medical information may necessarily contain information that's not relevant to every patient. Do you remember that? Are you aware of any laws that apply to you as an obstetrician gynecologist that require you to provide standardized medical information to your patients other than the laws at issue here?
There are some. So the start talking points require that before I provide an opioid prescription to a patient, I explain that the medication could be could cause addiction or abuse, and describe the ways to dispose of the medication. That's based on a law, state law in Michigan.
Any other procedures that you perform that require the provision of standardized medical information?
No.
Do you have to provide standardized medical information to women who choose to continue their pregnancies?
No.
Why don't you send links to DHHS's website to patients?
We reviewed the possibility of sending information back and forth with the patient through our EMR, and I consulted our Office of General Counsel to inquire about that possibility. And our current practice is based on that conversation that I had with the Office of General Counsel.
At any point since these laws came out, have you, following the due diligence that you did, decided to just send links to the DHHS website to patients? Like, is it something you don't just do now? Did you do it at one point, or have you ever done it?
I think members of our team have sent links through the EMR to the website before, but we have never received that final page from the patient because that was deemed not to be possible.
That's all that I have, Your Honor. Thank you very much. And thank you to your staff for allowing us to finish Dr. Loder's testimony. I know we're well past everyone's bedtime, and just thank you for the indulgence.
Thank you. Recross.
May I approach the witness?
Sure.
Have you seen that document before?
The screening tool for coercion? Yes.
And go ahead and turn to page 2 of 17 in the bottom right-hand corner. On that page, do you see ask screening questions?
I don't know what you're referring to. Oh, sorry. Yes, that heading. Yes.
Ask screening questions. You see that heading? It says that there are suggested questions there at the end of that paragraph, and then followed by questions, correct?
It says these may be incorporated into the general discussion about the reasons for visit and health screening.
Are we on the same page?
I don't know. Ask the screening questions.
Bottom of that paragraph, it says suggested screening questions, colon. Do you see that?
Yep.
So those following questions are suggested. Is that correct?
That's what this page would suggest.
I have no further questions. Thank you, Your Honor.
Okay, thank you very much. Thank you, Dr. Loder. You may be excused. Before we adjourn for the day, I want to thank everybody for our first day of trial and how it's been conducted. I especially want to thank Miss Kyra, is that how we, Kyla? Is that how we, Tyla? Cindy, thank you so much for stepping in midday to help us with court reporting services. We really appreciate you staying late and helping us. Also, I want to thank our security officer, Rich Corey, who has stayed well beyond what court hours normally are. With that, is there anything else that we need to discuss before we adjourn for the day?
Not for the plaintiffs, we're happy to get everybody home.
Okay. Okay, then we stand adjourned and I will see everybody here tomorrow at 9:00 a.m.
All rise.
Yeah.